Good morning, everyone. I'd like to welcome you to the March 7th, 2019 meeting of the Yamhill County Board of Commissioners. Before we get started, just a couple of things. If you have a cell phone, we ask that you please silence it. And if you have to make or receive a text or make a call, that you go out into the lobby to do that, please. And second, I'd like to thank the City of McMinnville for letting us use the Civic Center today for this critical hearing. So with that being said, I'll ask Commissioner Kula to lead us in the flag of.
Everybody ready? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you.
Thank you, Commissioner. This is a time that we accept public comments, and this public comment is period reserved for public comment on any topic other than those agenda items, a quasi-judicial land use matter, or a topic scheduled for a public hearing. What I do ask is I wouldn't limit anybody to 3 minutes, but if you do want to make a public comment that you, because of the public hearing we have today, that you try to keep your comments brief. So I don't have any cards here for anybody that wants to say anything in regular public comment period. So is there anybody that did not fill out a card that would like to speak about any other comment item? Okay, hearing none, we'll move on to our consent agenda. Commissioners, are on our consent agenda today. We have the minutes of the January 24th, January 31st, and February 7th meeting of the formal sessions. And plans, we have approval of a revised 2018-19 capital improvement list. Then we have several contracts and grants, including approval of accept a quote for Architecture for the restoration of the public health building, approval to accept proposal from Farnham Electric for installation of a backup generator, approval of an agreement between Yamhill County and Human Services and Wayne Scott for training on trauma-informed practices, approval amendment number 8 to agreement number 153142, which was board order 17-027 between Yamhill County and the Oregon Health Authority for funding of community mental health, substance use disorder, and problem gaming services. And then we have approval of an intergovernmental agreement between Yamhill County Health and Human Services and the State of Oregon Department of Human Services for behavioral support services. And then our last thing on our consent agenda is approval of a memorandum of understanding between the Housing Authority of Yamhill County and Yamhill County Health and Human Services for shared supportive housing case management projects retroactive to March 1st, 2019. So that being said, Commissioners, does anybody have anything they want to pull off of the consent agenda?
I would move approval of the consent agenda.
Okay, we approve. Okay. We have a motion to approve the consent agenda as presented. All those in favor signify by saying aye.
Aye.
Let it show that the Board of Commissioners, Commissioner Sterrett, Commissioner Kula, and Commissioner Olson all voted in the affirmative to approve the consent agenda. Thank you, Commissioners. That'll take us into old business. We do not have any old business scheduled. We'll move on to other business, and we don't have any other business scheduled. So that will take us right into our public hearing, and this is a public hearing for docket number G0118, consideration on remand of ordinance 904 related to the Yamhill Westsider Trail. Let me get my paperwork out here. Okay, so what I'll do is I'll open the public hearing and I'll call for abstentions by any of the commissioners. Does anybody need to abstain?
No.
We have no abstentions, and we'll ask if there are any of the audience, is there any parties that have objections to the jurisdiction of the board to hear the matter before it? Okay, hearing none. Does any board member need to announce and state on the record the substance of any ex parte contact or any site visits?
I have an ex parte contact that I'd like to disclose, which is that I communicated via email with Brian Schmidt of Stop the Trail and Wayne Webke of Friends of the Yamhill Westsider Trail, with whom I'd hope to meet to talk about trail issues and to promote some collaborative problem solving, as B.J. Matthews notes in her testimony. We did not get past seeking a time to meet, But in one of the emails, which is in your record, Brian Schmidt says that he understands me to continue to be impartial. And thanks, Brian, for that. And to that end, I hereby confirm that I am impartial, I'm unbiased and fair, and I am not set on a predetermined outcome in this proceeding. So thank you for that.
Mary?
None, Mr. Chair.
I'd just like to declare that over the long process of the trail, I have had several contacts with both the proponents and the opponents, but as far as the remand goes that we're here to address today, I have not had any ex parte contact, for the record. Okay, thank you, counselors. So what I'll ask, Ken, yes?
So, Wendy Killington, I believe I'm entitled to ask a little bit about those ex parte communications.
Sir,
Yeah, Wendy, you're free to address those in your rebuttal.
in your rebuttal.
Well, that doesn't give me a chance to ask about them.
You're not entitled to ask about them. You're entitled to address the substance of the ex parte communication that's been put on the record as part of your rebuttal.
Okay, Wendy Killington, for the record, state law is clear. The Oregon Court of Appeals has made it crystal clear that when there are ex parte communications, that they have the potential to so undermine the quasi-judicial land use process that it's important for all parties to the proceeding to fully explore and have an opportunity to understand exactly what those contacts were, when they happened, documents that were exchanged, and impressions that were left as a consequence of them. The Court of Appeals in Horizon Construction, as I think everybody in this room is well aware, said that the broadest opportunity for exploring and rebuttal is important. And here we're talking about the livelihoods and continuing viability of about $50 to $60 million a year in commercial farming. So I think it's worth doing this right and figuring it out and avoiding multiple trips up and down to the Land Use Board of Appeals. I'd like to have an
And
opportunity
you will be able to address that in your rebuttal.
Okay, I'm going to ask some questions then as well.
Yeah, you're not entitled to cross-examination in a quasi-judicial
Disagree,
hearing.
for the record. I think you're wrong.
Okay, thank you.
Thank you for
Wendy.
raising your concerns.
Then, moving forward, I'll ask our planning director, Ken Friday, to reading the statements required by state law to be read at the opening of a quasi-judicial land use matter.
Yes, sir. Oregon law requires that persons who attend a land use hearing be advised of certain rights and duties before the hearing begins. First, with regard to the standards for approval, state law, ORS 197.763 sub 5, requires that we list the applicable substantive criteria that must be met in order for the county to approve an application. The standards will be listed by the county planner, Stephanie, here in a few moments as part of her staff report. Testimony, arguments, and evidence must be directed towards the standards for approval. Second, the raise it or waive it rule. Under Oregon law, any issue that might be raised in an appeal of the county's decision in this matter must be raised before the record of this hearing is closed. Failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and the parties an opportunity to respond to the issue precludes appeal to the board based on that issue. Third, and this is directed to the applicant, under ORS 197.796, failure of the applicant to raise constitutional or other issues related to proposed conditions of approval, again with sufficient specificity to allow the court to respond to the issue, precludes an action for damages in circuit court. Finally, under Oregon law, and because this is the initial evidentiary hearing on this matter in a quasi-judicial matter, any participant, that is anyone who submits oral or written testimony during this hearing, may, before the record is closed, request an opportunity to present additional evidence, arguments, or testimony regarding the application. The request must be made prior to the time the chair announces the hearing is closed. And we have already received one request for that.
Okay, thank you, Ken. Moving on then, we will ask for staff report.
The original application was for an amendment to the county transportation system plan to authorize development of a 2.82-mile trail between the cities of Carlson
Stephanie, can you move maybe the microphone a little bit closer to you, please?
and as close as possible. LUBA remanded the county's adopted ordinance.
Can you hear?
I'll try and speak louder. So LUBA remanded the county's adopted ordinance. LUBA's remand requires that the county conduct a quasi-judicial hearing pursuant to Yamhill County zoning ordinance sections 402.04N, 402.07A, 1202, and 1301. The county has previously adopted findings to address 402.07A of the Yamhill County zoning ordinance, which is the farm impact standard of ORS 215.296. This includes potential impacts to the costs of farming or to farm practices, as the majority of the property surrounding this corridor is in farm use and zoned for exclusive farm use. Additional testimony and evidence regarding any specific farm impacts and practices is encouraged. Mr. Chair?
Okay, thank you. Thank you very much, Stephanie. So this is where we'll move to the applicants. Okay, so if we could have the applicant come forward, please.
Thank you. Todd Sadlow, Senior Assistant County Counsel for Yamhill County, 535 Northeast 5th Street, McMinnville, Oregon. Thank you for this opportunity to present planning, and I'm sorry, I got to get comfortable in this seat, planning docket G0118 to you on remand. Please feel free to interrupt me at any time if you have a question about what I am saying. As you know, I am the county attorney who presented the original docket to you. The original proceedings resulted in the adoption of Ordinance 904 on May 31st, 2018. That ordinance was appealed to the Land Use Board of Appeals and remanded to the county with instructions to hold a new quasi-judicial hearing and to adopt findings to address the conditional use standards in the county's zoning ordinance. First, I want to explain what a remand is. The land use appeal process is like a funnel. At the top of that funnel is the original proceedings, which is, in this case, include an original record of 613 pages, including our original application, which is at the back of those 613 pages, and a supplemental record that was a few extra pages. The original decision was appealed, and the opponents made a number of claims of error and prevailed on some of those claims. LUBA remanded to the county for further proceedings. If the county had made a fatal mistake, it would have been reversed. The decision would have been reversed. Instead, LUBA sent it back to you, the governing body of Yamhill County, to fix it or do whatever you thought was right. This is a continuation of the original proceedings initiated by the county to adopt Ordinance 904. This is the bottom of the funnel, hopefully. The issues that LUBA decided in favor of the county are no longer before the board. LUBA provided a final order which outlines specifically what the county must do to correct the decision originally made. In this case, LUBA stated that the county must hold a quasi-judicial hearing to reconsider Ordinance 904, not a legislative hearing as originally held, and also directed the county to address the conditional use standards of the county zoning ordinance. Those standards are addressed by draft findings contained in the staff report, but I'm going to state them now as well. A through F. A, the use is listed as a conditional use in the underlying zoning district. The use is consistent with those goals and policies of the comprehensive plan which apply to the proposed use. The parcel is suitable for the proposed use considering its size, shape, location, topography, existence of improvements and natural features. The proposed use will not alter the character of the surrounding area in a manner which substantially limits, impairs, or prevents the use of surrounding properties for permitted uses listed in the underlying zoning district. The proposed use is appropriate considering the adequacy of public facilities and services existing or planned for the area affected by the use, and the use can be made compatible. The use is or can be made compatible with existing uses and other allowable uses in the area. We're here today to talk about potential farm impacts because the farm impact standards are also part of the conditional use review standards and those standards that I just read. I think the draft findings in the staff report make abundantly clear that the proposed use is consistent with the comprehensive plan, very, very suitable for the proposed use, will be a continuing positive part of the character of the surrounding area and enhance that character, is appropriate considering existing facilities and the lack of need for most services, and can be made compatible with surrounding uses. The last standard is intertwined with the farm impact standard, and likely findings that address one are going to satisfy the other. Comprehensive land use planning is also kind of a funnel. The top of the funnel is the comprehensive plan. In this case, the comprehensive plan includes an ordinance adopted December 6, 2012, Ordinance 880, which was signed by a unanimous Board of Commissioners, Chair Leslie Lewis, and Commissioners Mary Stern and Kathy George. That ordinance added a significant policy to the county's comprehensive plan, a policy establishing support for the Hag Lake, and its title, Hag Lake to McMinnville Rail with Trail Project, and in quotes, in parentheses, Yamhill West Sider Trail Project, and establishing its importance to quote, both the county's rail and trail bikeway systems. The trail proposal was placed on a priority list in 2012 to be developed as a multi-use path along the existing railroad right-of-way. And that's in quotes too, a multi-use path along the existing railroad right-of-way, and this was 2012, sorry. Acquisition was estimated, and that estimate was put in the comprehensive plan at a cost of $2.4 million. We ended up purchasing the right-of-way in 2017 for $1.4 million with a partial donation by Union Pacific, which we're grateful for because it put the purchase within the budget of our ODOT grant. This whole project, with the support of a unanimous board, was set in motion decades ago, decades before that decision, and officially made county policy and a priority 6 years ago. This is part of the reason that we're here. In the best of worlds, a local government conforms its zoning ordinance to correspond to its comprehensive plan, but that did not occur in this case. No state law requires that use of an existing transportation corridor for a walking, biking, and equestrian trail is subject to conditional use standards in any zone or prohibits such facilities in any zone. Even so, the county did not in 2012 or since then follow up and amend its code to specifically allow outright the trail where the comprehensive plan says the county wants the trail to be. That is why we are here on remand. The county's zoning ordinance, through, I believe, inadvertence, requires that the county now establish compliance with the county's conditional use standards in order to approve the proposed trail, and does not list such a use as an allowed use at all in the AF10 zone, which half of the trail is in at one point along the corridor between Yamhill and Carlton segment. That needs to be fixed. The zoning ordinance needs to be amended to conform to state law and to the county's comprehensive plan. And until then, I am proposing an additional condition that prohibits development of the trail in any zone that does not currently allow development of the trail. And hopefully that problem with the zoning ordinance not being consistent with the county's comprehensive plan will be fixed in the future, and that problem will go away. What I've just stated is for clarification only. The county already addressed the farm impact standards in the previous proceedings and will continue to address them in this remand by accepting additional testimony and evidence, and it looks like you got a lot of great evidence and testimony. You're going to get some great testimony regarding potential farm impacts. The new staff report issued by planning contains additional proposed findings based on the existing record or the record as it existed before today, and that will be supplemented following the receipt of all additional testimony and evidence on remand. Hopefully, I believe it can, to show compliance with the conditional use standards of the county's zoning ordinance and the farm impact standards. Which brings me to the recent Supreme Court decision discussing the farm impact standards. The Riverbend landfill Supreme Court decision is relevant to this case in that in both cases, the county must adopt findings to address ORS 215-296, the farm impact standard. The court also clarified some things most of us already knew and have always done as planners and land use lawyers. We are directed by the court to look at individual farms and not attempt to make a case that in the global scheme of things, considering the overall agricultural economy, the impacts that might occur to farm practices or costs are insignificant. That was closer to what the Court of Appeals said. In that wide-angle view, the impacts from the landfill are insignificant if you consider that the county's agricultural economy is thriving even near the landfill, which has been there for decades. That's not the rule. We're supposed to look at individual farms. In every farm impact analysis I've ever done in my professional career, I've looked at individual farms. I've not attempted to make some global statement about agriculture not being harmed overall. For purposes of your review, the central holding of the Riverbend case is that the farm impact standards require looking at individual farms and that the term significant has its ordinary meaning. The Supreme Court overruled an approach by the Court of Appeals that took a more global view and sided more with Luba on that. That is, the Supreme Court settled a disagreement between the parties regarding the approach taken by the Court of Appeals and the approach taken by Luba. As with the trail case, the adoption of Ordinance 904, Riverbend, in fact, analyzed impacts to individual farms, almost exactly as specified by the Supreme Court, in my opinion. Mr. McPhillips's fields that had litter in them, and Mrs. Freese's cherry trees as good examples. And in this trail case, the county listed all 40 tax lots adjacent to the corridor and the farm uses that the county believes are taking place on each one of them. The county also submitted into the record literature from OSU and the OSU Extension Center outlining accepted agricultural practices common to the farm uses that we identified. Sorry. And yes, the county listened to what farm operators are saying, has sought to address their concerns, and will continue to do everything it can to make this trail work for them and to be acceptable to them. Like I said, the county issued draft findings addressing farm impacts. We did that on April 3rd, 2018. Everyone has known for a long time the county's position as the applicant in this case. Interested parties were provided an opportunity to provide their own information regarding farm practices and costs, and many did. And we received a large packet of information yesterday that contains a lot of additional information about the farm practices that are taking place on those farms. Ordinance 904 contains specific, clear, and objective conditions that required fencing along the entire corridor, signage notifying trail users of prohibited activities, and warnings regarding agricultural activities they may encounter. The conditions also require adoption by the county of a master plan for trail development and use before trail construction, other than the construction of the 3 bridges for which the county has already obtained grant funding. That's the way 904 was written. Going forward, if you vote on a new ordinance to correct and replace Ordinance 904, I will submit draft findings that address all of the issues raised on remand. The new ordinance will allow the county to continue to develop, and this would be an ordinance that would replace Ordinance 904, which would be repealed, will allow the county to continue to develop a trail in the former Union Pacific Rail corridor that is now owned by the county. And I just want to make one more process remark, and then I think I should rebut some of the comments that have already been submitted prior to this hearing today. A great deal of hay, I'm sorry for the pun, was made by the organized opposition before the board and on appeal about the fact that I work for you, I work for the county, and you are the governing body of the same county. Although it does not happen every day, local governments sometimes need to obtain land use authority to move forward with public projects. It is legally appropriate and fairly common for a local government, as in this case, to assign a staff member to present the proposal for land use authority. That's the procedure we followed in this case, and there's nothing in the remand decision that takes issue with that. There are several things that I may rebut, but I really wanted to start by just dealing with spray and overspray. And I may have additional rebuttal comments related to this afterwards, and that's because so much of the testimony appears to be focused on that. The opponents have repeatedly stated that their farm practices and costs will be significantly impacted if the existing rail corridor is allowed, because pedestrians and bikes that were not previously within 150 feet of their operation may then be within 150 feet. This is because, according to the opponents, a rule adopted by Oregon OSHA prohibits them from spraying within 150 feet of a trail or highway. In the original proceedings, the county debunked the claim regarding the then pending OSHA rule, which is in the original record. We submitted it as part of our application, with testimony from an OSHA contractor and administrator who were working on the rule. They both stated that the proposed rule does not apply to neighboring properties, period. They stated, as the rule states, and this is in the introductory paragraph of the rule, this rule applies in Oregon where workers or other people are adjacent to pesticides being applied in outdoor production areas that are within the boundaries of the establishment. That's OAR 437-004-6405. In the original proceedings, this was record page 344, a contractor for OSHA basically said what the opponents were saying was false. The rule does not apply to neighboring properties or people. The commentary to the rule, and I provided this yesterday, it's a 97-page commentary that talks mostly about what the rule actually does and not what it does not do. Bottom of page 26 states, quote, "The record includes recurring comments about the impracticability of closing trails, roads, and highways that might fall within the AEZ, which is the application exclusion zone. For Oregon OSHA purposes, such activities simply fall outside the scope of the rulemaking." The argument being made repeatedly by opponents that the presence of people on the trail affect their farm practices or costs can only be correct if farm operators currently have the right to spray property that does not belong to them as long as there are no people there. The county is only required to analyze potential impacts to accepted farm practices taking place on neighboring farms. Is it an accepted farm practice for a farm operator to spray or overspray the private property of others or government-owned property or rights-of-way? It's not. Overspray, especially overspray on neighboring property, people, or animals, is illegal. And in the packet that you received yesterday, one of the first letters from the Oregon Department of Agriculture states that very clearly. A farm operator is currently not allowed without permission to spray the land of his or her neighbor whether or not there are people there. Farm operators have, since the beginning of pesticide availability, been required to control where the spray ends up and are not, under any circumstances, allowed to spray the property of others without their permission, whether there are people or animals there or not. And this was the gist of the testimony received from Oregon OSHA, which said this is not our deal. They did say maybe the Department of Agriculture has something to do, or that it's still a concern to them. Those property owners, people and animals on neighboring properties, are already protected by existing law. And OSHA has jurisdiction to protect workers, not to make rules for otherwise illegal overspray onto neighboring properties. The OSHA rule seeks to protect farm workers and others within 150 feet of a spray operation who are working or are otherwise present on the land of the farm operator, where the farm operator otherwise has a legal right to spray if he follows the rules and the applicator follows the rules. Again, this matter was fully addressed in the original proceedings to consider Ordinance 904. A copy of the proposed rule was included in the original application. I've given you all the information we have on it, a clean copy of the rule, a copy of the rule is amended, 97 pages of commentary. To the extent the existing findings do not explain this clearly enough, Additional findings will be proposed for adoption on remand if you approve this. To make more clear that spraying pesticides on neighboring property, whether or not people or animals are present, is not an accepted farming practice, and the county is under no obligation to try to minimize or prevent such overspray, as the opponents would have it, by not using or allowing the public to use the county's own property. Like any other property owner, the county wants and needs to control what takes place on its property, even when the property is a public right-of-way. We will also need to perform maintenance, and we have the right to allow persons to be within the corridor, even if it is not formally open as a public trail. Like all property owners, we have a right to expect that we will not be sprayed by our neighbor. In conclusion, neighboring property owners have no current right to spray the corridor, and it is not an accepted farm practice for farm operators to spray neighboring properties, whether or not that property is a public trail, whether or not persons or animals are present, and whether or not OSHA has adopted a rule stating that they must remove all persons and animals within up to 150 feet on property that they own or that is part of their farm operation. I should also note with regard to that conclusion that even though the county is not required by the farm impact standards to address practices that are not accepted farm practices, it adopted conditions as part of Ordinance 904 to minimize perceptions that trail users might have when they smell pesticides, but may not be receiving a dangerous dose of it. Signage. For the first segment of trail, many trail users who may live on neighboring properties or in Yamhill or Carlton are already going to know the difference between a pesticide smell and being doused with it. It will be obvious to most users that as they pass through, that they are passing through farmland, and therefore they may encounter pesticide smells, dust, and odors normally associated with farm operations. I definitely want to address things like fire, which we already addressed. The Yamhill Fire Chief states that he needs at least 12 feet of width of the trail to get his equipment in there. That is the proposed width of our trail, and it has to be capable of supporting heavy equipment. And I would say try mostly compressed ballast that has had trains running over it for 100+ years. Again, the master plan will assess access as to each trail section. So I would just note that this section has access at Highway 240, Friar Road, and in Carlton at the very least. And although the bridges have not been designed, definitely there will be a discussion as to whether or not it needs to be designed for to support the weight of fire vehicles, or whether those vehicles can get to that location some other way. I do have other things that I could rebut, but I know you're anxious to hear from everybody else. I know you will listen carefully to and review all of the testimony received, and I thank you for listening to mine. Are there any questions at this point?
Casey, Commissioner Cooley, you have any questions?
Yes, Mr. Sadlow, you raised the question of OSHA, and I feel like you addressed it in the way that I understand the rules to be. Do you have information on the ODA's stance with regards to the same issue of the AZ?
That, I believe, is in the front of the submittal that you got yesterday, and I can get that for you.
Okay. Is that the one that, the big, yeah. I mean, I encountered it on my own, but I wanted to.
I think it's important.
It seems like they have a different interpretation because they have different goals, the ODA versus OSHA.
Yes, they say that application of pesticide products in a manner that allows drift onto another site, such as a right-of-way, would be considered use of a pesticide product inconsistent with product labeling, ORS 6343722, or application of a pesticide product in a faulty, careless, or negligent manner. I would also note that under the common law, it's trespass for you to allow substances that you generate or are generating to end up on somebody else's property. And it's a nuisance if it's to their detriment.
Mr. Sadler, I was also recalling,
Simply, a violation of the label is a violation of the law. There you go.
I recall that there was something about when there's a frequently asked questions out there, and it asks about the scenario of a trail, and it says something along the lines of an applicator should stop spraying when a person is present.
Absolutely.
Okay.
I think that's correct.
And I mean, that seems to be obviously best practice.
Yes.
But in the context of our proposed trail, do you have more thoughts on that? Do you think it would significantly impact farmers?
Well, obviously, there will be more people there, but I think that the county has an interest in making sure that farmers, farm operators follow the rules, whether or not the county owns the property or does not own the property. I just think that if, from the circumstance of now that we do own it, it's the responsibility of the county to maintain it in a safe condition for the uses that we're proposing for it now and the future uses. The comprehensive plan amendment doesn't just say that this should be a trail right now. It says that it should be preserved for future rail or other transportation use. And I think that makes sense given the trouble that they went to back in 1872 to put this corridor together. And the value of it, especially concerning the alternative to cars that it presents, specifically between Yamhill and Carlton, where we have a unified school district and we have a swimming pool in one town that's not in the other town. And we have reasons why those two communities could benefit economically if they were joined by a foot trail, a bicycle trail, a horse trail, a highway for these things that is not on the main highway where a lot of big trucks are roaring by.
And I apologize. I really appreciate everybody in the audience being here. But since I was asked if I had any questions, I'm going to pursue them. So please be patient with me. And then, Mr. Sadler, I also wanted to know what if we denied this remand after hearing all testimony. What are some of the current allowed uses? Is that the right language? Allowed uses on EFU land? For example, for other transportation means. Do you have off the top of your head? I mean, we could direct it to staff, but.
Well, most of the allowed outright uses on EFU land are farming related. The conditional use, what's allowed as a conditional use, it's a long, long list, but a lot of those things, a 60-foot and plus corridor extending over 12 miles is not going to be suitable for that. You can get certain housing as conditional uses. You can get certain productive, commercial uses in conjunction with farm use, that sort of thing. If in the end you really don't want to put the trail here, you would probably figure out how to sell it or deed it back to the people who deeded it away in 1872 and in subsequent years. We paid $1.4 million for it. Part of that was a donation. We had it all appraised when we did it. We just have always believed that it is worth far, far more as a unified corridor, which it is right now, than it would ever be being parceled off to the neighboring farm owners.
Thank you. Would, Mr. Sadler, again, what would it require of us if we wanted to put a road in there?
You could put a road in there, taking the same steps that you're taking now to put the trail in there.
As a conditional use permit?
Yes, I think, and this is one thing that Ms. Kellington raised about, or in her written submittal about the transportation system plan. She says we need to make findings related to that. Findings are routinely made to address that when a comprehensive plan amendment is done, and so I would be proposing findings to you if you approve this to address the transportation system plan. The findings as they are now basically just say it's listed, and that's what we argued at LUBA too, that it's listed in the transportation planning rule as something that is in compliance with several goals, including goals 3, 4, and 11, and I don't know what else, but I remember 3, 4, and 11, but and that was the approach that we took. But now that she has raised this issue, we will do that. And if you were putting a road in, I would think there would be more transportation system impacts than just where is the trailhead going to be, and will it impact that road. It would be more like intersections and sight distances and those sorts of things that we would need to be discussing. And, you know, the transportation planning rule requires that you have a 20-year horizon for planning, and I think in that case, we're looking at the 20-year horizon for how many people might want to recreate on that trail or get to school on that trail or ride their horse there or ride a train through there to Portland in 50 years. So I think that we will be able to come up with findings to meet the transportation system, the TSP rule.
Okay. And then do you have any more conditions of approval that you want to place or propose?
No, but if I could, just to keep people focused anyway,
Yeah.
just state what we already offered, and the other one would be that we not build any trail in a zone that doesn't currently allow it.
I wrote that down.
But that means that hopefully that will be changed so that it will be allowed in that zone. And what we said in the conditions was prior to formally opening a multimodal trail in the segment of corridor between State Highway 240 and the city of Carlton, fencing capable of preventing dogs and people from entering adjacent farm fields shall be installed by the county, and that means the county or the contractor, along the entire trail segment, unless an owner of adjacent land indicates that such fencing is not necessary to separate the owner's land from the trail corridor. And B, signage shall be installed at each point of trail entry from a public right-of-way or trailhead, directing and warning trail users not to trespass on adjacent lands, not to touch, pet, or otherwise harass livestock, indicating that agricultural uses are taking place in the area, and to expect potential dust, noise, agricultural and pesticide smells, and indicating that at designated agricultural trail crossings, and we've talked about this a lot, and I don't think I'm going to address it until rebuttal. Delays may occur, and that farm operators and machinery have the right-of-way over pedestrians and other trail users. Section 4, prior to trail construction, other than initial bridge construction in parentheses, a final plan or master plan, which shall be collaborative and coordinated effort, will be approved by the board, outlining additional trail design, management, and mitigation measures that are not necessary to meet state farm impact standards, but will help to ensure long-term minimization of conflicts between trail users and neighboring landowners.
Thank you. Have you, there at least one person in the record submitted something about an indemnification resolution from, I believe, California. Can I have your thoughts on that before we go into?
I have not had an opportunity to see that.
Okay.
So I would need to look at that more closely.
Okay, you haven't memorized?
The
I mean,
lawyers like to see the paperwork, and I have not seen that.
Okay.
To comment on it,
Okay.
so I probably
Thank you
should
for your
not.
questions. I don't want to take up too much more time.
Okay, Commissioner Sterrett.
I do have a question, Mr. Chair. Mr. Sadler, you said that the county, the applicant, had actually debunked the concerns about the application exclusion zone, and that we were able to basically, the argument being that this is land that is adjacent to a working farm, is not, it would be spraying, but the overspray would be on land that is not theirs, i.e. it's the trail, the proposed trail. And that we would make every effort to mitigate for any of those concerns. But I'm wondering if you ask any of the farmers here, one of their major pests, and I'm looking at an Oregon State University field crop professor's notations, that one of the major pests is slugs, and one of the slugs, slug baits that is commonly used in our area and in the adjoining farms is the metaldehyde, which is a system toxin, which can stay on the fields and visible for a day to 7 days. It is toxic to animals, it's toxic to humans. You could put signs up all day long, but a dog that is going underneath a fence ingesting a system toxin is not necessarily going to say, well, the county's mitigated and debunked that. So I just want to say that while we can say that the application exclusion zone isn't really going to affect anyone because legally they don't have the right to spray outside of their land, the fact remains that when you're farming, there is not a magical barrier that magically appears that makes it so that any of the toxins typically used in accepted farming today would not impact people when you're drawing people to working farms. And so I'm wondering how you mitigate for a pesticide that remains viable for 7 days.
Mr. Chair, Commissioner, what we tried to do was we tried to say that we will fence this area off so that people and animals cannot get onto these neighboring farms. That is what farmers usually do. That's the same thing we're proposing to do. We're proposing a fence that is capable of keeping dogs and people off of the neighboring property. If some odd thing happens, if somebody deliberately tears a hole in the fence and shoves their dog through it, I can see that there could be some problems. But I think what we're expecting here is that we're going to have a lot of people on this trail who are legitimate people who are just out there to jog or to ride their bike or ride their horse, and they're going to be looking for stuff like that. They're not going to be just, letting people vandalize the fences along the trail with some intent on allowing trespass that we don't want to occur. But the main issue, though, is that in the original proceeding, what they said was that it was this OSHA rule that prevented them that caused an increase in farming costs and limited their ability to farm within 150 feet of that trail. That's the part that was debunked, and we debunked it by talking to the administrator of OSHA. We had evidence in the record that they both said, no, this rule does not do this. So if they want to make this claim that they're impacted, that their farm practices are significantly impacted, or that their farm costs are significantly increased, they can't, I don't think they can legitimately do it on the basis of the OSHA rule when they specifically say in their news release, 2018, pesticide drift outside a treated area is already illegal. It can't be an accepted farm practice, and that's the point we're trying to make.
Thank you, Mr. Sadlow.
Mr. Sadlow, I think what I'd like to do is just take a minute and tell you I appreciate you putting together this information on the spraying, and after I read everything, because I think spraying is an issue, but I think I have much more clarification now on what OSHA has said and what the law says. So I think that was very helpful. So thank you, Mr. Sadlow.
Thank you. I'm sure you'll hear a difference.
Thank you.
Okay, we'll move in. I'm going to get my cards out here. We'll move in on testimony in support of the application, and I'll get my cards out here. And the first one I will call is Steve Harloft, it looks like. Steve, come on up. And if you can For the digital record, if you can state your name and your address.
Good morning. My name is Steve Harloff. I live at 16175 Putty Gulch Road, and that is in Yamhill, Oregon. With the Yamhalis West Sider Trail, residents of Yamhill County have a wonderful opportunity through involved community planning to create a functional, clean recreation corridor that will connect two towns better than ever before. There are three aspects of the Remand I wish to address. First, as online research shows, the concerns from agricultural communities in the creation of recreational trails have been well stated, and those concerns have been alleviated through techniques that include use of fencing, landscaping, and design to reduce privacy issues, policies that allow closure of trails when agricultural needs demand it, signage that informs trail users of ongoing agricultural operations, and maintaining and observing the trail to limit vandalism. Last year, I had an opportunity to walk on the Wabash Cannon Trail in northern Ohio, a 63-mile bike pedestrian trail that takes users to the Indiana border. The trail passes through suburban areas, but also has many rural sections. I walked with one rural dweller in a section next to fields of grain and soybeans, adjacent to sandy soils and tall hardwood forests. He told me local residents along the Wabash Cannonball love this chance to discover their part of Ohio on foot or on bike. Research again suggests there does not have to be a conflict between trail proponents and agricultural interests. All stakeholders should be satisfied with mitigation outcomes, including issues of spraying and privacy. There is no reason for the trail to impair or change local farming procedures and habits. Secondly, the land itself is perfect for this recreational opportunity. Stable valley soils and established lines of level passage for trail development. This is probably why it was originally chosen as a railway line. Throughout the country, recreational trails help to highlight the local values of agriculture, to accentuate why the land surrounding these trails is important to protect and preserve. The gentle contour of the land along the trail is ideal for family use on foot or on bikes. Finally, both of my kids attended Yamhill Carlton schools, and we would have loved having this trail for walking, riding, and exercise, and it would have served as a conduit between one town to the next. Walking or riding on Highway 47 or West Side Road is treacherous at best. The need for a functional pathway is obvious. My hope is that Yamhill County would involve farmers, students, artists and craftspeople, historians and interested citizens to celebrate local personalities and the pioneer history of Yamhill and Carlton, with much of that history driven by local heritage specialists. Thank you for allowing me to state my ideas.
Thank you very much. Looking at my check sheet here, I did forget to bring up that it is not my intent to limit anybody's testimony, but based on the number of people that want to testify, if you have any comments that are basically just repeating somebody else's comments, go ahead and you can state that, because they will be on both the digital and the written record. But again, I just want to make sure it's not my intent to limit anybody's comments. So that, moving forward, the next one I have is Wayne Webke. So Wayne, come on forward.
My name is Wayne Webke. I live at 13775 Meadow Lake Road, Carlton. And I'm here to support the adoption of Ordinance 904. I also want to say that I view this hearing as another opportunity for additional public input and to provide even more transparency to the entire project. In addition, this quasi-judicial hearing not only addresses one of LUBA's concerns, but can also move the trail forward by taking a previously established policy to the application or development phase. I think that's a good thing, and I thank you for having this meeting to do that. There are several assignment errors given in the LUBA remand, but the one that stands out is how the trail affects adjacent farmers' ability to farm. This is not anything new. We're not plowing new ground here. There are miles and miles of trails across the country that coexist with farming, just as extensive as borders this trail. This is a topic that has been discussed at every public meeting over the last 7 years. It has been discussed at length during the last couple of years at hearings that the county has provided, giving anyone who chooses ample time to present their testimony. The county has addressed the concerns voiced in these hearings and made them public record as part of the amendment to the Transportation System Plan. There is also a county commitment that goes along with this, which commits the county to working with each adjacent landowner to make things fair and equitable. The master plan will be one of the next things to happen with the trail. This process will give all of those landowners the opportunity to participate and present what will satisfy them as being a neighbor to the trail. The master plan will become the blueprint for the trail, which will include those individual concepts. My hope is that when the opportunity is there, reasonable people will come together and find reasonable outcomes. Thank you.
Okay, thank you, Mr. Webke. Veronica Hinks. Veronica, you here? There she is. Come on forward, Veronica.
Good morning. For the record, I'm Veronica Hinkes. I live at 16375 Northwest Meadow Lake Road. I submitted written testimony last week, so I was going to just briefly summarize, and since some of what I was going to say agreed with what Wayne just stated, I'll try to summarize even further. To go further on what he was saying about the thousands of miles of trails through agricultural land around the country, there have been studies done that look at these trails years and years after they've been built and talk to adjacent landowners about their experiences. And what they find is that while in the planning stages, the trails in agricultural areas often draw the same concerns as have been raised about the Yamhill Trail, once they're built, the trails in the agricultural areas can and do exist in harmony, and the adjacent property owners do not end up experiencing the things that they had feared. One such study, the Santa Paula Branch Line Recreational Trail Compatibility Study, listed many things that can be done to make sure that everybody coexists successfully. And in fact, those turn out to be the same issues raised in the LUBA Remand and the same things that have already been talked about with our trail. So this can be done so that it works for everybody. It's been done all around the country, and I urge you to continue to move forward with this project. Thank you.
Okay, thank you. Linda Klein. So Linda, come on forward.
Good morning. My name is Linda Klein. I live at 432 North Ace Place in Carlton. A lot of the things I would talk about have already been addressed, but one I wanted to expand on a little bit was about the kids in the school district. When I got involved with the Friends of the Trail about 5 years ago, I had 3 children in the school district. And that's why I got involved, is because I realized I have kids living in Carlton that without me providing them a vehicle have no means to get back and forth on their own from school. The other thing I've experienced with my own kids is, and I think this goes to point E about is it appropriate considering adequate public facilities. I would argue that we do not have adequate public facilities for getting kids back and forth because of the lack of shoulders on the roads, the lack of safety. In the last several summers, I've had my own kids working at Fruit Hill, which is at the other end of the trail in Yamhill. It has been a real hassle to get them there and back without us taking time off from work to drive them or provide them cars and I know for a fact that my kids have friends that live in Carlton that would choose to work in the summer if they had a way to get to the jobs in Yamhill. So, because Fruit Hill is one of the bigger employers of youth in our area, but it does require transportation. So I just want to say that I feel like this trail would enhance that as well for our youth, along with safety. Thank you.
Thank you very much. Ken Wright, Ken, come on forward.
Ken Wright, 236 North Cooch Street, Carlton, Oregon. Spraying is the big issue for, I think, most people in this case, both for and against this trail. I farm 220 acres, so it's an issue for me too. If we look to our closest example of a trail, that would be the Banks of Vernonia. In talking with the county attorney for Columbia County about whether there have been issues over these last 20 years, they said no. I talked with the sheriff, Columbia County. I asked, have you had complaints or issues? And he said no, over 20 years. Larry Heesacker, who has A1 Logging, he's in Yamhill, his offices are now. He has property on the Banks of Vernonia Trail, and he was initially against it. But once it became a reality, he, in fact, now enjoys it. He walks the trail quite often, in fact, and he thinks it's a tremendous asset for that region. So I think that having that reality of a trail so close to us and having that experience tells all. Thank you.
Thank you, Ken.
Mr. Wright.
Stan Permasic, Commissioner, come on forward.
Yes, my name is Stan Permasic. I live at 493 Southwest Pemberley Loop in McMinnville, Oregon. I was the one who had the honor of signing the paperwork that made the Yamhill Trail a county property. So I've been a big supporter of this project for many, many years. I think that most of the positives or the pro arguments for this trail have been well established by the people who preceded me in sharing. I just want to reiterate, if I could, the benefits of having this, and it will bring about some real compatibility between both our farm community and our urban community. I think it's really important that our young people living in the cities have a better understanding of just what takes place in our farmlands. And this trail will provide an opportunity. I can't say parents and children are going to take advantage of it, but we're going to provide the opportunity for that. The health benefits to people getting out and walking, riding, can't be stressed enough. We have a society whose health is far lower than it should be, and I think that providing this opportunity will be very, very good for the citizens of Yamhill County. I would love to see us move forward with this trail. The concerns of the opponents are being addressed, will be addressed. We are not going to satisfy everybody's desire, proponents or opponents, but we are able and capable of providing benefits for all of our citizens, and I think this trail goes a long way. the safety of our young people getting to and from school is vitally important. A 10-minute bike ride on a trail not only provides a healthy outlet for them, but it does then keep them off of our highways and roadways that are certainly not safe for pedestrians and bicycle riders. So I'm very supportive of the trail. I think all of the statements made by the proponents so far certainly support what I've just said, and I would ask you to look favorably upon this and send this back to LUBA with a strong, yes, we are going to do this. Thank you.
Thank you, Stan.
Thank you, Sam.
Stan?
Okay, Steve Wick.
For the record, let it show that my name is Steve Wick. I live at 29250 Northwest Olson Road in Gaston, Oregon, the northern reaches of Yamhill County. I am a farmer. I farm filberts. I did farm grains. I did do hay. I've done ornamentals on my property. I've done all types of things. Currently, I lease out my property for the grains, and I do the filbert farming myself. So I have a complete understanding of the spray rules and the consequences. I want to state one thing. If any farmer that farms next to a road has the same responsibilities and liabilities as anybody that would be farming next to a trail. No different. In my case, my property doesn't adjoin a public road, but I have a neighbor. It's less than 100 yards from my filbert orchard. I coordinate my spraying with a neighbor, and this is strictly a neighborly thing to do. I do it when the conditions are right, when everything's perfect. I notify them what I'm doing, and then I go and do my spraying. It's my responsibility to keep my sprays, and I put some pretty nasty stuff on filberts, off of their property. But at the same time, I want to let them know what I'm doing so that when they see it or they smell it, they understand what I'm doing. Again, there's no difference for a farmer spraying next to a trail than there is any difference for spraying next to a road. In the case of trespass, and let's just talk about, my wife and I take our dog and we walk the Banks Vernonia Trail. We take our horses and we ride that trail. And sometimes we just take our bicycles on that trail. When we take our dog on that trail, that dog is on a leash. That is part of the rules. You want to take your dog on the trail, it has to be on a leash. If my dog got off leash, broke through a fence, and trespassed on somebody's property, that's trespass. But I always obey the rules on that trail and keep my dog on leash. Also, I have animals on my property. And so I have to protect my animals and protect myself from liability. And so I use a special type of fencing. In my case, I use New Zealand fencing. It's a 12-gauge smooth wire. It's electrified. I'm not recommending it for the trail. But I use that to keep my horses in and to keep critters out. And it works for me. I understand some of the problems that somebody's going to have if they live, a farmer or somebody has critters next to the trail. I think it's their responsibility, it's my responsibility to put up the type of fence I want to protect my animals and to protect myself. I think that's something that has to be worked with on the county, but again, if I would live next to this trail, I would have my own fence up there. And then I'd ask the county, well, okay, can you put something up? Because I don't want any looky-loos coming over and looking over my fence or something like that. And that can be a big liability for somebody that wants to jump over the fence or look over the fence. So, in short, I'm saying that the bottom line of this trail corrects a safety problem. I know of 4 people that have been killed on bikes on Highway 47. And it's a real simple thing. It's an inconvenience for farmers. I know what the spraying for me, it's an inconvenience to notify my neighbor. It's an inconvenience for me to make sure that my spray doesn't leave my property. But it's an inconvenience, and that's all it is. And for a simple inconvenience, I think it's a small price to pay for the safety of the people of our community. Thank you.
Okay, thank you, Mr. Wicks. Before we get started on the opponent's case, I just want to notify the public that I do have received written testimony, letters of support from Dan Armstrong, Yamhill, Oregon, Grant Hoyt, Carlton, Oregon, Steve Battaglia, McMinnville, Oregon, and Linda Watkins, Carlton, Oregon. So those will get entered into the record also. And we have one neutral observer that just was going to provide written testimony, and that's Rob Veruska of Carlton, Oregon. So that being said, we'll go ahead and we'll move to the opponents. We'll move to the opponent's case. So Wendy, come on forward, please.
Thank you. Sarah, you come with me. Mr. Chair, Wendy Killington, for the record. And
Cheryl and Sarah Mitchell, for the record.
Okay. Somebody wants to turn on the projector so it illuminates above, that'd be excellent. So I'm Wendy Killington. I have submitted to you a binder of materials. Each of you has your own individual binder in front of you, I hope. If you do, it'll help you enormously to follow along with our testimony today of all of the farmers. I do represent all of these farmers. Everybody I represent, raise your hand. Okay. These are my clients. They're the most wonderful, smart, committed, community-minded clients I have ever represented in 35 years. What I want to ask you to do is to avoid a train wreck. Last week, the Oregon Supreme Court told Yamhill County that the way it had been applying the farm impact standard was wrong, wrong, wrong. And that wrong-headed view of the farm impact standard has always affected this case. So let's go to what the words, because I went to school on Commissioner Olson having an interest in, what the real words on the page say, and we'll get to what ODA really says about the worker protection standard on that so you're clear, because I think you want to be. But let's talk about what the Oregon Supreme Court had to say about the legal standard. It's not whether the expediency of a county's quitclaim deed for $1.4 million 2 years ago provides a nice opportunity to convert 12 miles of commercial farmland producing crops and products for the local, Oregon, national, and global economy in the amount of $50 to $60 million every single year should be thrown to the side, just thrown to the side because it's kind of inconvenient for them. Well, it's not inconvenient. The trail poses significant adverse impacts on those farming practices, and the expediency of holding a piece of paper of a quitclaim deed is no basis to throw away all your farmers. And that's what this proposal does. So let's talk about what the Oregon Supreme Court had to say. It's beautiful in its simplicity. It's in my letter that I submitted to you today, which you should also have in front of you. It's kind of long and kind of big.
Is it the big one or the smaller one?
Big one.
Okay.
Big one on my letterhead. And on page 2, the court held, a significant change or increase in cost is one that will have an important influence or effect on the farm. If I present evidence to you today, I would have asked you questions about this had I been given an opportunity. But if I present evidence to you today, either through me or through my farmers, that this trail will cause an important influence or effect on any farm, individually or cumulatively, you must deny it. It doesn't matter if it's a good idea. You're free to have a trail somewhere. And we think you probably ought to. Sounds like you need one. But it needs to be in a location that meets legal standards and doesn't throw away the $50 to $60 million a year of Oregon agriculture. The Oregon Supreme Court also told you that conditions of approval for, master plans and, nice collaboration and stuff, that doesn't cut it. So in that case, what Yamhill County had done is it had imposed two conditions that the court wanted to talk about, one being the landfill was going to foist all kinds of litter on adjoining farms, and so the county was going to, or Riverbend was going to go pay for those, for some folks to pick up litter on the farms. And the Oregon Supreme Court says that doesn't talk to the legal standard. Sure, yeah, you're picking it up, but now you're changing in an important way. It's an important influence on that farm that now they got a whole bunch of people walking around picking up garbage. That's a change. That's not a condition that saves a project. Similarly, Mrs. Jones, I don't remember her name, she had a whole bunch of cherries. All the birds from the landfill expansion were going to peck at them and ruin her crop. Condition of approval, well, we'll buy it. Oregon Supreme Court, oh, please. That doesn't change the fact that you have an important influence or effect on a farm, individually or cumulatively. So that's the legal standard we're chasing here. There are four things that the farmers are going to talk to you about, and they're going to talk to you about some other things as well. But there are four things you got to keep in mind why this trail cannot be approved. As a matter of law, you have to deny it based on the evidence in the record, because there is no condition in the approval that God himself could impose that would avoid a significant adverse impact as the Oregon Supreme Court has articulated it. The first problem is this agricultural, or not, at the application exclusion zone. Let's talk a little bit about that. In your hymnal, your big binder, at tab 3, you have a letter from the Oregon Department of Agriculture. On page 2, which is not what Mr. Sadler read to you, I asked the question and they answered it. What impact will the new worker protection rules have on the farmer's ability to spray pesticides, any pesticides, if the trail is approved? And ODA, as I think Commissioner Kula understands, said the following: the AEZ requires an applicator suspend the pesticide operation if a person or individuals on an adjoining site may be within an established AEZ. Applicators utilizing ground spray equipment must suspend the application if persons or individuals on the adjoining site are within 25 feet to 100 feet, and that's under the federal rule. So think about what that looks like. These farmers, as they will tell you, this is their accepted farming practice. They farm by spraying these chemicals. That's how they bring $50 to $60 million a year to the county, the state, and the world of agriculture. They spray those chemicals. Under the federal rule, if there's somebody on the trail, maybe they don't like spraying. Maybe they just want to sit there and watch. The farmer has to just stop. And he has to continue to stop for as long as they choose to be there. He has no ability to exclude them once you approve this thing. So what is he going to do in reality? Well, he's not going to spray anymore. Now you ask yourself, is that an important influence on an accepted farming practice? You bet it is. You bet it is. And there's attached to that letter on the second page, there's an email where I wrote back to Department of Agriculture and I said, well, wait, I get it, what you said, but was that a typo, or were you only talking about the federal rule? Because it gets worse with the Oregon rule. The Oregon rule is 150 feet, not 100 feet. And they write back in their email and say, no, you're right, we were only talking about the federal rule in our letter. And so please understand that what we've got here for these farms, and somebody's going to talk about this in greater detail, but this image you're looking at, that yellow, that is land along the proposed corridor where there's going to be no more spraying, which means there's going to be no more hazelnuts, going to be no more anything else that needs that kind of spraying, because there's a 150-foot exclusion zone. And there's attached to my letter, Exhibit 1, is an FAQ from the Department of Agriculture, where they expressly state in the third paragraph to a question about whether the AEZ applies outside of the context of workers. They say, when applying a pesticide where other people may be in proximity of the ongoing application, off the establishment in an applicator should do the following: suspend the application if people are present. That's kind of it. So the first important influence on how all of these nice people farm is that they are going to have to stop spraying for at least 150 feet along the corridor. And I don't know about you, but I don't think it even takes a lawyer to know that that's a significant impact, and this has to go straight down to the denial waste bin. Now, does that mean you want to have a trail? No. It means you're going to take a thoughtful planning approach to a proposed trail and put it in a location that's right. So the second problem, and Sarah's going to get into this in more detail, is you have not only these AEZ things, you have pesticide label restrictions. And they use all kinds of weaselly words like around. You can't spray around sensitive sites, which include parks and schools. You can't spray in the vicinity of those things. And again, ODA's letter, which I just referred you to, again, it's at tab 3, they explain, I said, what does around on a pesticide label mean? And what did they say? They said this definition on page 2 could preclude applications in fields, whole fields, adjacent to the trail or sensitive sites identified in product labeling. This is a common pesticide that these guys are spraying, and ODA enforcement folks are saying, well, yeah, it kind of looks like it applies to us, so it could preclude applications in fields adjacent to the trail or sensitive sites identified in product labeling. Now, that's kind of a big deal. Well, maybe Mr. Sadlow say, well, it says could. Maybe it means they could spray. Maybe it means they can't. And kind of like Clint Eastwood, are you feeling lucky? The farmers aren't feeling lucky, because if they guess wrong and spray where they aren't allowed to, and somebody complains, Mrs. Jones and her ladies group from Lake Oswego, who, by the way, are not used to pesticide smells and have no idea what this country is all about, complains, and there's an investigation, and around means a whole field, then the farmer could suffer civil and criminal liability. So again, is that an important influence? Thinking it is. So what's the next thing? Food safety. Okay, this is the real deal. You're going to hear about it. Food safety. There are federal and state requirements that say you cannot have dog poop, horse poop, people poop, garbage find its way into fields. People's dirty little feet and their dirty little urban shoes can't find their way into crops. It's a real thing. Lee Schreppel and others who are expert in this are going to talk to you about it, and you've got piles and piles of papers from all kinds of experts in this binder I provided to you that so says. So if The poor farmer spins the Russian relay wheel on the gun and decides, do I want a fence? Or do I not want to be able to get to my farms back and forth? Because that's how I've always gotten back and forth to my fields, is over the corridor. Do I want to have an orphan field I can't get to? Or do I want to have a fence to keep out dogs and people and horses and horse poop? Well, is he changing his practices? Sure he is. Because in order to prevent food safety pollution and losing his important certification and having the blight, the reputational blight of it being the happy victim of or purveyor of a salmonella outbreak, he's probably going to go for the fence and orphan the field. Is that the field across the trail, is that an important influence? Kind of thinking it is. And then the fourth sort of category, liability. This is real stuff. These are grain and seed fields, a lot of them. And when those things catch on fire, either because a trail user tosses a cigarette or a combine hits a rock, and they did just last year and the year before that, and they start a farm fire, there is no amount of emergency services in the world that's going to stop that fire from overwhelming the trail users. And aside from the untold tragedy of that, the farmers are going to have the pantsuit off of them. You know it, I know it. They're going to lose everything because that's how that's going to roll. Some lawyer in Portland will do a contingent fee case, and this will be what enables him to retire. And then the insurance is going to be canceled. And there's no farmer on the planet who's going to continue to farm when his insurance is canceled. And there are letters in this binder of materials that I have provided to you from insurance agents that say, essentially, these guys better not be making claims, because too many claims from trail problems, vandalism, equipment that's ruined, people that have claims about pesticide exposure, even if they're not, if the farmer doesn't just pay them off and shut them up, they make an insurance claim, they're going to get canceled, or their premiums are going to go sky high. So you can't meet the farm impact standard, is the truth. And I hope, I didn't get a chance to ask you about it, but I hope, because I know you've all been ex-partied up the yin-yang about paying for the most expensive part and building the most expensive part of the bridges, or part of the trail, the bridges, before this thing is ever approved, bridges in the EFU zone that are completely illegal to build right now. And you've been told that, geez, if you don't spend the money and build the bridges, wow, there's going to be all kinds of problems with the grant. I'm hoping you can set all of that aside, because the fact is, I'm going to pay attention to that issue too, and I'm going to have to go after it, because we've got people fighting for their lives, and you can't spend money on illegal things that don't have land use approval, and land use approval isn't going to happen here. And I hope you feel comfortable in your own skin denying this thing, notwithstanding that the county has spent some grant money, but I know for sure you haven't spent the big dollars on it, because I've spent some time with ODOT, and I know that hasn't happened, and I hope you don't. So on the conditional use permit standards, those are ones also that are going to, to me, they're non-starters. And one of the really, really big problems in the room is that the conditional use permit standards require compliance with adequate public facilities and services to serve the trail. You guys haven't even started to do your homework. There are completely inadequate road systems to handle the places that are proposed to be the proposed trailheads. In my letter to you, I have photographs of wrecks on Gun Club Road. If you look at page 39 and page 40, and these are from Lynn Weiser, who wanted to be here, but I understand she's real sick. She's a farmer, and she lives...
Ms. Kellington, can you let us know specifically where that is? Is this in the...
Oh,
this is in my packet, yes, I'm sorry.
I think she called it, what did you call this, the new one? You had a word for it. Was
Narrative?
It
My narrative,
No, I think you called it the
Page
hymnal.
39.
oh, my hymnal.
Please turn to-
Oh, the hymnal. Well, you know, I'm a good church-going girl, so that's how I am. Okay, so page 39, you'll see that, and then on page, I think, 40, there's another nice picture. And what those pictures are is they're of wrecks that Lynn Weiser says are pretty typical on Gun Club Road. The problem being, apparently I haven't been out there, but there's a separation between where the railroad bed is and where the road is, and there's a inadequate sight distance and a bad curve, and even police cars run into trees sometime. They catch some air and boom, off they go, catch on fires. Well, this is a trailhead, folks. This is a trailhead. If you look at page 37, you get to see where that trailhead's supposed to be. I don't see any place for it. So you've got an adequate public facilities and services standard. You have to write findings based on substantial evidence that's in the record that passes the straight face test that I'm not going to be able to go back and tell Luba it's ridiculous and send it back again. That says Gun Club Road is an adequate public facility and service during harvest for a whole bunch of semis bringing product in and out, for slow-moving tractors, for passenger vehicles, horse trailers and trucks, and a whole bunch of cyclists to be competing for space in July and August. You can't make those findings. You know it, I know it. That road, there's no way. Second, emergency services. Many times in all of Yamhill County, the total number of sheriff's deputies are hanging around to take care of problems is 2. Now, there's other guys and gals on the payroll, but apparently at various times they are contracted for by cities of Carlton and Yamhill and others to provide police services. They're really not available to Yamhill County for Yamhill County needs. And so when there's a call for some sort of violent event, as happens on these trails, a rape or whatever else happens to happen, because this is real rural in the middle of nowhere, who's going to respond? Who's going to police those things? There's no plan, there's no program in place. Again, impossible to make a finding of adequate public facilities and services on police. Let's talk about fire. We've talked about the very real problems with fire, and you got a letter from the Yamhill County Fire Chief, you got a letter from former Fire Chief Tim Frost, and you've got a letter from former Fire Chief Brian Cousins. And all of them are telling you the same thing. This is no place for a trail. It's too rural, it's too hard to get to, and the kinds of fuel for the kinds of fires are too big and too wide and too deep for you to be able to deal with. Number one, there's no way for a fire truck to get into many areas of this trail unless they go zooming in over somebody's field or going through somebody's livestock, scaring them half to death, and ruining crops in order to get to people. None of this has been thought through. These bridges, I'm trying to keep you from building and spending money on, aren't even, I mean, they're pedestrian bridges. They're not supposed to deal with fire trucks. I mean, this hasn't been thought through. There's no way for fire trucks to get to the emergencies we know are going to happen. What about the heart attack? One of us old guys who cycles a lot, me included, keels over. Who's going to get to him? Well, they're not going to, and the only way they're going to get there is life flighting or driving in over a farm, over a field. $50–60 million a year worth of agriculture. And we're not even thinking about it. We're just saying we'll figure it out in some sort of a collaborative, standardless, kumbaya master plan process. That's not what the standards require. I want to talk a little bit about, there are other standards, but I don't want to pig everybody's time, so I'm going to let other people talk.
I'd love to hear what you have to say. So if there are things that you want to continue with, I'm comfortable with that.
Well,
I know the
aren't
people
you
behind
nice?
you aren't, but
Yeah, they'll probably start daggers in my head or something.
I still have room on my page, so.
Okay, well, good. All right, thank you very much. One of the things, Commissioner Kula, that you talked about is somebody floated, well, what about an indemnity resolution? Doesn't that solve for these impacts? And it's kind of like hiring litter guys to go out and pick up or buying Mrs. Jones cherries. It's paying for something, but it doesn't stop the important change that the farmer's going to have to make. Because I'm not sure that any farmer is going to feel real comfortable just relying on a county indemnity agreement, since the county has a constitutional debt limitation, for example, whether that's really enforceable or something that the county would even be able to do. And besides, even if the county could somehow pay a farmer's way out of liability for allegations of improper spraying, which I'm pretty sure would not happen, or anything else, the fact is, a farmer is none of these guys, and they'll tell you, you can ask them, none of these guys are going to expose themselves to civil and criminal liability, go through the litigation, and finally win and say, okay, county, now you can indemnify me. I mean, they're not going to do that. So that doesn't solve the problem here. You heard a lot of talk about trespass and drift, and by God, we own this land now, and those farmers better not, you name whatever the farming practice is on the trail. Well, let's be a little careful with that. Number one, LUBA didn't say the county's quitclaim deed does squat for the county. It just says, that's not what we deal with. You're still in litigation with a farmer, and if I have my way, you're going to be in litigation with a whole bunch more over who owns this land. But regardless of who you think has superior interests, the fact is, and you know it in your heart, and it is undeniable, that even when the railroad used this old right-of-way, that the farmers, because it cut off a majority of these farms, or a big number of these farms in the corridor, I don't know if it's a majority, but it's a bunch of them. You can see them on this big graphic. Because it cut them in two, and the only access back and forth was across the old right-of-way, it stretches belief to say, and the farmers continued to farm, it stretches belief to say that the farmers gave away their right to cross. They didn't. The other thing is, not only when the railroad was using the old abandoned right-of-way, but also in the last 30, 20, 10 years, 10 years being the period of prescription, the farmers have been spraying the old right-of-way. Why? Because they've got really important seed crops and other crops that depend upon that old abandoned right-of-way, not sending all kinds of fun invasives into their fields. So they spray to keep that crap out of their fields. That's an accepted farming practice that they have been doing and plan to continue to do. That it was never inconsistent with the railroad's rights, but it sounds like Mr. Sadler would like to take the position he thinks it's inconsistent with your rights, and that's up to you to decide, but I think you ought to think long and hard about that. And then the other thing is, I think the whole idea about, a question was asked by Commissioner Kula, well, what are we going to do with this old right-of-way if we can't put it into a trail? And the obvious answer, farm it. Farm it. That's what you should do with it. And settle up all this litigation stuff and either lease it to the farmers, let them, just put away their disagreements about ownership, cut some sort of an agreement. I think we've got some good problem solvers on the board who'd be able to do that. Lease it to them, or sell it to them, or give it to them, whatever the way it works out being. But it's on land zoned EFU. And you've seen pictures of it. It's nothing. It's not like it's a super highway. Farm it. To the extent you want to think about all of that, Alan Brickley, again, who's the expert, who's testified about how all this legal stuff works, has a letter in the record at your tab 4, and he says, and he explains why in 4 or 5 pages, you advise that the county contends that its quitclaim from the railroad deed came with rights to foreclose or limit the underlying fee owner's access across the easement area, or limit or foreclose their ability to spray the easement area for weeds, or manage the easement area for fire prevention. If this is its position, the county's contention is incorrect. So again, setting the entire process premise on the idea that, by golly, we have a piece of paper now that says it's a quitclaim deed and we can do whatever we want and the farmers better get out of the way. It's bad from a point of view of manners, but it's also bad from a point of view of not being the world's strongest legal position, to say the least. I want to walk you through with what you have. You've got a whole bunch of people a lot smarter than me who have written testimony in the record, who've explained that there are significant concerns and problems with this proposed trail in the middle of agriculture country. Kind of like you wouldn't put a commercial trail in the middle of a foundry, you wouldn't put a trail in the middle here. And you sure as heck wouldn't send your 10 and 11-year-olds bicycling away down it. It's not safe and it's not smart. You have the Oregon Department of Agriculture in the binder. You also have an email from them, which I presented to you today, that expresses concerns and talks about the importance of this agriculture. You have insurance agents. You have Kuhn Agricultural Consulting, that's at tab 9. You have an insurance agency at 10. Valley Agronomics at page 11. Western Ag Improvements at 12. Columbia Ag Research at 13. You have Oregonians for Food and Shelter. You have the Oregon Farm Bureau. These are the quality of people, in addition to the farmers, who are telling you that there are going to be significant changes to how these farmers are able to farm if you approve this thing. Which, what does that mean? It means you don't meet the applicable legal standard. Sarah, tell them about pesticides. We have to do this because you really need to understand this pesticide issue, because this is the elephant in the room.
Thank you. So I think that Wendy already did a great job of responding to the idea that the applicant has debunked this other interpretation that exists out there about the new Oregon OSHA rule regarding the worker protection standard, that the application exclusion zone applies off the establishment. And ODA, who shares joint enforcement authority for pesticide violations, in fact says that it does. And we pointed out that ODA frequently asked questions sheet that Commissioner Kola had mentioned earlier that points out this scenario, and I'd like to kind of read from that again if I could, just to make things clear. So the scenario presented is that growers, applicators who use air blast sprayers are farming adjacent to public transportation corridors, which may include public roads or community bike trails, because the grower has either planted tall, dense hedgerows or there is naturally occurring tall, dense vegetation between the application site and the public transportation corridor. The applicator cannot see if anyone is on the road or on the bike trail. So, question posed, in this limited visibility scenario, how do applicators ensure compliance with the application exclusion zone requirements for the portion of the property that's not on the agricultural establishment? And the response from ODA is, when applying a pesticide near establishment borders where other people may be in the proximity of the ongoing application, i.e. off the establishment, the applicator should do the following. Stop the application. If people are present, you need to suspend the application. This is the worker protection standard requirement. evaluate the conditions and ensure you can continue the application safely, and then resume the application only when you're confident that there's not a reasonable chance of a car or bike passing through. So this practice, starting, stopping, is a huge disruption and a big impact on the ability to spray. I mean, it effectively creates this up to 150-foot buffer from the trail because it's just impossible to know when pedestrians or cyclists are going to come zooming by, especially when you're spraying down a row of hazelnuts where you can't see anyone on either direction, on either side of the trees there. That's a very significant impact. And we have aerial photos in the binder that we provided you that show, that highlight this 150-foot zone, and it can really impress upon you the actual amount of land relative to each farm that's going to be impacted by the presence of this trail.
Tab 2 of your binder.
Thank you. So I just want to reiterate, this is not about spraying on the trail or the farmers claiming any kind of right to be able to spray on the trail or allowing spray to drift. We all know that's illegal. Farmers know drift is illegal, and they do everything that they can to minimize that. This is about the requirement of the application exclusion zone off the establishment. And ODA says that it applies off the establishment. So the second thing regarding pesticides that I wanted to talk about are label restrictions. And Wendy also briefly mentioned this, but I wanted to go in a little bit more detail. Under both state and federal law, the label is the law. Farmers are required to apply pesticides in accordance with their labels, and every label has its own set of requirements. And we've provided you commissioners with some of the pesticides that are commonly used by farmers along the trail, and those begin at tab 37, of the binder. So for an example of some of these restrictions contained in pesticide labels, the labels for gramoxone and parazone, which are pesticides commonly used by farmers along the right-of-way, both say in big, bold, capital letters, do not use around home gardens, schools, recreational parks, golf courses, or playgrounds. Now, ODA provided a letter responding to our inquiry about these labels, and that's also provided in your binders at tab, I believe, 3. Yes. And they have said that while the term around hasn't been defined, a trail could be considered a recreational park, and that this statement, do not use around recreational parks, is an enforceable statement, and that it could preclude spraying in entire fields adjacent to the trail. There's just no knowing what or how that term around is going to be interpreted. And farmers aren't willing to take that gamble on whose interpretation to heed, to spray or not to spray. They're not willing to open themselves up to that kind of potential civil or criminal liability. So that is absolutely a significant impact. I think you can all agree. Entire fields adjacent to the trail could be forced to go out of production because of the inability to spray there. Further, some pesticides require a buffer zone, in some cases up to 100 feet, depending on the method of application, to separate areas that they call sensitive sites from the application site. And this is separate from the AEZ requirement that we've been kind of debating here. This is a label requirement, so this applies regardless. And the labels actually define sensitive sites as, quote, Areas frequented by non-occupational bystanders, especially children. These include residential lawns, pedestrian sidewalks, and outdoor recreational areas. And I think that we can agree here that the proposed trail would fall into this category as well. So again, that would mean that farmers wouldn't be able to spray these chemicals that require a buffer zone up to 100 feet from the trail. Again, taking out of production those crops within 100 feet. A huge impact. And that's all I have.
So I hope that you have been persuaded just by us. The next person who's coming up is going to go through some aerial images so you can see the impacts, and the farmers are going to start talking to you. But I hope that you can see we're not talking about a mere inconvenience, as was stated. And I hope you can also see that a trail imposes problems that are not the same as a road. They're very different, very, very different animals, as you can tell from both AG's view of the application exclusion zone as well as label restrictions. So last legal thing for me, and then I'm going to shut up. I'm asking you to leave the record open for a period of at least 7 days. I received some new material I haven't had a chance to review from Mr. Sadlow, and we have a right to ask for that, and I think we'd like to be sure that we've, really made a super good record. So unless you have questions, I'm going to let Matt Chesley come up here and go over.
Okay, Commissioner Kula, questions?
Yeah, I do have questions. I asked them of him, so I thought I should have some for you,
Sure.
but I do have some. First of all, I was confused, and I was wondering if I could get clarification on, you mentioned 12 and a half miles of farmland, and this is just a minor thing. That's a distance, not an area. Are you referring to each adjacent side of the trail?
Sorry, thanks for the clarification. I'm talking about, I believe it's 12.4 linear miles of proposed trail. The proposal is in the old application for the quote-unquote immediate construction of 3 miles, and then to provide the green light for construction whenever the county feels like it for the balance.
Okay, but you were talking about the area, you also mentioned the area that you believed would be excluded from farm production. Do you know the number of acres of that? There's 600, or was that the number that in the giant?
No, Matt Chesley is going to kind of show you the acres that would actually be taken out of production overall. The worst of it is in about 6 miles of the proposed trail, as you can see here, but there's certainly some more to the north. But someone told me it was 72 acres that would be for sure taken out of production. I think it's more than that. I think that was being conservative. But again, the point is, even if it were 1, that would be enough under the Oregon Supreme Court's articulation of the impact test.
Okay, thank you for that clarification. And then you included a quotation that I believe was from the Oregon Supreme Court opinion, the most recent one.
Yes.
But there was no specific citation, and so I wanted to say that was from the opinion?
It is from the opinion.
Okay. Next time citation, please.
Okay, fair enough.
I've only taken 1 class in law school, but they drilled that into me, right?
Cite it for him. All right.
I did, or it's fiction.
All right.
That's what they told me.
All right.
So
Well, while you're talking, maybe I'll find it.
the 60 million number that you've thrown around, or sorry, that's the 60 million number that you have referred to, 50 to 60. What is that?
I asked my guys for a ballpark, and a bunch of them responded, and I put the numbers together that I got, and that's what I came up with.
I'm sorry, is it annual farm gate value or?
Gross,
Right, so
annual gross.
annual gross of
Yeah,
all
and
of
it's very,
your
very,
clients.
it's rough ballpark. If we wanted to get real specific, we certainly could, but
Okay, so that's their total farms and not the, with adjacent to the land, or is it the land adjacent?
my understanding is it was adjacent.
Right-of-way.
I mean, yeah, it's adjacent. I mean, that's my understanding.
Okay.
I think the point is, I think we can all agree that it's a pretty big impact, and, as OSU and others you'll hear saying, this is the real deal of real farming.
Yeah, I just wanted to clarify because I know that a lot of farmers farm a lot of land, so.
Well, you can ask them. How about that? They
That's
know
right.
better than me.
That sounds good. And then I noticed that in the AZ stuff, it said should, and I'm not a lawyer, obviously just the one class. Should is it different than must? I think of should as a recommendation. Is that your interpretation?
So here's how it works in the world of pesticide enforcement. So ODA enforces, they've got a requirement. They say, here's what this requires, and I don't remember if it was could or should or what it was, but when ODA says you should do something, or that a particular exclusion area could include an entire farm field, then a farmer has to decide whether that guidance from the regulators is one to be adhered to, or one to say, no, it wasn't exactly mandatory, I'm going to take my chances. And that's where the significant impact comes in, because no reasonable and prudent farmer is going to take a chance and, dare a regulator to come after them for their could or should. And so the problem is that you will have farmers that simply stop spraying because they're not interested in civil or criminal. There's criminal liability here too.
Right.
Civil or criminal liability. And that's before we even get to the label. The labels aren't should or coulds. Those are shall and must.
Yeah, I saw those. Okay, thank you for that. Now, how do the farmers currently, and since you are representing, you probably can answer this, and I can ask them, but it's easier to start with you. How do the farmers currently deal with users of the road with regards to the AZ and the guidance from the ODA versus OSHA?
So I'm not sure how they deal with the road. I would imagine that it's not a problem with cars because you don't have people.
Because they're protected, right?
Yeah, they're protected. But if a cyclist goes whizzing by, and Brian Cousins is the best guy to talk about this because I think he may be the only one of the guys who's got this, but there may be others, who actually has part of his frontage, his farm frontage on a road. And we can ask him about how he does that, but my guess is that if there's a cyclist, he stops. The difference with the trail is that you're inviting, you hope, thousands of people to come in. You've got these intensive operations that are going to be going on, and people can linger and watch. You know, it's not like a cyclist who's in a real big hurry to get off 47 and get on something a little safer. You got somebody who's standing there, kind of watching, or who may actually be being aggressive. Say, okay, I'm going to dare you to keep spraying, or I'm going to make you stop. It's different.
And I believe that there's at least frontage on Old McMinnville for some of your clients too.
Pardon?
I believe that there's some Old McMinnville frontage as well among your clients. So there are roads that aren't just 47, but we can talk to them, right?
I think so. I
Okay.
think so.
And then I was wondering, one question I have is, are there parcels, tax lots that are split because of the railroad track, or the railroad line, where it's the same tax lot on both sides?
Yes.
Yeah.
Many.
From the
And you can see those on the blue.
Yeah.
So for example, one of them is, okay, so yeah, we got somebody who will specifically get into it, but the answer is absolutely yes. And
Okay.
it's not just a problem of farm equipment going back and forth in isolation, which is one of the concerns that ODA also lists in its email, but it's also, you got, Country Lane Dairy and Brian Schmidt's Rudis Lac LLC, where he's got cows going back and forth to water and food across, so,
Right.
yeah.
Right, okay. And then can I ask, what is the zoning on Fruit Hill's packing plant? What's the zoning there?
So Fruit Hill is zoned a combination of things. They are heavy industrial
Okay.
and rural industrial, and they have some EFU land as well. That's where their orchard is. And on the HI zone land and the RI zone land, a trail is prohibited. And I think the county hasn't been paying any attention to that because I think they wanted to turn his parking lot into a trail parking lot, and it's not allowed.
And what are some of the allowed uses on HI land, since you brought that up?
Industrial uses, I mean,
Okay, specifics, any?
no, I don't have that in my
Okay.
head. I don't really pay much attention to industrial. The only thing I looked at to see was a trail or a trail's parking lot allowed.
Yeah, my mind went lots of places about what you could have next to a fruit packing plant, so.
Yeah.
Okay, next question is, well, you've addressed that you don't think that county-provided indemnification would cover the, quote, farmers getting their pants suit off, so I'm not going to address that one again.
And it also doesn't stop the impact or the change because of the impact, right?
Right, yeah, you addressed that one.
Okay.
Okay, the next question I have for you is, I never heard the word ex parte made into ex parteed, but I really enjoyed ex parteed. And so ex parteed up the wahoo was, I believe, what I wrote down.
Is that what I said?
That's what you
Did
said.
I really say that?
Yeah, I even
talks that
Commissioner Poole, I
way.
believe it was wazoo.
Oh, the wazoo!
You know, look, here's my problem. I went to Crater High School. This is how we talk.
That's
Get it right.
That's a new legal term.
It's a central point thing. That's all I can
It's a
say.
central point thing. I love it. So my question about that, I'm sorry, was it sounds like your interpretation of the situation is that our ongoing conversation about a grant for the bridge would be considered ex parte contact with members of the staff who are the applicant in this? Is that?
Absolutely.
I just wanted to get it really clear what you were saying.
Thank you so much for that. So absolutely. So an ex parte contact is a communication with one party to a matter on a fact or regarding a fact or legal issue pending. And the facts and the legal issues about the trail are for sure pending. And so when the applicant comes to you and says, let's execute a contract to fund and build a bridge that you haven't approved yet, that absolutely is an ex parte contact about whether that bridge is legal, whether that bridge can be approved. And I took great offense to that, and I wrote 3 different letters to County Council asking him to share them with you. My understanding is that he did not do that, that you saw them for the first time in your packet for this matter. Now, what does that tell you about how the county staff is viewing my communications about the grant funding matter? Why they're viewing those as communications about the merits of the trail that we're talking about here. So I don't think anybody really seriously would contend that when a development applicant comes to you one-sided and says, hey, let's issue a contract to commit the county to build my development, let's not worry about the land use process, that you can bet that that's an ex parte contact, and there's all kinds of problems with that.
I believe that your definition of ex parte contact, though, when you began, and thank you for that explanation. It sounded like you were really excited to give it to us.
Thank you.
But I noticed that it did not reference quasi-judicial matters, and I feel like, as my understanding, we are really held to ex parte, declarations of ex parte in quasi-judicial. Is that correct?
No. So
I love that. No, but thank you for, please clarify.
So the ex parte rule pretends that county commissioners are judges.
Right.
And so anything that might be coming to you to judge, you need to not talk to either party about the facts or law about that matter. And instead, what you're supposed to do is make a decision based on the evidence and argument that's presented to you based on the legal standards that apply. Things can happen outside of that quasi-judicial hat you wear, like a judge, that are ex parte and improper and should never have happened, just like they can happen with a judge. And the fact that it happens with a judge sitting in a room in a committee he or she is involved with, and somebody starts talking about some, real big real estate case that's going to trial before him in 3 weeks, and he knows about it, and starts, making a bunch of statements about it, he better leave. He better not be involved in that. Why? It's not during the quasi-judicial process. It's something totally different, but it is designed to be a communication and is a communication about something that's pending before that judge, and you're the judge. And the applicant this just frosted my sense, that the applicant brought before you the approval of the most expensive parts of this trail that Luba just sent back on a broom to write a binding contract to fund and build without any land use approval. And then when I sent letters and I sent farmers in to tell you that's the dumbest idea ever, they weren't allowed to talk because, well, that's ex parte. And my letters weren't allowed to get to you because that's ex parte. So the applicant can bring his, goodie bag to the commissioners for a binding decision that goofs up my clients, but I don't have a chance to defend myself, and they don't have a chance to defend themselves. And that was just so backwards and so bad, and I'm still mad about it.
Well, thank you for that explanation. And I'd also like to push back a little bit that common law or case law in Oregon does make a distinction, from my understanding, based upon my reading of them, between a judge in a criminal or civil case and elected officials who are making land use decisions in a quasi-judicial manner. And one of the distinctions that I understand, at least, is that we are allowed to have expressed opinions in the past. And I think one of the language of one of the decisions even says something along the lines of that it was either Court of Appeals or Supreme Court said we expect that political figures will have opinions. And so I just wanted to clarify that I know that I'm wading into dangerous territory. I can see your eyes raised and your eyebrows. But I wanted to clarify that we are not expected to be judges, but we are expected to be fair and impartial and unbiased. Is the language.
I agree.
And I'm not trying to push back, but I wanted to make sure that that was into the record too.
I want to make sure you're clear too. But what you were just articulating were the different bias and prejudgment rules that apply to elected bodies. That's a very different thing than ex parte communications on a quasi-judicial matter brought to you by the applicant and then telling the farmers that they can't have the same opportunity. That's the part that...
Absolutely.
Yeah.
I understand.
Okay.
Yeah,
So
I recognize the difference.
my citation
Yes.
for the error of not citing is page 31 of the Supreme Court's decision at lines 10 through 14. Actually, no, 10 through 11. A significant change or increase in cost is one that will have an important influence or effect on the farm. Page 31, lines 10 to 12.
Okay, thank you. All right, and the next question, you developed you generated all these questions for me.
I love it.
Yes, me too. I hope everybody else is patient enough with us. But you brought up, maybe Sarah, brought up adequate public facilities with, road counts, is what I'm wondering about, because Gun Club Road, I know Gun Club Road. Do you think it would be appropriate to have current road counts, predicted road counts, and then capacity counts?
Yes, so again, any other developer that I've ever seen in 35 years would, before they ever submit this application, would have done first of all, decided exactly what they were going to study, what they were going to propose to do, and then done traffic counts of affected roads and intersections for geometry, site distance, width, meeting standards, area, all of that stuff to determine whether the sort of napkin proposal can meet public facility standards. And if they can't, go back to the drawing board and come up with something else. And then before the application is submitted, you have a plan and program that will comply with the adequate public facility standard, because it does. And we also have the TPR that applies here, the Transportation Planning Rule, which is a total different thing. But with regard to your conditional use permit standards, the application would say, we've evaluated the standard, we've evaluated average daily trips, peak hour trips, geometry, safety, and the proposal as we are mitigating it with road improvements and all of these things, which will be in place before the trail opens, enable the public facilities and services to be adequate. Same with fire, access, all of that. It's just, this is such a cart before the horse.
Ben Van Dyke has said that a lot, but he said it's 2 carts before the horse.
Is it? Okay, he would know.
Yeah, yeah. Okay, next question I have for you is, and thank you for addressing that. I'm wondering, I'm a little bit confused as to why a fire truck would try to go down a trail. And do you have any sense? I hike on a lot of trails and I mountain bike on a lot of trails, and I never expect that a fire truck is going to come to me.
Well, so this country is grain and, seed fire country.
Yeah.
And, if one of those things starts and you got this public trail running through the middle of that country, my guess is you've got every fire truck within 20 miles coming to try to put it out and save lives and not let it, spread at least linearly north and south to cause even more damage. So I think they're going to try anything they can do to get there to prevent the loss of life and property. And probably they're going to try to go on the trail as much as they can. But in order to get there, first, they're going to have to zoom through, Van Dyke or Gable or any of these guys' fields to get there.
So then the trail could, in that scenario, be a benefit to fire access, is what I'm hearing you say.
No, not at all, because it presents the situation where, people are going to be put in harm's way, and fire trucks have to get to them, and in order to get to them, there aren't places. None of this has been studied. And then they're going to drive on the trail as much as they can once they get there. And, Todd says, oh, yeah, it'll be plenty wide enough. But the problem is getting there. And once you get there, there's no water. And in order for a fire truck to work, there's got to be water with adequate pressure and volume. And I don't know where that's coming from, and neither does anybody in the queue here. And certainly, I don't think hooking up to some farmer's well or irrigation is anything that's going to make any sense, because then what's going to happen to the farmer trying to irrigate his crop? So, I don't know. The trail doesn't help. The trail hurts everything.
What I was hearing, though, was that in the event of a grass fire or a wheat straw fire now, you're suggesting that happens now, is that fire trucks do drive across people's fields? Or are you suggesting that doesn't happen right now, but it would in the future?
I don't think that it's a 4-alarm fire when it happens right now, because it's kind of in the middle of nowhere. There's nobody in harm's way. Sure, they come and they put it out, and you'll hear from, Brian and Tim Frost and others who, Van Dykes, who know boots on the ground how that is. But nobody's worried about the Lake Oswego Moms Club and their 12, ladies with strollers being stranded, by the trail, being overwhelmed real quick with fire. It's a very different problem.
So currently, right now, then, the 1 mile a minute fire movement, you're suggesting isn't really a big deal because it's out in the middle of nowhere. I believe I read that in the...
Yeah.
Okay. Then let's move on to my next question. I wrote down that you believe that spraying another person's land is an accepted farm practice. And what I'm wondering is whether you would clarify that by saying you don't believe it's another person's land, or you contend that it's an accepted farm practice. Which, can you clarify?
You bet. So the farmer's predecessors in interest gave the railroad something. There's an awful lot of legal ambiguity about what that something is. But I think there is nobody who can say that the farmers gave away their ability to cross or to spray that old right-of-way, because those uses would have been completely consistent with whatever the railroad got. And even if it weren't, when the railroad went away, as it did along these farms, there's no tracks or any of that stuff, for more than 10 years, which is the period of prescription, adverse possession, somebody had to do something with that right away, because it was sprouting up weeds and causing problems if they didn't. And so the farmers have been continuing to manage it without trains going over and, I mean, somebody's got to take care of it, and they're the ones who've been taking care of it. Why? Because many of them have certified fields by OSU, and as soon as you have invasives that, germinate, and they blow in the wind, they cause problems for their certified fields, as you know, I think. And so, yeah, they spray. And so it's, whether it was part of the original suite of things that the farmers gave away in the first place, and they retained their ability to take care of that land as in their farming practices, or whether they obtained a prescriptive right, because they've been doing it consistently, openly, under a claim of right for a very long time, certainly more than 10 years, they have a prescriptive right to do that. And so for the applicant to come in and just assume farmers have no rights is a really, really bitter pill to swallow and a really big assumption to make.
Isn't it the case that if we give them permission to spray, then they lose that prescriptive? Is that not, maybe I'm incorrect.
So for the last 10 years, as far as I know, and certainly for the period before the county's quote-unquote claim of ownership, the farmers have been spraying and going across that right away. And it was open, it was notorious, it was under a claim of right, and I don't know if they had permission for that or not, but I think if they had permission, then you have no business telling them they can't do it. And if they didn't have permission, they've got a prescriptive right. So either way, the farmers are doing what they're allowed to do, and this sort of wholesale big statement that the farmers, by golly, just ought to, stop their spraying because they don't have any rights. It's kind of a big statement to make without a whole lot to back it up. Maybe it's true, maybe it isn't, is the thing. But there's an accepted farming practice of doing these things that will change.
Because there's new ownership, is that the?
No, because if this thing becomes a trail, the farmers are going to skedaddle at least 150 feet away, or based on ODA's interpretation of some of the labels, they're going to stop spraying fields altogether, which means they're not going to farm those fields altogether.
I see. How would your clients feel about a railroad there?
Railroad was great. Railroad was great. Railroad wasn't any problem at all. So, if assuming, everybody kind of works out their differences and all of that, and someday, there's an idea about light rail or something like that. I mean, that's never been a problem for the farmers to have rail running across. It's not all the time. It doesn't put vulnerable people there. They can do what they do, and everybody lives and let lives. Now, whether that's all going to happen, I don't know.
I'm surprised to hear that, because back when I was just a normal person and I didn't get to make these decisions, people told me all the time about how terrified they were at the idea of having a rail line going between their fields. And so I'm surprised to hear that, because I can think of specific people in the room who expressed a great fear of that.
Well, they're free to say that, and whatever they say is true. My thought is that there has been a railroad running through there, and my understanding was when the railroad went through there, it wasn't a problem. And if it was, I don't know. Did I live there? Did I farm there? Did my family farm there? No. So these guys, they'll let me know if I'm wrong, and I'll hear about it. I'll get lots of phone calls tonight.
I just had to say at this point, no further questions.
Wow, okay.
But I think you're late for your going to Portland.
Oh, I'm okay. Thank you.
I hope you make your flight. Thank
No,
you.
I will. No, I think I can leave at 12:45 for a 4:05.
Okay.
Okay, Commissioner.
Thank you.
Thank you for your patience, everybody.
Ms. Kellington, I'm sorry, I have a few.
No.
I'll have a few too. So go
Not so
ahead.
fast. Real quick.
Okay.
I just wanted to ask you a couple of things. Could you you made a comment about the Oregon, application exclusion zone rule being more restrictive than OSHA's, the federal law. Can you just give me real quickly what those, how much more restrictive and to what degree?
Yes, the federal EPA rule is 100 feet, and OSHA's is 150. Oregon's is 150, feds are 100.
Okay, thank you. So Oregon's, we knew that they were thinking of a more restrictive before that was even actually instituted. The other question I had is, there is case law about an easement could be terminated once the primary purpose for such an easement no longer exists. So since there's no longer a railroad utilizing this corridor, that simply what could happen is the purpose of the easement would come to an end, it's terminated, and then the conveyance to Yamhill County would pretty much be moot. So my question regarding that is, should the board at some point maybe decide that this, as you said, farm it, it is more in the interests of the keeping with the culture in our county to give it back to the farmers, what would that look like?
Thank you, Commissioner Starrett. That's a really good question. I think that'd be pretty simple. I mean, the position I have always taken when it comes to ownership is exactly that whatever, and that Alan Brickley has reinforced, is that whatever interest the county got was nothing, because by the time it got it, the railroad interest had gone. It had been given up by the railroad for a very long time. It had been abandoned. But even if you just assume that the county has, some sort of an easement interest that is disputed, farmers say it's gone, it's not worth anything. The county says, well, I think we have some sort of an interest. The county could real easy just quit claim it to the farmers. It could make some sort of a deal about, again, these are deal things because everybody has divergent, positions about who owns what and all of that. But, leasing it to them, it would be a very simple thing, because why? That's what these farmers do. They farm, and they just want to move on with their lives. So they would be very amenable with working with the county to establish whatever protocol for restoring farming without all this controversy that was in the best interests of all persons involved.
Thank you. And one more question. Is there anybody who's going to be at any point testifying and giving us more details regarding the indemnification question? Or would that be a question you'd feel?
That's me. There's nobody else.
Okay, there isn't anyone else. So I know that in the past, in conversations with county council, I've brought up the question about indemnification for the farmers, and was pretty much told, and I won't quote anybody because I got the impression that it was a non-starter. It was not up for discussion. It was nothing that the county could or would consider doing. And if it were the case, it would be prohibitively expensive. So in terms of that indemnification, as the farm insurance agents have pointed out, that the farm insurance costs, the premiums would in fact increase should this recreational trail go in. What are we looking at in terms of, and do you have any ballpark of what a farmer would have to incur in terms of an indemnity policy? Additionally, in addition to what their policies already.
Yeah, I mean, I have no idea. So here's the thing about indemnity. So you continue to take the risks. The risks are all there, and someone sues you, and you get involved in some real big lawsuit over some simple thing that happened, like an alleged spray exposure that you think didn't even happen, but a whole bunch of people get together and they say it did, and it goes to trial, and you spend a whole lot of money on lawyers, and you get a judgment against you, and the judgment against you says, well, I think you sprayed wrong, or I think you were negligent, and you owe this gajillion dollars. An indemnity policy would say, well, we'll pay you back for that. The problem is I have never seen an indemnity policy, and there may be something that would indemnify for negligent pesticide spraying or, I mean, maybe there is such a thing, but the problem with indemnity is you've already gone through all of this process and lost everything. I mean, these lawsuits are, million-dollar legal fee kinds of cases. So what many of these say is indemnify, defend, and hold harmless. Indemnity all by itself isn't enough. But it doesn't solve the Supreme Court's test here. It doesn't stop the fear of lawsuits that would cause a farmer to stop farming for 150 feet on either side, or where a farmer sprays using those labels where ODA says it could mean your whole field is off limits, and he stops spraying that whole field because he's concerned about the liability, the ambiguity, the uncertainty. And so the trail itself stops him from farming huge swaths that he used to farm. An indemnity clause doesn't stop that impact from being one that had an important influence or effect on what he did at his farm. So it kind of begs the question, even if you can get one and you spend a lot of money to get it, and assuming you can get it to cover everything it needs to cover, it still doesn't solve the legal test.
Okay, I just, Ms. Cullington, have a couple questions for you. Commissioner Kula asked several of the same questions I was going to ask, but I have two. You mentioned a little bit about, and I know it's hard not to weave the grant, not weave the civil lawsuits regarding the ownership of the right-of-way and this together, but just a couple questions. You mentioned that, and you brought from safety the Gun Club Road area and you talked a lot about the trailhead, which was identified in the preliminary design. Can you show me any place where it says there will be a trailhead at Gun Club Road?
Just the preliminary design. I mean, one of the problems here is the applicant didn't even put together an application for a conditional use permit. I mean, we're all kind of guessing about what the proposal is, and so we're looking at, those preliminary designs, and we're trying to figure out what the proposal is, which is not the way this is supposed to be in the first place. So I'm going on that preliminary design. I have no idea. It could be that there are a whole bunch of other proposed trailheads. I think it's undeniable, though, that because the proposed trail would begin at Gun Club Road, that people on with horse trailers and trucks and bicycles and cars are going to be looking for a place to park to make it an informal trailhead because it's the point of beginning.
Okay, but since there is no master plan done yet, you alluded to the master plan, we really don't know if one's going to be there or not. Is that correct?
Well, yeah, we don't know hardly anything about this application, but the master plan idea is not, I mean, usually what we do is we have a planning program that comes up with a proposed master plan for a trail. It goes through this process, this hearing process. It goes through the farm impact standards. It goes through the conditional use permit standards to see if it meets legal standards. And then you've got a defined program, which I think you've been searching for, I know, more than anybody in this whole process. I want a defined program to look at. A master plan would do that for you. But this one, in Commissioner Kula's cart before the horse, we're saying, we're going to have this trail, and then we're going to figure out all the details later. And that's not the way the legal planning program allows it to happen. So I don't know where the trailheads are going to be. You don't know where they're going to be. You don't know what the affected roads are. You don't know about intersection geometry or safe intersections any more than the next guy. All we can do is infer, and that's one of the many problems with starting here.
Okay, then the other question is along the same lines. You made a comment regarding the safety of the fire apparatus on the trail and getting to people on the trail for a safety issue or getting to fires. And you made a reference that the comment that the bridges were not designed, they were only designed to be basically pedestrian and trail bridges. Since the engineering and design hasn't been done on the bridges yet, I mean, I'd like to know where that where you got your information to see if you know something that we don't know.
Yeah, well, that's opaque too, but the bridges are called quote-unquote pedestrian bridges. And when I hear about pedestrian bridges, I think about bridges that hold pedestrians and not, fire trucks. And so that's where that comes from.
Okay, those are the only questions I
Okay,
have.
good,
Thank you.
Mr. Chair, I just had one
Yes,
comment. I do
go ahead.
remember there was a conceptual drawing.
Conceptual,
At one
correct.
point that showed a trailhead at Gun Club, because I got a lot of.
Yes, there was a conceptual, and I'll agree
I
that there
got a lot
was.
of phone calls, and people were concerned because it was sort of like really close to their front door.
Right, and I got
you got
those
those
same
too.
ones, so that's why I brought up that it was in a conceptual, it
I think all that's fair. I mean, I'm not in your shoes, but if I was, I'd for sure deny it. But I'd say, I want you to bring us back something that we can work with, something that, is good for our community. Instead of tearing it apart, let's look at something that we can celebrate, that celebrates all of agriculture and provides a safe place for kids to get back and forth. The truth is out there. There are ways to do it. It's just the expediency of this abandoned right-of-way is not the way to do it.
Okay, thank you. I think, Casey, you had one more follow-up.
Believe it or not, Commissioner Sterrett prompted them with her questions. I'll go with I want to follow up on the indemnification, and partly that's because during the course of the last year, when I was listening very closely as a candidate for office, I heard a lot of conversations from farmers who were asking for some sort of indemnification if the trail was developed. And what I'm curious now, and maybe a little confused by, is was that before they had legal counsel that they were expressing that, and have their views changed with your perhaps explanations?
No, I mean, I think that's really smart. I mean, from their point of view, they're not in a position to just roll over and have this trail, foreclose farming. And so I think what you were probably hearing is, if you're going to do this, you're going to be buying the farm. I think that's what you were hearing. Are you prepared to buy the farm? And are you prepared to make sure that we can continue doing what we're doing? And I mean, that's what they want. They don't want a whole bunch of, legal papers this high, and I'm a nice girl, but they don't want to be spending a whole lot of time with me anymore. They don't want to be doing this. What they'd really like to do is just be farmers and do the good things that they do for the community and the state and the world. And, if you're going to do it to them, they kind of figure, I think that's what they told you, that you're going to have to buy the farm and you're going to have to somehow make me whole, because this thing ruins me.
And I want to clarify that I don't really want you to throw "buy the farm" on me, since that has a connotation of dying somewhere far away. Just the "bought the farm" thing. So, do you know the phrase? Oh, they bought the farm.
Yeah, okay. Yeah, so it took me a while, but now I get it. Yeah, I get it.
Okay, are you
yeah.
prepared to buy the farm when you were looking right at me?
Oh, wow, I am so sorry. Gosh, that's,
Casey,
no.
Commissioner, does that complete?
So I'm
your
usually better at
comment?
that.
one more
but-
question.
Okay, one more question.
Yeah, and that is, it's a hypothetical, because I know you love hypotheticals.
Okay.
Which is, what would happen among the permitted allowed uses in EFU zone lands is farming. And one of the allowed farming activities is certified organic farming. And I have a certified organic farm, so to me it comes up. And what I wonder is, how would practices change, if practices would change, if a person like myself started farming certified organic vegetables, nursery crops on the railroad right-of-way? And to me, it's a hard question to answer. Like, what would the practices, how would they change? Because I suspect they might change.
Well, I don't know, but the farm impact test wouldn't come up. I mean,
Right.
that's a political question. I mean, if the idea would be to sort of, I mean, I don't know what the idea would be, but,
Right.
farming's a permitted outright use.
Right. But you're right that it wouldn't, the farm
There's
impact
no,
analysis
I
would
mean,
not commit.
the idea, I mean, remember, the old abandoned railroad right-of-way, it doesn't have irrigation, it doesn't have water, it doesn't have access. I mean, I think really the only thing that it is, and for the last 30 years at least, has been good for, is farming on either side of it.
Thank you very much for your patience.
Thank you.
Okay, I think that's it now, so.
Okay, so the next, let me tell you the kind of the way I'd like to do this, unless y'all think differently about it, is I'd like to have Matt, just really quickly, I'll bet it takes 6 minutes, it's maybe 10, is to just go through the slides and familiarize you, and then let the folks talk to you. Let the folks talk to you.
Fill up my page.
Okay.
Okay, before we get Matt to start, I think with the commissioners, we've been here about 2 hours now, so why don't we take a 10-minute break, is that okay? So we'll be adjourned for 10 minutes. Wait a minute until everybody gets seated, and then we'll go ahead and start. Okay, welcome back, everybody. We'll go ahead and continue our public hearing. So do you want to go ahead and give your name and your address for the record, please?
And my name is Matt Chesley. I live on 18022 Northwest Skyline Boulevard in Portland. I specialize in remote sensing and geospatial analysis, and I was asked by farmers that contacted me to look at the impact of specifically the AEZ, this exclusion zone, or we call it the buffer zone. I've got, this is kind of the overview of kind of the southern 13 miles of potential trail with Gun Club Road at the base. So outlined in blue or cyan is the farmers that reached out that were in opposition to the trail. The magenta is kind of the trail down the middle. I don't know what's easiest for you to look at. But the southernmost end of that magenta trail is where it meets Gun Club Road. We zoom in a little bit further. You start to see a few of the farms outlined there in blue, from a small 4.5 acre hazelnut farm leased. In yellow is the 150-foot buffer that we've been talking about, that would comprise 1.3 acres of his farm, or 29%. And as you move north, you've got the dairy-owned land. They've got a right-of-way border of over 2,000 feet. 150-foot buffer would be 7.2 acres, 18%. Further north, you've got a landowner that's leasing that to the dairy, almost 5 acres, or 26%. Again, the dairy on the other side, there's another 2.8 acres, 16%. Zooming in on that, you can kind of see how the dairy is using the ground. They've got an open crossing on the north where the cows can go back and forth. You might notice clearly that the 60-foot width of that right-of-way is being farmed inside both sides. You can even see cows inside right now, the right-of-way. I'm going to just keep moving further north. The farm there on the right side, it's got an impact of about 9.5% with that buffer. And, you know, this is no means an exclusive list of all the farms on there. This is just the ones that reached out. The landowner north of there has got another 13% out of his, and on the left side of the trail, you can see another almost 5 acres or 15%. I'm just going to continue to go on up north and get an idea. So I'll look at the middle two there. Again, 13 and 15% of their acreage removed by that buffer. I was reminded that this buffer comes about no matter what kind of pesticide used, if it's used with an aerial sprayer. It could be an organic pesticide, but it's the application method that requires that. Obviously, if you own both sides of that field there, you know that no one's in that zone, and so the buffer can be ignored, if that makes sense. Further north, another 10% on that field. And then as you get up towards Carlton, you've got another 9.5 acres and 3 acres on the smaller with that buffer. This area here, north of Carlton, up to Yamhill and above, that's the area that I'm looking at next. And again, these are just the farmers that reached out. Got almost 5 acres, or basically 10%. The two fields on the north there, those are combined. They've been converted into hazelnuts, over 10% impact of the acreage. I'll skip forward a little bit more. This field on the bottom, same landowner owns both sides. So currently he can cross the buffer with his equipment. He knows that no one's spraying or no one's on the other side because it's his field. There's nobody in the middle because it's not a pathway at the moment, and so he doesn't need to worry about that. This is, you know, unlike the condition of the roads. He's kind of hit twice as hard by this buffer exclusion. Once people are in there or cyclists are in there. And of course, the longer and narrower your fields are, the more impact this has. But you know, for a pretty big field, it's got a 17% impact. The large field in the middle, you know, there's 18 acres taken out by that buffer. I might point out, I don't have the slide, but there's in between the large field in the middle and the field on the south end, there's a dairy that crosses in that triangle-shaped property. The dairy uses both sides. The cows are both on the right-of-way as well as on the other side. They wander back and forth as it's currently been used and has been for some time. And in the northern field, you see there's another 10% taken out. Oops, sorry, back here. So there's so this keeps going back. kind of a clear area where you can see that the, in the 60-foot right-of-way, the kind of the abandoned rail bed is you know, less than 15 feet in some places. The farmers, being farmers, they farm the flat ground. They've put the time in. They're farming right up to where the rail bed was, as they have for decades. And you can go back and you can look back in time. While the aerial imagery doesn't get as sharp and as clear as this as you go back, but you know, clearly since the 90s, they've at least been farming this ground. They've applied the soil conditioners. They've adjusted the pH. It's in their best interest to keep that boundary as small as possible, because of course it makes their fields as good, as well as the additional crops. So when you add the 150-foot buffers, plus if a farmer's farming half of that right-of-way as now, that's another 30 feet of the 60, then you're, get my figure here, every 132 feet of right-of-way, you lose an acre. And that's just the space and the analytics. If you don't have any farm inside the right-of-way, you lose an acre every 145 feet. And that's just because you have to pay attention to this exclusion zone. Now, north of 240, you've got the Fruit Hill Orchard. You've got 30 feet proposed, as been relayed to me, in the high industrial zone, and that's about almost 14% of that parcel. You've got a light industrial zone there on the left, an 18-acre parcel. The 150-foot buffer zone would take almost 19% out of that field. I think you get the general idea here, and that 150-foot zone is something would be a pretty significant change from current practices. Further north, as the fields get longer and narrower, the impact goes up. You've got 6 acres of impact, 28% of that particular property owner's field. Then further north, there's 8.5 acres there, 22%. And that's a conservative number, because that's not 22% of his farmed area. That's 22% of the parcel size. So where you have a creek going through, he loses a few acres, and suddenly that 150-foot buffer doesn't become just 22%. It might be closer to 25 or 30. And of course, if you happen to own the field on the right side and you lose almost 7.37 acres, that's 43% of that parcel. So that gives you a little bit of impact of an idea of an impact of the size of what that buffer does. You know, the farmers react to what's needed, whether it's a pest or a fungus or something. Last year the buffer was 100 feet. Oregon changed that to 150 this year. Who's to say they wouldn't change it depending on the type of application or the type of pesticide that's needed for the next invasive species? It's not really a problem right now, because the right-of-way is not something that they need to worry about people being inside. Even if they don't own the other side, if they farm next to a farmer that they can coordinate with, I think we heard somebody earlier talking about they can work with their neighbor. And finally, I'll say I'm a cyclist. I've spent I've got hundreds of miles logged on the Banks to Vernonia Trail. I love riding that. It's in mostly forest land. You've got rotations of 40 and 50 years. You generally don't have the application of pesticides and herbicides on a lot of these large forest land. When they do, they're very seldom. They can be posted. I think linear trails are a great idea. In this area, I would be, you can't ignore the impact to the farmers. That's clearly obvious. But as a family person, I would be a little bit more concerned about the conflict of bringing some of those back into my house if I were riding on there. I also know that I can ride on flat ground. It's easy to ride 15, 20 miles an hour with just a normal bike, and to have a farmer get out and look up and see that it's clear and get back into his machine and come forward, well, you can travel 1,700 feet in a minute and at 20 miles an hour. So the idea that someone can check and see if it's clear and get back in and then come down the end of their hazelnuts and turn and oh, there you are. I think that potential is clear, but anyway, that's all I have to present.
Okay, thank you very much. Any questions, Casey? No questions? Commissioner Starrett, no questions? Thank you very much. Okay, now we will go ahead and take testimony for the opponents, and I'm just going to go through these in order that they were submitted. So the first one I have is Jim Van Dyke. So Jim, come on forward, would you please?
Good afternoon, Jim Van Dyke, PO 400 Yamhill. Well, those are going to be hard act to follow. I guess most everything that was wanting to talk about has been discussed. I think one of the main things I hope you all realize is we don't get a paycheck. We don't have a secondary job. This is how we make our living, all right? So, if you start beating up, you see 10% quite often. There's one little strip there at 40%. We know that's exaggerated for the whole deal, but it's a significant impact on our farms, all right? I have some real concerns with this, with what's been going on with the fire. Wendy was asked a little bit, I think it was maybe misconstrued. They, I don't know, Mary might have asked about, okay, a fire truck going down the trail. Well, what I was referring to in my previous testimonies is we have field fires. It's just a way of life. You run a rock through a machine, you set the field on fire. We all know what happened in Morrow County last year. Mr. Frost touched base on that, where fire's going a mile a minute. If you have a bike event, people are going to get hurt or die. I mean, it's just, you're putting them out there where they don't belong. As long as that's not a trail, it's not an issue. It runs across there and they catch it at the next road or pull into someone's house. And yeah, if there's a fire going on, absolutely, get those fire trucks out through our crops if they have to, deal with it. That's not what we're talking about. I'm talking about personal safety of people. You talk about little Johnny riding his bicycle between the two towns. Little Johnny is not going to outrun a fire. I've dealt with fire my whole life. We used to open field burn. We've kind of given up on that. I know what fire can do. So that's a very serious concern of mine. The spraying issues, my son that I'm in business with, he does most of the day-to-day operations, so he can address a lot of this buffer zone or exclusion zone, excuse me. I'm not the guy to talk to because he deals with that daily. But what I want you to think about, and I know you have to base your things on our crops today, but farming isn't going to be this way forever. It's a changing evolution of crops, of markets and everything. Another thing that's come up today that, that I'd like to touch base on, this exclusion zone wasn't an issue a year ago. Well, this is a new rule that's come in. What's ahead? What's going to happen 3 years from now? What are they going to throw at us 3 years from now? It just complicates things having this trail through our property. So that's one of the biggest issues. I guess I really, I have some real strong feelings against what you're being advised by counsel, Mr. Sadlow. I think in the past, we're very concerned about it now. We watch what we do a little bit more. But we have testified in the past, and I feel that a lot of our information hasn't maybe even got to you. Just yesterday we went, maybe you can answer a question for me. Yesterday we brought that handbook out to you. My cousin John and I got that job, so we had 4 of them. We carried them to your office, and the receptionist says, no, you have to take those to planning, and planning will disperse them. We walked over immediately to planning. This is at 1:30 in the afternoon. The door is locked. There's a sign. They're closed Wednesday afternoon. So we walked back and we demanded that she accept these. She had to call Mr. Olson and see if that was okay to accept it. I mean, and he said yes, and hopefully you got them this morning. But I guess, to me, I'm frustrated with, yes, so I guess I'm frustrated with, why couldn't we just drop these off when we first walked in there? I thought that's where they were supposed to go. And I guess I just feel like we get snowed a lot. You know, one of those meetings, they shut us down. They said we could not talk about the Luba appeal. And I really think, couldn't we have talked about that? So I feel we get snowed a lot. We're not congressmen, we're not politicians, we're not anything. We're just out there making a living, and I really feel that we get pushed aside a lot. That's why we've hired Wendy to kind of represent us and tell us what's legal and what isn't legal. So I guess with that said, I just want you to take all these facts that we're trying to present to you. Wendy compiled a pretty good portfolio of what we've done, and I want you to really read the facts. We don't care about a trail, we don't care about anything. We just want the facts out there that a lot of this just plain doesn't work. So please do your homework before you sign on the bottom line, okay?
Okay, thank you, Jim.
Thank you.
Okay.
We did get them, and I think we all got to read them maybe late.
Yeah, I got mine yesterday afternoon, so I read it last
Is that normal
night.
policy?
Yes.
Yes.
Okay.
Yeah, yeah, but thank you for bringing it up, because that's important to me.
Okay, John Van Dyke. Come on forward, John.
Good morning. I'm John Van Dyke, 1255 East Main Street in Yamhill. But before I get started here, I'm going to bring up a point of clarification. The contract that you were about to sign with OBEC specified right in the contract that the bridges would be designed and built to the preliminary designs. So that you were almost ready to sign that. So anyway, that's where that's at. Anyway, good morning. I have submitted a letter for the record. I own approximately 22 acres that lie on both sides of Stag Hollow Creek and bordered by the abandoned right-of-way. My letter details my operation and the negative effects the trail would have on my farming practices. Your packets include letters from farmers and neighbors who are affected by the significant impacts that this trail would inflict upon them. These same people are the backbone and bread and butter of this community, and to force this on them would have a devastating trickle-down effect on the entire community. Please read these very informative letters, as they include the details that show why land use laws are so very important. Recognizing the huge impact it would have on farming, the Benton County Board of Commissioners had the good sense to deny a trail proposal that would significantly harm working farms, and you should deny this one also. Thank you for taking the time to carefully consider this matter.
Thank you, John.
Thank you.
John, can I ask you one question about that? You brought up the Benton County case, and it's actually, it was land that was going to run through a friend's farm, a friend of mine, a good friend, and he has told me back in the day, so not recently, told me all about their operation and what happened there. Was there anything to your knowledge that was different about that application or proposed trail than this one?
I'm not real familiar with the entire case. I just know that it was denied for farm impact stuff. So,
can I tell you what the difference was? Do you mind?
Sure.
The difference was that they were proposing a brand new trail through the middle of farmland where there was no previous trail existing. There was no previous right-of-way. And that's my friend's, he was very concerned about that. So, but I appreciate bringing it up because it is a case where Benton County did deny.
Yes, and it deals with farm impacts.
Yes, exactly. But it was a brand new one. Yeah.
Thank you.
Thank you.
Okay. Lee Schreppel. So Lee, come on forward.
I'm Lee Schreppel,
sorry, Lee.
of Fruit Hill Incorporated. I live and work at 6501 Northeast Highway 240, Yamhill. We, the Schreppel family, have farmed in Yamhill County since 1919, processed fruit since 1950, and been processing fruit in our Yamhill location since 1955. I recently submitted a letter with enclosures from food safety and risk control consultants that should be a part of the record in these proceedings. It should be in the hymnal that you got.
That's different. The hymnal is different than the binder.
Okay, well, it should have come in, it's one of the tabs in.
It's in there. Yeah, it's in there. I read it.
In my letter, I described our properties that the proposed trail will impact. Fruit Hill farms cherries, plums, hazelnuts, and wine grapes, and is licensed by ODA as a food processing establishment. Our fresh and frozen products are marketed nationwide and internationally. We've been Global GAP certified. Our processing plant is kosher and certified by Oregon Tilth as organic. Our plant is Safe Quality Food SQF Edition 8 audited and certified for compliance with the Food Safety Modernization Act. We're registered and audited by the U.S. Food and Drug Administration. We're also audited by the Oregon and U.S. Departments of Agriculture. For 7 years, we have employed a full-time, very highly trained professional food safety manager. You need to sort the wheat from the chaff today. You've heard about the law. You need to hear the difference between what is said as opinion and preference and which is expressed as fact and impact. We all dread the consequences of a situation such as seen in the news about romaine lettuce, spinach, peanut butter, or hazelnuts. If our customers or their consumers are given a reason for doubt or concern about our food safety, our business will not survive. The proposed trail creates substantial potential for unsanitary practices, trash, contamination, trespass, and thefts that could be ruinous to our food production business. The prospective trail amounts to more than 10% of our HI zoned site. For the county to approve use of this site for a trail, it would do irreparable harm to our present and long-term use of this site. Fruit Hill's investment in food safety and defense literally runs into the hundreds of thousands of dollars, including facility improvements, staffing to identify and manage related risks, and the redevelopment of our company culture. Any threat to this investment is a threat to our survival as an agricultural industry, a farm, and an employer. Regulators and third-party auditors are very liberal in determination of what is our premises and do not like to stop at a property line. The proposed trail will substantially limit, impair, and prevent the use of our property for the permitted uses listed in the underlying zoning district. It is up to the applicant to prove that this proposal does not cause these adverse effects upon farming and our agricultural business. We will not be able to convince insurers and regulators that we can keep the food we grow and process safe without significant new costs. We have production and warehouse facilities very near the proposed trail. These facilities are kept to a high standard of cleanliness, and they would be vulnerable to trespassers, and their security and sanitation could be compromised unless we build sophisticated fencing and install expensive security devices. Fruit Hill has an extensive pest management program and undertakes costly measures to control pests. Litter along the trail would likely attract more pests, such as rodents and insects, to our grounds and facilities. The much larger concern, however, is not about inconvenience and aesthetics. It's about our role in providing a share of the world's food supply. Litter, loitering, human, animal, and food waste are totally incompatible with ingredients for baby food, yogurt, ice cream, and pastries. It is a potential nightmare with disastrous and irreversible consequences for our customers, our consumers, our farm, our family, and for the community. The applicant has no plan or program to manage this. We are concerned about the attraction posed by farm and fruit processing equipment, forklifts, and licensed vehicles parked a literal stone's throw from the proposed trail. Our workers, vendors, and visitors park on the site at all times, day and night. Ramps are on the site from which we load and unload trucks who park through the night. The increased risk of theft, vandalism, adulteration, sabotage, and contamination related to increased traffic could force a shutdown, an audit failure, a food safety recall, or let your mind run with it. What's worse, a death? In suggested measures of mitigation offered by the applicant, signage, a fence, and gates are proposed. Signs only warn, they don't stop. It's difficult to imagine trail fencing and gates that would not substantially interfere with our farming, and that wouldn't be extremely costly for us to install and maintain. Securing Fruit Hill to the extent expected by customers, auditors, and regulators in the face of public access, as proposed by applicant, we need a 6-foot chain link fence topped with barbed wire. It will need to surround the entire processing operation in a way that secures from intentional and inadvertent intruders, with adequate gates and operating systems such that it does not interfere with day-to-day operations as they're currently conducted and projected to function in the foreseeable future. A fence with adequate gates and operators is really only the start. Installation and annual costs of operation and maintenance for new warehouse walls, doors, state-of-the-art locks, motion sensors, lighting, cameras, recording equipment, and likely increased insurance premiums will cost additional thousands of dollars to assure the safety and security of the food we process, the people we employ, and the vendors who frequent our facilities. The proposed trails crossing of Oregon Highway 240 is already used by a local school bus company, several residences, and a storage facility. A trail could attract many people of all ages and modes of travel, crossing where the highway traffic crests a hill with limited visibility and is accelerating as it departs Yamhill. Traffic congestion is already a potential issue, as evidenced by near-miss situations we have observed, and the trail will compound the risk for semi-trucks of our vendors and automobiles of our employees which come and go, day and night. The trail cannot be allowed to compromise personal safety. You must recognize that the impacts from the proposed trail to our farming operation are significant, cannot be easily mitigated, and will significantly increase the costs of our farming practices. The applicant has not and cannot demonstrate that the proposed trail meets the state's EFU zone standards, the county's farm impact standards, and the conditional use permit standards. The county cannot find that the adverse impacts upon our farm lack significance and will not significantly increase the costs of our farm practices. The applicant has not demonstrated that the proposed and intended use is or can be made compatible with existing uses and other allowed uses in this area. The proposal must be denied. As did Wendy earlier, and I'm requesting a little more than she asked, we respectfully request that the record of these proceedings remain open for at least 2 full weeks to afford all of us the opportunity to address matters that we are hearing for the first time today. Thank you for your attention.
Thank you, Lee.
Mr. Chair, I have a question for Mr. Schraple.
Go ahead, Commissioner.
Mr. Schraple, you said you've been farming, your family's been farming for a century,
Yes, ma'am.
100 years. Have you seen fewer or more restrictions in terms of agriculture over the years?
Exponentially more. It's just, there's so much more regulation now that it's incredible. Year to year, even.
So since 1919 to 2019,
It's a different world when it comes to regulation, expectation. Expectation goes beyond regulation. Sometimes there's a leapfrog, but the Food Safety Modernization Act, enacted by Congress, and put in the hands of the FDA, really, really raised the bar. The food processing industry saw it coming, was preparing for it. There were all kinds of standards around, and I think it kind of harmonized the way that people had to be safe as a food producer or processor, so that certain agencies became generally well accepted as auditors to be a credential to show that you were qualified to do what you do. Did that address your question?
thank you.
Yeah. Casey?
Thank you. I know that your last name is Schraple, but thank you for coming, and thank you for having Fruit Hill. I mean, it's a treasure for our county, and you know that, hopefully. I wanted to ask a few clarifying questions, though, if I could. What I'm wondering is, what is the history of your properties, because there's multiple tax lots right there with the plant, with regards to a trail or an easement can you explain how it is that the trail might go through your property? I've heard that kind of some history, but I've never heard it from you.
You have a specific question?
Well, I'm confused. I heard from Wendy Kellington declared that you can't put a trail through HI zone lands. But then my understanding is that there was some kind of easement for a trail or some kind of easement through property that you own. Which of those is true or not true? Is there an easement through your property for?
I'm not in a position, a witness, to attest to the HI qualifications and limitations.
Okay.
you got a planning department and you've got attorneys that should be giving you good advice about that. The 3 parcels we have are now displayed.
Yeah.
The parcel that is the 19-point-odd acres that includes my home site, quite a bit of Stag Hollow Creek, and an orchard was purchased by my parents as part of a 20-ish acre property in 1955. It was a former sawmill site. The smaller parcel that's 3.23 acres where our processing facility is, first of all, the 19 acre is an EFU zone. The processing site is on the Resource Industrial, or RI, and that's where the sawmill used to be. The mill pond used to reach way back up through our property and into properties further to the east. What used to be a planer mill and railroad sidings is the 900 to 1,000 foot section that runs north and south, 250 feet wide, that we offered to buy from the railroad in the 1980s when the railroad discontinued use of the rails, and we negotiated on and off for decades, purchasing it in September of 2013. At the time, the railroad and the trail people and perhaps even the county were in conversations. I probably shouldn't even say that. That's hearsay on my part, but I heard that they were in conversations. And the railroad was unwilling to sell that 5.6 acre parcel without provisions to provide reassurance for a trail if the trail were to be constructed in a timely manner. And so the timely manner was built into that easement, which I've always just considered to be a prospective easement until it's proven that the conditions have been satisfied. That answer your question?
Yeah, that's exactly what I wanted to hear. I wanted to learn. Thank you. The other thing I wanted to ask about is because the land around the plant is, it sounds like is owned heavy industrial or resource. Is that what you called it?
The 5.6 that came from the railroad is HI, heavy industrial. The plant site is resource, or whatever RI stands for.
Okay, that sounds great. I just wanted to clarify that. Okay, thank you.
Okay, thank you very much, Lee. Okay, that'll take Sarah Mitchell. Come on, I'll get forward again, Sarah.
I've already said
Yes, so
what
that's
I would
actually
like to
all.
say about pesticides, so I'll let someone.
Got it, thank you. Ben Van Dyke. Ben, come on up. Oh, the tractors for demonstration purposes, right?
Yep.
You can't keep it.
Yeah.
That's payola.
That's payola. Or $75, $50.
Thank you. Ben Van Dyke, 15221 Northwest West Side Road in Yamhill. The tractor, the iconic symbol of a farmer. It represents the simplicity, the idea that if you jump into the seat and make a few circles in a field, magically crops are produced and the world is fed and clothed. I watch this production play out night after night in my living room floor with my son and daughter. As I watch them dream of a future when the tractor noises are real and they are the ones in the seat, I'm reminded of when I was farming, when I thought farming was just as easy at their age also. Really, the basics of the thought are correct, but as they say, if only it was that simple. Farming is a complex business where producers are constantly involved in a dance where we manage the things that we can, prepare for the things that we can't, and pray that at the end of the year, we are blessed with an opportunity to do it all over again. We work hard to produce the highest possible yields, exceptional purity of seed, and the highest quality food in the world. To do this, we have to be diligent and attentive to the advances in agriculture so we can keep our crops healthy and our customers satisfied. We find ourselves here today in what boils down to a land use issue. People keep pitting it trail versus no trail, and that is not correct at all. I'm very pro-trail, if they are planned and constructed in a way that they honor the EFU rules that have been put in place in this state. These rules, enacted in the 1970s, were put in place to protect the large tracts of farmland from being cut up and divided in such a way that they would limit the productiveness of the state that we live in. Where we find ourselves today is where the applicant wants to cut, dissect, and divide large portions of land that I currently farm and place into that cut unabated access to the general public that have never had access there before. I have farmed many of these fields since I was a kid, and besides the strip of gravel that I was told had a railroad track in it at once in a time, there has been no encumbrance to farm the land on either side of it. We manage the fields like the gravel is just a small obstacle, like a tree or a patch of rock. This new dissecting trail will have a major impact on the operations we currently exercise on these lands. I've outlined many of them in my letter that I submitted earlier in detail, but let me recap a couple of them. Trespass into cropping areas, application exclusion zones like we've talked a lot about today, increased risk of fire due to human activity on the trail, inability to cross the trail due to fences, gates, people, dogs, horses, you name it. Loss of the ability to grow high-quality seed at the foundation and even the certified level due to the strips that will be converted into trail that we are currently farming that will have purity implications on our seed crops. Increased need for higher insurance levels and increased insurance premiums, and changes in our farming patterns to try to accommodate trail users. All of these occurrences have a major impact on the way we farm. Each field and crop are very unique and will require a different means to address the impacts of a new trail. But at the end, they all cause damage in our farming practice, and those changes all have a cost. We have all seen the standard of what an applicant must prove to get a conditional use permit on an EFU zone. The standards are very strict. In the past week, they were made even clearer by the Oregon State Supreme Court in a case that this very county is involved in. The court included this: when the parties dispute whether a non-farm use will force a significant change to a particular accepted farm practice or significantly increase the cost of that practice, the farm impact test in ORS 215-296-1 requires an applicant to prove that the proposed non-farm use, 1, will not force a significant change in the accepted farm practice, and 2, will not significantly increase the cost of that practice. A significant, quote-unquote, change or increase in cost is one that will have an important influence on the effect of the farm. The applicant to this point has done zero to investigate and document these farm impacts. These must be done farm by farm and field by field on a granular process as stated by the court. The burden of proof falls squarely on the shoulders of the applicant, and in this case, all the evidence has come directly from the affected landowners and farmers. The only way the applicant has gotten away with this is that they are also the ones telling you, the commissioners, that the laws and procedures you must follow because they are county's land use council. They are the proverbial fox in the henhouse, and as the chickens show up missing, they keep telling you with feathers in their mouth they have no idea what's happened. You are being sold a bad bill of sale, and it's time to call these people to question. The time to act on this matter is now. You have seen where the land use proceedings have ended up for the Riverbend landfill, and I don't want this land use matter to follow that similar path. But if it must, We are willing to fight, not for just our farms, but for Oregon's EFU laws. For most of you commissioners, you inherited this problem. You are not on the leading edge of getting this to where we are now. It is time to let the folly of this project be the legacy of your predecessors. It does not need to be how your commissionership is remembered. You have the power to stop this waste of time, money, and energy and move forward with more important matters. I know for myself, I would love to have this saga behind me and get back to what I love doing and what I dreamed of as a kid. When I used to go around, I just want to sit in a tractor seat. I'm tired of sitting in front of you. Thank you.
Thank you, Ben. Any questions, Mary?
Thank you.
No. Please, Commissioner Kula. Commissioner Kula.
Hey, Ben. Or excuse me, that's not very appropriate, but we'll figure it out, right? Ben, I would love to ask you some questions, but you up for it?
Yep.
Okay, just want to make sure. Do you have a sense of how many hours every year you spend spraying?
It's a tough question. I'd have to go off applicator hours.
Yeah.
And we do want to do it as whole as a farm or as me personal?
I was thinking whole as a farm.
Whole as a farm. Between our 4 applicator buggies, they probably get close to 1,200 to 1,500 hours a year put on them.
Okay.
And that's
what I
just
would've
application
guessed, yeah.
time.
That's what I would have guessed, yeah.
Sure.
The like actual moving time.
Yep.
And how does that compare to how much time you spend farming in a year? Probably.
It's a large percentage of what we do.
Yeah.
But I can't equate a number to that for you.
Yeah, no, but it is a large percentage, right?
Yeah.
That was what I wanted to find out.
Yes.
Okay. One thing I wanted to clarify is, as far as I understand, the staff report is what has presented us with a move to recommend for approval of the conditional use permit. Just, I wanted to clarify that.
Okay.
Yeah, but thank you. I wanted to get a sense of how many hours you're out there spraying. So
Sure.
Thanks
Thank you.
for that.
Okay, thanks, Ben.
Yep. Thank you.
Boy, might as well keep this rolling now. Let's go to Casey Van Dyke. Casey, come on forward.
All right, I'm Casey Van Dyke, 11900 Northeast Yamhill Road, Carlton. I work for Ben. I'm an employee on the farm. My main job on the farm is pesticide application. That's, when you see a sprayer out running, a lot of times it's me in it. So what I want to talk about is the issues that brings to me as an applicator. So having a pedestrian trail directly through the middle of active farm ground has a major impact on how I do my job. Pesticide application is a very important tool we use to maintain the health and purity of our crops, and we do several applications per year. This is not once or twice a year, this is many, many times a year. I follow many laws and labels, including the application exclusion zone that you've heard so much about today. According to this law, many applications would not be possible when people are present on the trail. This poses a major problem. When I'm doing an application, we often work in small, tight weather windows to get a certain job done. We have a lot of fields to cover, and sometimes you got a small window that has to be done in. If we have to hold off on an application because of people present on the trail, we may miss that window of opportunity. Specific wording in the AEZ that states working by a public corridor, the applicator should make applications where there is lowest probability of people being present, such as late evening or early morning. Having to make special plans for an application by the trail has a major impact on our farming practices. Also, most labels specifically state do not apply during an air inversion. Early morning and late evening are when inversions most likely occur. This will also cause us to become completely inefficient. Equipment is large, and we move from field to field in a planned and efficient way to limit road time and maximize time in the field. Having to move in and out of a field multiplies times that we do one spray application. So having to move in and out of a field multiple times to do one spray applications so we comply with the AZ has a major impact on how we get the job done. Also, the trail will severely impact how we access some fields. We currently use the right-of-way to cross large equipment back and forth. This is done multiple times per day when we're working in that field. Not being able to do that quickly and efficiently greatly impacts our farm operation. Please keep in mind this land is zoned for exclusive farm use. Building this trail will have a major impact on our farming practices and my ability to do my job on land that is specifically zoned for farming. Thank you.
Thank you.
Okay, thank you, Casey. Well, let's keep it rolling. Sure.
Ask you a question.
Sure.
'Cause they come up, like I'm in your world on the weekends now, but there was in Ben's testimony, written testimony, there was talk of 25-foot wide equipment. Can you explain which of your equipment? Is it just a grain header or?
Our grain head is 30 feet wide.
Okay.
Our boom sprayer,
Yeah.
we have two boom sprayers. The largest one is 100 feet wide.
Right.
And for an example, when I cross into, we have one particular field I can think of that's landlocked. We only access it across the right-of-way. So I have my booms out 100 feet wide and cross that corridor. If I had to open gates, that's, for one, I got to stop, open gates. I got to fold the booms up.
Yeah, that was kind of what I was wondering about. Yeah, okay, thank you, because I think you brought that up. The other question is, how often do you encounter people alongside the road? Do you spray alongside any, like Highway 47?
Yes, I do.
And then do you encounter people regularly who are in the unprotected class?
It's not regular, but yes, you come upon, if somebody's walking or biking, I do come upon them, and I do immediately cease what I'm doing until they pass, absolutely.
Okay. And it's uncommon, but it happens?
Yeah, yes,
Okay.
it happens, yes.
Okay, thank you for answering those questions. I appreciate it.
Okay, thanks, Casey. Corey, you might as well come on forward since we're talking about the Van Dyke. So Corey, come on forward.
Corey Van Dyke, 2312 Northwest Wintergreen Court, McMinnville. You might be surprised to learn I'm not a farmer. I'm a Van Dyke, but I'm not a farmer. And I've submitted a letter for the record, so I'm not going to rehash all of that, but I just wanted to quickly state I'm not a farmer, but I manage a local grass seed company, so I do kind of have a handle on what goes on. As I've outlined in my letter, I think the trail could have a severe impact on the quality of the seed products that are produced along that corridor, mostly due to invasive weeds if it's not able to be properly managed. And that is a real concern, and it costs people a lot of money, not just the farmers. So anyway, for that reason, along with all the other reasons that you have heard and will hear, I am opposed to the trail.
Okay.
Okay, thanks, Corey.
Thank you.
Okay, it looks like Brian Cousins. Brian, are you still here? He's still here.
Good afternoon. Brian Cousins, 6325 Northwest Glencoe Road, Hillsboro, Oregon. I came here this afternoon with all of the same concerns that everybody else has, excuse me, presented. So I'm going to kind of skip over the trespass issue. One thing that I will say is trail users do not stay on the trail. Another issue that I have is access points. Based on what we've seen so far is the limited number of trailheads will create every driveway and every access that borders the trail to become a trailhead. And along with that, people such as myself that have access that literally crosses the right-of-way becomes a great concern for us because literally it will block our access to get to our field. One thing that I do want to reiterate, or I should say emphasize, the issue of the ag chemical issue that will undoubtedly come up from the trail users. Oftentimes, our chemicals that we use have reentry periods, restrictions that can last up to 36 hours. And this goes hand in hand with the trespass issue. Even though we post our fields, it's not unusual for us to get people from town that actually ignore these postings. As you've heard, the new worker protection standards will not allow untrained people within 100 feet of air blast sprayers, and it's actually 150 feet in Oregon. There isn't a grower in this room that wants to be OSHA's first test case. So nobody's going to make that differentiation between farm workers and bystanders. As many of you know, eastern filbert blight has ravaged the Willamette Valley and nearly destroyed the industry. Our new varieties are blight resistant, but they're not blight proof. So if we have areas in our orchards that cannot be sprayed in a timely manner due to the trail, we run the risk of creating pockets of blight that will affect future production and possibly the overall resistance of our trees. And another issue that hasn't been brought up today is property values. What happens to our property values? My guess is that if this trail goes in, our values go down, they don't go up. I'm addressing you today with firsthand knowledge of trail issues as both a landowner and an emergency service provider. I'm the retired fire chief of Banks Fire District. We contracted emergency services with the Oregon Parks Department to provide coverage for the for the Banks Vernonia Linear Trail. In my 15 years as fire chief, I've seen dozens of issues ranging from heart attacks to wildland fires, all directly related to usage of the trail. I'm also an avid mountain biker. I've ridden hundreds of miles on the trail, so I feel I have a very good working knowledge of the clientele and the unforeseen issues that a project like this will attract. Does the county have a plan to deal with the emergency services of this project? My experience is that trails usually don't attract criminals, but they do attract mischief. And the recipients of that mischief are the adjacent landowners. People don't think about things like trail users that smoke, trail users that light off fireworks, trail users sometimes use firearms, and sometimes they start mysterious fires just because no one else is around. I've seen each of these firsthand as a fire cause, and allowing this conduit through dry brush and fields is a hazard to the adjacent landowners that currently does not exist. Signs and rules don't stop this, and when no one is watching, people will do as they wish, day or night. And finally, the advocates for the trail that are here today are only a tiny fraction of the people that will actually use the trail. I know that these people in this room will follow the rules, or they wouldn't be here today. The hundreds of people from outside the area that don't know the culture of this area are the people that worry me. Thank you.
Thank you, Brian. Any questions for Brian?
Yes.
Eric?
Yes, thank you for that. We've heard over the years, we've had several of these hearings, we've heard a lot of testimony saying that the Banks Vernonia Trail has been virtually without incident, and if that is the prologue to a proposed trail here, we would expect to see no incidents, some of the things that you mentioned. Having been in that emergency response capacity, can you give us some details regarding that in terms of the Banks Vernonia Trail? Because we've heard nothing but glowing reports about how the trail operates there.
Yeah, I believe I can address that. First of all, there was a gentleman up here earlier that said that in Columbia County there were no issues. Columbia County is about a fifth of the traffic as the Washington County side of the trail, mainly because of the Stubb Stewart Park. One of our biggest issues as responders was the majority of these people are from out of the area and they have no idea where they are. So when they do have an issue, we spend a tremendous amount of resource and time trying to locate these people. I've seen everything from suicides to horses that had to be put down on trails, all because it's just a place where people think that there is, I guess they're out of their element as far as the urban setting, and they feel that they're so far out in the country that basically there are no rules. So I'm not sure if I'm answering your question specifically. Did you have a...
we have been painted a picture of the Banks Vernonia Trail being a place where everything really functions well and there are no incidents, and that's what we've heard over the years.
Well, no, that's simply not true. I've been associated with the trail since 1990. We used to live in the Banks area, and I probably at one time knew the trail better than even the people that maintained it. Like I said, I'm an avid rider, and one of the things that I know that was brought up today was the access issue with fire apparatus. And most of the Banks Trail is built to withstand the weight of actual fire apparatus. I can only think of 2 bridges that actually you could not cross. One of them happens to be an abandoned trestle. However, there is a trail that actually goes around the trestle, so it doesn't have to be used by fire apparatus. Another thing that is always an issue is dogs off leash. I know many people that are responsible owners, they will keep their dogs on leash, but typically, as soon as they hit the trail, the leashes come off, and unfortunately, dogs that haven't been around horses, they tend to create issues. And it's fairly common that horse users are injured just as often as bike riders. And a lot of it has to do with compatibility with either people on the trail or dogs off leash.
Capacity for, we just heard Ms. Kellington's testimony citing the numbers of deputies that would be available to police this, and she said the number was 2. I don't have any reason to question that. In terms of your capacity in responding to various things, whether it was, I know you weren't policing, but just response in terms of public safety, 2 deputies available in the area to respond, not just to the trail, but just to the whole general area, would that be a significant number of deputies?
No. We were fortunate. The 9 car out of county sheriffs basically covered everything on the west side of the county. So we had 1 county sheriff, and if we had an incident before midnight, we would get OSP also. So that's 2. And then getting them all together on the same page was another issue. So I guess in a nutshell, if you've got 1 car on odd hours, you were lucky.
Thank you.
Okay. Thank you very much.
I wanted to ask one question because it sounded like you're really you have appreciation of trails, but you also have this realistic, real life experience with rescue on them. In your view, for Banks Vernonia, how does that weigh out? Are you more grateful that it exists than, and this is totally subjective, but I'm asking you for a subjective, if you're willing.
I'm not sure I understand. Am I grateful for the fact that...
Are you glad that it exists? I'm just wondering,
in that scenario, since there's only about 3 miles of the trail that are actually in ag use, I would say that that was a proper use of that trail, or excuse me, that frontage, right away, whatever you want to call it. We're kind of talking apples and oranges when we're running this through the middle of an ag area. And I thought that was an interesting comment you made about the Benton County, where they were actually proposing a new trail versus using an existing right-of-way.
Right.
And as soon as you said that, I thought, well, the conflicts are still the same. Whether the trail's there or not, it's still the same impact on on an ag operation. So I was a little confused by that.
Well, the not Department of State Lands, the person who wrote the thing that's in the record in the big binder that the opposition presented, he explained that it is from his perspective as a state employee whose responsibility is to keep farming lands and farming, that it was a different to have an existing right-of-way versus to create a new right-of-way through people's land. So that was just his opinion, and that's in the record from the opposition. So,
okay.
Yeah. Thank you.
Thank you.
What do you think, Brian?
Thank you.
Okay, let's have Roxanne Cousins. Roxanne, you want to come forward, please?
Roxanne Cousins, 6325 Northwest Glencoe Road in Hillsborough. I am now a landowner here in Yamhill County, and I wish to express my opposition to the trail. My husband and I bought a piece of my father's legacy a couple years ago. We pay taxes, follow the rules, just as Dad did. Our 75 acres borders 2,300 feet of the rail line and includes a necessary crossing to Highway 47, which Dad paid the railroad to cross for many years. Obviously, it's a necessary and designated crossing. This is our only all-weather access, a must for our orchard. Another piece of property still in my family's trust includes an area which is designated for a footbridge, and that piece is on A10. Now the county wants to impose their will over these areas, but are they following the rules? This project was spearheaded and pushed without the addressing the landowners' concerns. In fact, we have been ignored. It seems this project is being fast-tracked to stay ahead of any opposition. We used to live near the Banks Vernonia Trail. Cars parked along Highway 47 next to the no parking signs. If you ride that trail, you will see dozens of trails that run off the paved designated trail onto private property or through the trees. People do not stay on the trail. They think they are in the country, so it's a free-for-all for them, their pets, and free access to your crops. Yet if they hurt themselves when they ride their horse through your orchard, or their dog eats something that makes them sick, or they get cut on a fence wire, then you will hear from them. And it doesn't matter that they were trespassing, which in your lawyer's words is illegal. I have written previously, but have not received a response. I would again like to ask, who do we call when trail users are parked in undesignated areas? Who do we call when trespassers are on our property? Who do we call to clean up garbage? Who do we call when we catch thieves helping themselves to just one bucket of nuts? And how will you process them? Who do we call when someone sets up camp on or near the trail? And finally, what about the legal fees we will incur if human and animal waste have mingled with our nuts and cause a salmonella outbreak? Where will you be? Thank you.
Thank you, Roxanne.
Thank you.
Okay, moving right along. Scott Bernard. Scott, come on forward.
Thank you.
Hi, Scott.
Commissioners. Yeah, I guess I spoke here a year or so ago. Same issues, and farming is my life. This trail is absolutely going to affect how we do business. It just absolutely will. I've got several stories how it's affected me in our areas. Even Roxanne's family, and I don't know if they started a fire years ago or it was in that brush row. burnt down that brush row, jumped the Highway 47 into a wheat field of mine. And if there was walkers on that path, they wouldn't have fared well. That's just one incident. And just a couple of years ago, on just a little bit further south from where that fire was, there was a couple of teenage girls, probably on the trail. It's kind of a trail there, and it was in June, and they were out just doing what teenage kids do. You know, they weren't malicious or anything, but they were trespassing, and they were out in the field, and the one young lady succumbed to the fescue, and her throat was constricted. She was struggling breathing. They called 911, and her dad got there, and he was livid because the farmer had poisoned his daughter and wanted to know what that farmer had sprayed. And I've been a volunteer for 35 years in Carlton, and I responded to the call. Certainly that was not the time to try to convince the father of his poisoned daughter that I was the farmer. And none of my comrades threw me under the bus. Fortunately, they got I snowed her with some Benadryl, and you know, she come around all right. Yeah, she was poisoned all right. She was yellow in pollen, tall fescue, and you know, it became all right. But it was scary for her and her parents. But you know, I was attacked basically for poisoning her. It never became apparent that I was the farmer, but I was the farmer. You know, we've had trespassing issues. You know, dogs. We swath. Horses will ride that trail. I've gone out and blue heelers typically, you know, can be notoriously grumpy. I know one time I went out to yell at these two young ladies, and their blue heeler dog attacked me. I turned it upside down as it came, and of course they called the police because I kicked their dog. But you know, just many stories of things. Another time, a young lady was riding out in the field, and I probably should have fixed tile blowout, but I had a big suck hole out there in the field, and she was running her horse across the field, and she dislocated her shoulder and broke the leg of her horse that we had to put down. And so back to, somebody mentioned something about, Mr. Cousins talked about on the Vernonia Trail, dogs and horses, holes in horses, or trespassing. You know, those are the kinds of things that absolutely the more apparent. And then with the exclusion zone, when you're spraying there and you can't see them with those the REIs, and I know going to those meetings when you go to ODA or the worker protection stuff, it's scary. I'm not very versed in all of the rules, but I've sat in on a couple of them now for my license hours, and it's just like, holy crap. I don't know how we're going to deal with it in the future. You know, maybe, you know, and I am totally a farm guy. I think that the county and the state is, you know, a lot of people, you know, with the laws of being able to divide these farms up, it does take our ability to sell these properties for more money, but I wouldn't trade it for anything. I wouldn't trade it for anything for all the money. It allows these farms to stay whole, and what the county appears to maybe be trying to do here isn't making us whole. And like what Ben was talking, and he's so well-spoken that it saddens me that you know, we might lose what we've had for generations. So that's all I got. Just seriously, you know, keep in heart what we're trying to do here. Thank you.
Thank you, Scott.
Thank you,
Scott, I have a tile blowout too that I hope nobody ever falls in. So I have a tile blowout that I hope nobody ever falls into.
Thank you.
Okay, Alice Partridge. Alice.
Hello, my name's Alice Partridge, and I live at 687 North Coolidge Street in Carlton. I'm a fairly new resident to Yamhill County. I moved here in February of 2016. Had I known what was behind my house, I would have not bought that property in the first place. This whole process has been extremely enlightening for me. I've always believed that if people stood up and told the truth and had a legitimate complaint, that right would prevail and things would not come crashing down around them. I witnessed that in Deschutes County when DEQ came in and started trying to regulate septic tanks in the area. Long story short, after a 2-year battle with a lot of people coming forth and giving very compelling testimony, DEQ backed off and just grandfathered in the existing units instead of mandating $30,000 plus filtration systems that were not effective at any rate. We're facing a similar situation here where the good of the public, quote unquote, is being weighed against the good of the locals and the landowners and the farmers here. Your group is entrusted with decisions that affect all of us. What I have witnessed over the last year and a half is an extremely biased opinion and an agenda afoot. If you don't want the trail, you're treated like a NIMBY. But I would say, you know, if you actually lived on the trail and your house was within feet of the trail, would you really want to invite the general public 24/7 into that area? You have my letter on record, and I'm not a farmer, but I am a landowner adjacent to it, and it backs up to over 100 feet on the trail. The trail is also a good 5 feet higher than my backyard, which means my 6-foot-high board fence will not be effective at all in maintaining my privacy and my security. There has been arguments that, oh, the trail is going to increase property values. Well, I have personal experience of looking for an affordable place for over 2 years in multiple counties around the area in the Willamette Valley and Tualatin Valley area. Anything that was on a public access of any kind, be it freeway, be it busy street, be it a trail or anything, those houses in reality, where you might say, oh, it's a wonderful thing, it's going to attract people, people are going to want it. In reality, those properties were less valuable and, for us at the time, more affordable. Those were the only ones that were within our budget because it does not enhance. It detracts from the property value. I can't possibly compare with Ben's eloquent statements. He is wonderful with giving you visual imagery, and for males especially, that hits home. And I am asking you, as a landowner that is opposed to this trail for multiple reasons, that you would realize that everything that is dangled out in front of us is not desirable. And the carrot of the funding to do something good, yes, absolutely, is being dangled, but it has the restrictions of the rail right-of-ways. Ideally, that funding should be broadened and opened up so that each individual county and people in those counties can fit something into the plan that will benefit everybody. But as you can see here today, there's a lot of people that it not only isn't good for, it is absolutely detrimental. And I'm asking you guys to really take your position as a public elected servant to protect us. Our government was formed to protect the little people of this country against big government. And our government was formed to protect against big business. Government is becoming big business and just usurping land rights left and right. And if you look around and you drive around, you realize our farming land is disappearing left and right to build new houses. We need housing, yes, but they're mass producing. We have not learned from history. The Chicago fire happened and was so devastating because houses were so close together. They started changing the zoning laws and making the houses farther apart for safety. What are we back to? We're crowding in again. And in the process, we're taking more and more agricultural land away. What is wrong with a rural environment and keeping it a rural environment and not urbanizing everything and making it convenient for those that don't understand what we're doing in a smaller area? Everybody should be able to be happy with these things. I would love to see the roadways expanded, culverts put in, and an actual trails. You mentioned how that it was touted that this was a wonderful connection between Carlton and Yamhill. Well, I drive school bus out of Yamhill, and that trail would dump those young people over a mile away from the school onto 240, which has no shoulders. You can't walk on it safely, and that's 40 miles an hour, right butting up against the 25, and before that is 55. That you can't imagine the close calls like the Fruit Hill gentleman talked about. There has been so many close calls there, and it is not feasible to bring people a mile out from the town that they're supposedly going in. You're going to have to make another whole constructions and everything is going to have to go on. This has not been thought out in detail and well planned. It just hasn't. It's not a wise choice of funding. The one person that couldn't be here today is a friend of mine, Lynn Weiser, and she lives on Gun Club Road. And she has a perspective that just boggles your mind. She's got a 30-year history with seeing what has been going on the Gun Club Road area. She has been bullied, and she has been lied to. People that have been pro-trail, not necessarily directly connected with the county, but have come and said, well, don't you know your neighbor's donating land for the trailhead? And when they were surprised, and when they actually got a chance to talk to that neighbor, he says, so I hear you're donating land for a parking lot. And this neighbor goes, I am? I mean, the mentality behind having to bring up things that aren't even true to get your way, that's not a credible stand to take. I mean, it just smacks of having to manufacture things to push an agenda that maybe shouldn't be happening in the first place. And I think credibility and integrity on an individual basis is extremely important, especially when we're talking about public servant people that are doing their job to protect the overall benefit of the county. We have a wonderful rural county here. Let's try and keep it that way and absolutely figure out a way to put in some kind of recreational thing that's safe. My son is a police officer in Central Oregon. The town there had a established bike trail, and there's so many proponents for trails, and like they're all wonderful, and there's nothing that goes wrong. But you've got spring water, and you've got what's gone on in Salem, and this trail in Central Oregon had been there for quite a few years. Well, they didn't allow for lighting and surveillance and maintenance and all that kind of thing. My son had to go to the state to ask for extra funding to take care of that, because that wonderful bike path had turned into a harbor for those that had done something nefarious at one end of it and could hustle down the whole length of there, get clear to the other end of the town before a police officer could get by street down to where they are, and they disappear. Well, now it's costing that town more money than the town coffers have. And that's, lack of planning. The other thing, they're talking about the off-leash dogs and stuff like that. Let's not forget that parvo is transmitted just by stepping in contamination, and it can stay on a ground for years. It literally has to be bleached out of the ground. We're talking ramifications far beyond anything that has even been brought up here. This is a big thing. And we've got to follow rules because we have to maintain longevity in this. The infrastructure is not in place. The Yamhill police chief, I talked to him about this and asked him what he thought about it. He says, I'm just terrified that this is going to go through. He says, because not so much the fire trucks themselves, but emergency response equipment is going to have a hard time reaching these people. He says, I'm going to have to cover an area that's just impossible to cover in addition to what we have to do in our local area. The fire chiefs are realizing the full ramifications of these things, and we have to listen to them, or we're going to be, sticking our head in the sand and just ignoring everything that's going around, and there's going to be a hurricane going on. And I'm just asking you, please, don't discount those that are coming before you today, because we're taxpayers too. We're your constituents. We may have voted for you. So just do the overall inside, look at your heart and realize, are you willing to, okay, how about this? Would you be willing to pay the price these farmers are saying that they're going to have to do if you were in their place? And truly represent everybody, not just the dollars that the tourists may or may not bring in. And frankly, I wouldn't want a bunch of drunk people that are doing wine tours and then getting on bikes. I wouldn't want them, literally 35, 40 feet from my backyard, hooting and hollering or doing whatever they're going to do. And my privacy and my peace of mind is just absolutely disturbed. I don't want to have to move. I actually like it down here. It is a nice area. Let's be a little bit more wiser with what we do with funds. And just because it's free and being dangled out there and matching funds doesn't mean it's a good choice. Thank you.
Thank you.
Thank you, Mrs. Patridge. Okay, Brian Schmidt. Brian, come on up.
Good afternoon, Chairman, and Board. My name is Brian Schmidt. Yes, and the whole Board, Commissioner Kula and the staff. Thank you. My name is Brian Schmidt, 7580 Northeast Hendricks Road, Carlton, Oregon. I've testified many times and also found that several times my material did not get into the record. And thank you to Mr. Olson. At one of those Tuesday meetings, you said, well, why don't you have our legal counsel just meet with you afterwards and put it in the record. Great. So I did. I sat down with them, and their demeanor was totally changed in a little intimidation situation. And I've shared with you a couple years prior another meeting where I was in a meeting with Mr. Fried over here, and Mr. Bonish and Mr. Sadlow and the prior administrator, and we were told that this property, that it's not really going to be a bicycle path, that there's no farm study because it's just going to be for a light rail, future light rail lands just being preserved, and that's what this was really all about. And we said, well, wait a minute, that's, we might like that news, but wait a minute, if we do that, then so what, you're just lying to Ken Wright and all that? And then it got a little ugly, and so I just kind of want to add on to other people's concerns that there's been a big lack of transparency and people's records not getting put in proper and sticking. So I don't know what that's about, but I'd like to just add to the record, Mr. Commissioner Kula, that in Benton County that was a railroad right-of-way. I don't know if it was abandoned long ago, but what happened was some of the people started doing what Mr. Bonish suggested that we start doing at that meeting that I told you about. He said, this property, until it's a light rail, you can just grow grass seed on it or graze cattle. And I read the material, and that's what the organic farmer, I think, was the only one who was using all of the property, including the right-of-way that path would have gone through. Okay, so I would like to request that the record please be left open for, I'd say, at least 2 weeks also. So those spray rules, they're all new. I just want everyone to know that. We haven't had to deal with these before. Okay. So I farm 2 little pieces of property. I lease both of them. The first one is hazelnuts. I do use 2 RUP sprays. I can think of sprays as crutches, but if I have a broken leg, I'm going to use a crutch, and that's the end of it. And if somebody can figure out a better way, I'm all for it. If organic's the way, then let's see it happen. But it's not that way today, with hazelnuts at least. The guys I see doing organic hazelnuts, they all die over and over. But the point is I use 2 RUP sprays, and I have to have an ODA license for that. And every 3 months, I get a paper from the ODA, and it's got all the people who get cited in there. And those are big fines, like $1,000 fines. That's a big deal to me. Okay, so this recreational areas and schools, that's language is in one of my sprays. And this AEZ, from what I hear, it would 150 feet, that's 8 rows. I have 16-foot rows. Most people have 20. Okay. You all know what EFB is. It started on the East Coast. It killed off the trees. They didn't have this new technology called pesticides. Fortunately, we do, and we can protect ourselves from our orchards dying. Some people, they go through a divorce or whatever happens, and they just don't spray their orchard for 2 years. Well, guess what? It looks great. Nobody knows. But 3 years later, the trees croak, and your harvest drops, and your trees pretty much are dead. So, also, hazelnuts, filberts, they get a little filbert worm in them. It's a little maggot that grows inside. And if you spray it before it's a nut, after it's pollinizing, then that takes care of that maggot. You notice organic food always grows maggots if you keep it for too long in your house. Well, hazelnuts grow them while they're on the trees. The little maggot grows in the nut. I want to talk about the my second leased property where I have some dairy cows and beef cattle. I'm trying to do grass-fed cattle. We'll see how that turns out. But I do graze on both sides of the tracks and what was the tracks. And I got one of my cows, actually both of them, from a dairyman up in Washington. And last fall, about October, his neighbor's dog, which the neighbor's been there a long time, decided to cross the fence, the farm fence. Mr. Sadler, you want to put a farm fence along the railroad. He crossed the farm fence, and he started biting at the cow's teats. And cows have 4 teats, and he just started chewing on them. And then he got her on the ground, and then he chewed her ears off and chewed her nose off. She didn't get shot till 6 hours later. She laid there for 6 hours suffering. Okay? It's a nice, real nice, bloody picture. Okay. So I'm thinking, I talked to the sheriff's department about the Banks Vernonia Trail, and I also visited it, and I also talked to dairymen who used to dairy up there, Mr. Evers, who since, I think he's moved away from there. And I understand there was a bull that got out, and there's a lot of dogs. People go up there, and they lose their dogs, and they can't find them, and they call 911, and they think they're going to get help finding their dog. Well, that's a concern for me. Have you been reading in the paper that homeless camp east of Carlton? It's a saga of stories. I don't think I'll talk anything about that. We have a homeless problem, and if you have a barn, that's a big deal. Okay, let's see. So for me, this would be a security cost for equipment. I sell milk. I put it in jars, and my customers come. They usually pick 1 day a week, and they come every week on that day, and they get their jars of milk, and they leave. Okay, if I have people around there, that changes everything. So what does that mean? And if my cows cross the path, both sides, how are we going to do that? We're going to have a tunnel. We're going to push button gates. The cow can push with his nose. You know, it causes a problem. Okay, so let's see. Yeah, the fence thing, it doesn't make sense to me how that would work. I want to tell one little story about this Food Safety Modernization Act. We're just now seeing that implemented. My friend's uncle grew lettuce last year, and he got a claim of some kind of bacteria. So the FDA comes to his farm and tells him he has to empty out his cooler. So they put him on video of him hauling it to the dump. He can't compost it. He can't give it to somebody's pigs. He has to haul it to the dump, and they're going to stand there until he does it. They test the lettuce. It comes in negative. whatever this bacteria is, it comes from people's stools, okay? So he had 20 employees. They tested all of their stools. Couldn't find it. Oops, sorry. Okay, yeah, you know what I mean? This FSMA stuff is new, and if you're growing a crop that's vulnerable to that, I don't grow lettuce, that's going to be a big deal. Thank you for your time and the opportunity to.
Any questions, Casey?
Yes.
No questions?
But we'll-
Okay, great. Commissioner?
Thank you, Brian.
Thanks a lot, Brian.
And we did get your testimony, because it wasn't that giant thing. Yeah.
Okay, Piper Sweeney. Piper, come on forward.
Good afternoon. For the record, my name is Piper Sweeney. I live at 7175 Southeast Wallace Road in Dayton. So we do not have property near the trail, and I'm here because we've had experience with potentially a natural gas line going through our property. And other farmers stepped up and stood up for us. And I think that is, that's the reason that I'm here. My father-in-law, Sam, we farmed together in Dayton, sent this letter, and I'm going to read it. I think he says it very well. Dear Commissioners, the proposed trail's purpose is to be used by anyone who wants to use it as a recreational hiking and biking trail. The trail goes through some of the most productive farmland in Yamhill County, farmed and cared for by this area's farmers. The question for you is, will these users significantly impact the farms and increase their costs that abut the trail? It has been my experience in a similar situation that it will. One of our farm fields west of Dayton abuts Ferry Street and is several thousand feet long. Ferry Street is also used by people to walk and ride their bicycles alongside it. As farmers, we try to be good neighbors. We take precautions so that any of our farm operations will not negatively impact anyone using the road or living in the houses on the other side. In planning any needed operations in this field, we have to take into consideration when people might be using this road and schedule our operation when people may not be present. These field operations include applications of lime, crop protection products, tillage, or any harvest operations that create dust. Our timing of any operation depends on the people and when they use the road. As a result, our time of operations is dependent and subservient to theirs. One house we notify, and that ends up being me notifying her, anytime we apply any crop production products. Now, this might be one that has absolute no harmful effects, but she needs to know so that she's not worried about it. Otherwise, she sees what goes on out there and then she's worried. She'll make that call or she'll come down and talk to Sam. And so there was another farmer that testified today that he always lets his, and he's actually a proponent of the trail, but he lets his neighbor know what he's doing. And he does that because when people understand better, then they're more able to feel safe in that situation. So in this case, there would be no time for these surrounding farmers. There's no way for you to notify everybody that's going to use the trail so that they can understand what's going on and that it is not a harmful situation that they're in. And it brings those it puts those farmers in a place of having to defend themselves. And anyway, I'll finish his letter. Since this field has these limitations, we do not plant crops that require extra field operations that can impact the people who use the road or any neighbors on the other side of the road 30 to 100 feet away. Yes, this field and its close proximity to Ferry Street does require extra attention, extra time, extra effort to farm, and it significantly affects our farm operation and increases our costs. So we know this on a right-of-way, that we're on that street, we knew that, and so that's something we have to incur. In this case, the applicant is asking for a conditional use permit that is going to then put these same restrictions on these neighboring farmers. And so I just think it's based on the significant increase in time, effort, and money to the agriculture operations. We have to say no to this application. Thank you very much for your time.
Thank you, Piper.
Thank you, Piper. Thanks to the letter from Swan.
Okay, Kelsey Freeze. Kelsey? Is she the one that had to leave, or no, here she comes. Here she comes.
Kelsey Freeze, 17630 Southeast Webfoot Road, Dayton, Oregon. I just want to come before you today and say that I am standing with the farmers in the Carlton and Yamhill area in opposition of the trail as currently proposed. I also have been out in the waiting room with my son all day and just overhearing a couple of things as a citizen of the county that kind of caught my ear, I guess. One, someone brought up the issue of kids getting to school and that would give access to kids getting to school more easily. And I went to Carlton Elementary, I went to Yamhill Carlton High School. We have systems in place to get kids to school. I rode the bus all along Highway 47. We picked up town kids at the grade school and transported them to the high school. So I don't really see that as an issue of great importance or need for our communities. Another thing that I just kind of heard is the money that's already been spent on the trail. As a citizen of the county, not in the Yamhill Carlton area, that does make me concerned that we're already spending money on this project without the zoning. I'm also a little bit concerned about how many citizens will actually be accessing this trail as opposed to people outside the county, and it's kind of being sold as something for the county, and it feels more like another tourist attraction. And you know, growing up as we've transitioned kind of into the wine industry and a lot of new and different, I don't even have the words right now, just a change from when I grew up to now. I appreciate the wine industry. I'm members at several wine clubs, but I can't kind of disconnect that this seems like another thing to bring tourists to the community for those purposes. And then, yeah, just the money that's already been spent, and that it doesn't, I really would appreciate if you would take the concerns of the farmers to heart, because this is their life, and they're a big part of the community in that area of the county, so.
Okay, thank you, Kelsey.
Thank you.
Thank you, Kelsey.
Okay, Christy Klofel. Is Christy here? Come on forward, Christy, and have a seat.
Hi, I'm Christy Clubville. I live at 8733 Northeast Gun Club Road. My concerns are for the residents of Gun Club Road, the traffic that it'll create by having this added trail as a proposed trailhead. It comes together with Old McMinnville Highway, Highway 47, and Gun Club. On the online site for the trail, proposed trail, it says it'll easily be accessed from 99W. That means it'll have to come off of Mineral Springs Road, Hahn Creek Road, or down 47. Those are all either inadequate for any more traffic, or they're already congested with traffic. A lot of farm equipment goes down Gun Club Road. Sometimes it's like a train of, if you go down through there, we live on Gun Club. So between May and October, it's not unusual to see 10, 12 combines or swathers coming down through there on a regular basis, all together. And if we add more traffic through bicyclists, hikers, and all those kinds of things. It's just going to cause more congestion, and I fear what that will do for our community down through that road. We also farm. We don't farm right next to the proposed trail, but again, we are totally against this trail. We don't think it's going to be good for our farming community. We think it's going to be a detriment cost-wise and just our way of life. Thank you.
Okay, thank you, Christy.
Thank you.
Okay, Janet Foltz.
I think it's good afternoon now. I'm Janet Foltz with Oregonians for Food and Shelter. Address is 1320 Capitol Street Northeast, Salem, Oregon, 97301. Oregonians for Food and Shelter are a coalition of farmers, foresters, and other technology users focused on natural resource issues involving the safe and responsible use of pesticides, fertilizer, and biotechnology. I'm a policy associate with OFS, but previously, full disclosure here, I worked as a manager in the pesticides division of the Oregon Department of Agriculture for 21 years, and then the director of environmental and biosecurity programs for the Texas Department of Agriculture. I've been closely involved with pesticide issues at the state and federal level for over 30 years. So I can very much support the fact that pesticide regulation has gotten crazy. That's not in here. OFS supports the Yamhill County agricultural operations that may be negatively impacted by the proposed recreational trail. OFS is concerned about the short and long-term impacts related to the use of this trail by the public and the potential infringement on the ability of adjacent farmers to continue to farm in a responsible and economical manner using the pesticide, fertilizer, and biotech tools that are legally available for them to use. One concern that's been expressed here involves the AEZ, the requirement of the Worker Protection Standard. The WPS is a federal regulation that adds significant amount of requirements to ag employers while applying pesticides on agricultural establishments. Several of the requirements of the WPS have been made more stringent by Oregon OSHA. One of these elements is the AEZ, or the Application Exclusion Zone. For clarity, the AEZ is an area surrounding pesticide equipment, application equipment that workers and other people are not allowed to enter. Oregon OSHA addresses the AEZ on ag establishments directly related to workers, and that's where the 150-foot AEZ comes into play. ODA addresses the AEZ on and off an agricultural establishment for everybody else, and that's where it's limited to 100 feet. So there's two standards, one for agricultural workers and one for everybody else. It's very confusing, but it's another one of those convoluted things that our growers have to try and figure out before they get out there and get in a situation where they get caught with this. The AEZ requirements apply when an application is being conducted and may extend beyond property lines. Depending on the pesticide applied and the application method, it may be between 25 and 100 feet, according to federal law, which is adopted by state law under ODA. So they take care of the 25 to 100 foot, and then OSHA takes care of the ag workers at 150 feet. Only in Oregon has this been done. So every other state, it follows federal law. If the sphere surrounding a pesticide application extends off a grower's establishment and a person enters this sphere, the application must stop until the person has moved out of the AEZ or until the applicator can ensure that the application will not contact the person. This is a must, it's not a should, even though ODA's Q&A says should. The AEZ is not a buffer, nor is it an area where pesticide drift is allowed. The concern for Yamhill County growers who farm adjacent to this proposed trail is that when a pesticide application is made, it will be a challenge to know when the trail will be in use, be able to see a person approaching, and comply with a requirement to stop the application and assess the situation before continuing. This could impair the consistency of an application, causing crop damage and loss, lengthen the amount of time it takes to make an application due to starting and stopping, subject the grower to potential complaints, and much more. Most of the general public are not knowledgeable of the numerous measures regulating pesticide applications, especially those made on agricultural land. If someone unfamiliar with these processes see a pesticide application made by ground, or especially if it's made by an airplane or helicopter, they could perceive that they are being exposed to the pesticide. It is also a concern that trail users will wander off the trail themselves or allow their pets to roam in fields which have been recently treated or have a rodenticide or a slug bait applied to them. If either the person or pet is harmed by entering a treated field, will growers suffer legal challenges? Will the grower be held responsible for someone's exposure if they trespass? Legal pesticide applications can have serious outcomes when uninformed persons enter treated areas. Growers are left vulnerable to the unpredictable actions of the general public. Since many pesticide products also have an odor to them intended to increase handler awareness and safety, if a bystander smells a chemical odor, they may mistakenly perceive as if they've been exposed to the chemical. This is not usually the situation, but it becomes subjective, what puts the grower in a defensive situation when it may not be warranted. It is often that pesticide odors are erroneously reported to ODA as a pesticide exposure. If there's a complaint made to ODA of alleged drift or perceived exposure to a person, animal, or the environment, they have primacy in investigating the incident. If ODA determines that the complaint is to be investigated, an ODA investigator will then contact all the parties involved, take statements, gather records, take photos, examine application equipment, review product labels, take samples of vegetation or any other items, and gather information that may be helpful in determining if there was a violation of law. This is a huge amount of time and money spent by the agency, the grower, the applicator, and others, but rarely the complainant. This investigative process may take many months, and if it results in enforcement action, even a minor infraction, months to years are tied up in administrative processes and/or legal proceedings. Even if the allegations are unfounded, the complainant pays nothing and thus has nothing to lose. Although any investigation is very costly, it can be especially damaging to the persons unjustly subject to the complaint. ODA's investigations of ag and forestry complaint-driven pesticide investigations have found that growers and foresters have been in 85 to 95% compliance rate for complaint-driven cases over the last 8 years. That's a total of about 675 different investigations that were conducted. Violations have been determined in only 5 to 15% of the cases, and it could have been for any violation from something as serious as exposure or drift to minor administrative violations like record keeping. These data clearly show that most Oregon growers are making pesticide applications in a legal and safe manner, but have had to endure lengthy investigations into their routine activities to defend themselves until proven innocent. Allowing the general public uncontrolled access to trails adjacent to farmland and/or timberland will undoubtedly result in a spike of complaints being filed with ODA regarding any pesticide application that may be made while the trail is being used, regardless if there is a violation or not. In fact, applications of lime, which is dusty, fertilizer that may be visible on the ground in pellets, or other standard farm practices, dust, noise, odor, etc., could become problematic with trail users and culminate in complaints. Once people start using the trail, they will have a voice for what can happen around the trail, and farming will most likely lose. As presented above, there are many challenges and concerns that arise when the public has access to areas adjacent to farmland, especially when the trail will be on land that has been managed as part of a farm. The actual boundaries of a farm become vague, and the ability of farmers to manage noxious or undesirable weeds adjacent to their crops, or weeds or pests on their own cropland, is impaired or is only accomplished with anxiety that somebody will file a costly and unjustified complaint. Conducting standard farm practices should not have to put a farmer on the defensive, which appears to be inevitable when incompatible activities such as the proposed trail and farming occupy the same space. Oregon growers are being subject to more and more urban encroachment, which ultimately modifies or adversely impacts the ability to use the tools necessary to be economically successful in agriculture. Impeding farming practices in a predominantly rural area such as Yamhill County harms the viability of farmers, their livelihood, and their economic significance to the county and to the state. It must be remembered that agriculture and forest products are Yamhill County's primary industries, and they must be protected. OFS stands behind our farm and timber owners to support coexistence with other interests, but not to the detriment of agriculture. Thank you.
Okay, thank you. Commissioner Starrett, any questions?
No, thank you very much.
Any questions, Commissioner Kula?
No, thank you.
Thank you very much. Okay, that will move on to Tom Hammer. Tom, come on forward.
Tom Hammer, 23701 Wallace Road, near Wheatland, Oregon. This exercise with LUBA has been most useful in exposing the years of ongoing illegal advice given by county council to people working at various levels of county government and to our elected officials. LUBA made it clear that the county could not legally consider the trail in a legislative proceeding to cut off farmers' rights. LUBA made it clear that the farmers all along had many rights that the county council had improperly told county to deny them. Contrary to county council's claims, LUBA made clear that before the trail can ever be approved, you must find all farm impact standards are met and all conditional use permit standards are met. And also, contrary to county council's advice, if the trail is not allowed in a zone, it cannot be approved in that zone. I think you had a question along those lines. LUBA's order, in no uncertain terms, sent the entire trail matter back for a do-over. Yet here we are with county council telling you, 1, the county needs to do nothing new. 2, that no conditional use permit application needs to be filed. 3, no new evidence is needed on farm impacts. And 4, the county council can just reapprove the trail even in areas where it is prohibited by county code. Worst of all, the county council is giving you bad legal advice and has put up roadblocks in front of the farmer's ability to provide you with information important to your consideration of this matter. Partisan wishes have superseded the rule of law for too long. I hope you read Luba's order for yourself and see the fallacy of the advice you are being given. Until now, most had no clear way of knowing County Council's advice was bad. The recent remand by Luba brings a clear counter to his actions and from the proper authority. So far as I can tell, his reaction has been to defy Luba and go on as though their decision doesn't mean a thing. I hope you on the Board of Commissioners realize how that crosses us into new and dangerous territory. This individual seems unwilling to acknowledge mistakes and appears to just follow one mistake with another. With that approach, he will take you down with him if you let him. That happened to our most recently departed board members. They approved a lot of spending on this trail before they had any way to know if it could legally be approved, as did some before them. With good legal advice now available, Luba endorsed, commissioners can and must act on the rule of law and not to partisan wishes. County Council expects you to protect the now illegal spending that was initiated before your tenure by acquiescing to his defiance of the Luba decision. He expects you to keep authorizing public money spending on the trail when it's very clear now that can't be legally approved. In fact, County Council is trying to get you to approve funding on the design and construction of the most expensive parts of the trail even today, hoping to commit you to the trail when it's a lose-lose proposition for you and the county. All the while, at least as far as I know, County Council has never advised you of your liability or the county's legal peril for spending public money on an illegal project. County Council is playing a $1 million game of chicken with the board members and expects you to blink. A farm impact study will likely find the trail creates significant adverse impacts on farms and causes significant new operating costs on farming and simply can't be built. When that happens, at best, grant monies would need to be returned. When it comes to damage control, your first loss is your least loss. However, once the commissioners start acknowledging serious mistakes have been made and refuse to cover those old mistakes with new layers of mistakes, you can be on the road to recovery. You need an evaluation of your legal department. You need to be sure you're getting fair and good sound legal advice on everything from land use law to proper spending of public money. Thank you for your attention.
Thank you very much, Tom. Casey, questions?
Thank you, Mr. Hammer.
No, I think I've heard a lot from Tom. So.
Okay. Thank you, Tom.
Thank you.
Okay, Richard Clofield. So Richard, come on forward.
Richard Clofield, 8733 Northeast Gun Club Road, Carlton, Oregon. A lot of the issues have already been brought up that that I'd like to raise, but one thing for sure, this is zoned agriculture. We're on track there. I'm not against the trail, but as it's going to be a big problem for ag. We farm several hundred acres close by. We're not on the railroad grade. One thing I want to touch base back up is that hasn't been brought up is we've had, I think, 6 cases with our farm. I try to be as careful as possible. We're a small operation with just 4 people running it. People can call ODA anonymously, and it's happened to us. We've never been fined yet, but it takes up a lot of your time. They don't know what they're calling about. They've smelt something, or I've had ODA call me and want to check my records from somebody that thought they smelled chemicals a mile away from our existing field. And this is going to really be a problem with the trail And earlier, a fellow brought up the fact that he can work with these neighbors. The neighbors are pretty easy to work with because you know them and they know you. It's really going to be difficult. I don't know how fellows are going to deal with people walking by that are maybe from Multnomah County or somewhere, and they're just not in touch with this, and all they have to do is make a phone call and they can tie you up for days and investigations, and then it was already touched upon. I thought it was 85%, but let's say on the average, what I've just heard, it's about 90% of the time or more, these are bogus calls, but they take up your time and money and the state's time and money. And somehow this needs to be addressed, because it's going to cause a problem, and we're being told, oh no, it won't be a problem, but it is a problem. And it is zoned agriculture, and we'd really like you to consider backing up a little bit and seeing what you can do to abide by the rules the way they're supposed to be. Thanks for your time.
Thank you. Thank you, Richard.
Thank you, Richard.
Matt Chesley? Oh, okay. Now we got in there twice. Billie Jean Matthews. Billie Jean, come on forward.
My name is Billie Jean Matthews. I live at 19643 Northwest Goodrich Road. You've got my written testimony. And I think much of what I wanted to say has been covered, but I would like to emphasize one thing. I think the trail has been misrepresented from the start. Okay? If you look at the trail concept map and their statement that the proposed trail runs along Highway 47, one could be led to believe that the trail is adjacent to the highway. In fact, less than a mile of the 2.8 mile stretch between Carlton and Yamhill is adjacent to the highway, about 30% of it. So 70% runs through properties, mostly farms. If you go north of Yamhill, or look at the whole 12.8 miles, let's do that. 2.8 miles, or 22%, lies along the highway. The rest of it runs through farms, residences, and in some instances, as you can see from the map of property 2434300, it runs feet from a unique structure for hay storage. It's not a pole barn. We store equipment down there. I've got sheep down there. The property across the road also belongs to Gordon and his brother Paul, and there's a pole building there. It has some equipment and hay in it. That one building on the north side of Cove Orchard holds about 3,000 bales of hay. And it's feet, literally feet from the trail. What happens if somebody decides to take a break from the rain and light up? That building is not going to be replaced. It's stacked 2x4s. 40% of it has concrete floors, and 40% of it is stacked 2x4 walls used for grain storage. It's not a pole barn. Okay. Going on. Trail advocates assure us it will not create problems for the farmers. So I think you've seen today that it does create problems for farmers. They also assure us it's going to be safe for users. How can they assure farmers and citizens and users of the trail that this is going to be safe? It's not just Springwater Trail that's got problems. The Fano Creek Trail runs through a recreational area next to a residential area. It's supposed to be one of the best trails, one of the safest trails. They had a daylight rape last year and 2 coyote attacks on kids. When you put a trail away from where it can be seen, you're asking for trouble. One of the reasons this has happened is because everyone has not been involved. In fact, when specific suggestions have been made about alternative routes or meeting with farmers and residents, we have been ignored totally. And I know that's not what the intention was, because in 409, it says, communicate with and meet with adjacent owners, operators, and residents seeking to participate in the development and implementation of a final or master plan. And a lot of us really appreciated that being added, but it hasn't happened. Go back even farther. This is supposed to be a rail-to-trail project. And the Rail-to-Trail Conservancy, which represents rail-to-trail projects all over the country, said this: farmland and ranches are sensitive in terms of vegetation, privacy, and the division of public and private property. Open communication with surrounding property owners is vital. Listen, be honest, and take into account how the trail will affect their livelihood and land. Make sure to coordinate construction times, et cetera, don't disturb the animals. Whenever possible, use public land and do not fragment farms. Build trails away from barns, crops, or anything else that can be looted or vandalized. And this is from the National Rail-to-Trail Organization. Been ignored by the local people. You guys have really been misled. You've really been led down the garden path. Yes, that's what I had to say, and I hope it goes in a better direction from now on. It's unfortunate that it had to go all the way to Luba to get somebody's attention.
Okay, thank you, Billie Jean.
I have a question for Billie Jean.
Sure.
If you don't mind. You've often mentioned that you want to see alternative routes or
Yes.
routes that are. Can you provide us with suggestions now? Are you willing to do that?
I would
What would you
rather have Gordon, my husband, involved in it, because he's the one that came up with some of this,
Okay.
and it's a significant portion.
Yeah.
I don't know that it helps the situation between Carlton and Yamhill, but certainly moving north it probably does. It's not without problems, okay? Because you have residences along the highways, et cetera, and access. But I've also done some looking at the GIS system and spotted things like platted roads that could solve part of the problem. They've never been raised or suggested, and I'm floored that somebody who really wants this trail hasn't done some homework, and they've just tried to cram it down everybody's throat. It's not right. And please don't let it happen again, because they're trying to set this as a precedence for doing what they want, regardless of what the county or state rules are, and it's not right.
Thank you.
Okay, thank you, Billie Jean. Okay, Chris Madsen. Chris?
Chris Matson, Yamhill, Oregon. I guess one thing, we're supposed to talk about a change in significant cost of our farms. My insurance is probably going to double perpetually, you know, as long as if this thing's gets going. And I've actually spent more money than I'll probably ever make back on the land that I have so far, trying to protect my rights. I got a question on the bridges. I think we don't know what the bridge is. I think you kind of said that about for fire trucks. How could it be put out to bid to engineers if nobody knows what the specs are? How is that possible?
I think I'll just answer that, Chris, is the part of that contract calls for the design too and the engineering. So once the design and engineering is done, and if there's any permitting, then it could go out to bid for construction. But of course, It can't, you're right, it can't go out for bid for construction until all the design and engineering is done.
So you're just asking engineers to design something?
Actually, it calls for the design and engineering of 3 bridges, and the construction of the Stag Hollow Bridge, which could not begin until after the design and engineering for the Stag Hollow Bridge be completed.
Mr. Chair, I could even clarify further. It doesn't actually call for the construction of the bridge, but it would be a contract that would allow for the contractor to provide the construction management. There would be a separate process later that this contractor would oversee that would actually let the actual contract for construction itself.
Thanks for the clarification, Christian.
So somebody has to have some specs for them to design something, or are they free to design something and then you guys approve it? There's got to be
Well,
some specs.
I don't know much
Yeah,
about
that's what I'm
contract,
trying to
but that's
remember.
what,
This guy probably
yeah.
knows, but you're right.
I
that
think
we
you're
need
right.
to
They'll
give them an
design.
RFP, right?
Yeah, they'll design, we'll work with them, and then, of course, whatever the final design looks like would be subject to the approval of the board.
But Chris, I'm sorry, is it okay if I address you? I'm pretty sure that I never saw anything in the early stage stuff about, I'm distracted by Brian's hand, so, about specs for the request for proposals. So I get what you're saying, but I don't have an answer for you, alas.
Right, it just seems odd to ask for a request to build something and we don't seem to know any specs.
Yeah.
Brian, I'm not going to recognize you right now, so.
There must be some idea what the bridges need to be.
Well, again, I'll just weigh in as well. As far as the bridge, the grant calls for and the contract with OBEC is to design bridges for set standards that are national standards on engineering for the bridges. And we know the, potential location within the corridor, but we haven't, you're right, there's not a design because that's what the contract with OBEC is supposed to do, is to design those bridges. And then once those bridges are designed, then it would move to the next phase, like Christian was saying, which is managing a contract to construct the project, to actually take them through the permitting process and then get them ready for construction and then supervise the construction.
So you said there's some national specs they have to follow. What are those?
Well, I don't have that right off the top of my head.
We can get you a copy of the RFP if you'd like.
Yeah.
Well, I'm just curious because it's been brought up to sign this and we.
Yeah, it's all in the RFP, so if you'd like.
Okay, so we know the specs, we just don't know them today.
I'm sorry?
So we know the specs of the bridge, we just don't know what they are today?
So the RFP contains the specifications to which the bridges are supposed to be designed. We know that today.
Okay.
I just can't remember.
But I say they are in the RFP, and we can get you a copy of the RFP.
And then it sounds like the fencing is kind of the fix-all for the trail to keep everybody in, dogs in and out. We don't know the fence, what it is, but how are you going to address driveways, road crossings? It's optional if you want fence. How's that going to work as far as if your neighbor doesn't want it? How do you keep stuff from encroaching on your land? Are you going to go down somebody's property way, 100 yards, 200 yards?
I think those are all valid questions, Chris, and those are the kind of questions that I insisted several months ago that be included in a master plan to answer those kind of questions. Because to tell you the truth, I don't think we know, other than fencing is required and gates is required, we don't know what the answers to those questions are now.
At what point will we know, how much money do we have to spend? How far do we have to go before we can figure that out?
As soon as the master plan would be done, then we'd know all that information.
When will the master plan be done?
It hasn't been scheduled yet.
So we're gonna build the trail without a master plan? We're
No.
gonna start spending money?
We will not start construction of the trail until a master plan is done. Other than the 3 bridges that we had designed in the construction of 1 bridge. So.
And then I think one other thing that was brought up, it sounded like early on for the farm impact study, it sounded like it was on more of a farm-to-farm type basis than just a conglomerate. I myself have never met with anybody from the county that have asked about my concerns. I don't know, is anybody else here met with the county?
Chris, you need to keep your comments to us and not to the audience,
I
please.
apologize. So I guess I have not.
I tried.
What's up?
That I tried
With?
Brian. But I figured since you were asking, I should answer that.
Oh, so there's one. So duly noted one. I think that's all I have right now. So.
Okay, thank you, Chris.
Thanks, Chris.
Thanks, Chris.
Okay, Daniel Kearns.
Chairman Rules, I work with Wendy Killington. I was hoping to do a wrap-up when all the opponents are done. Can I do that? Do you have any left?
Actually, with a request, rebuttal by the applicant, he'll have a chance to do that after him.
He'll be last.
Okay. So I got some other, because if you want, I got a whole bunch of others here to go.
Plow through those, and I'll come at the end of the opponents if that's okay as a wrap-up.
It's okay with me. Is that correct, Christian? Is that the way? Sure. Okay, let's go to Greg McGrady. Yeah, if it was Van Dyke, I could have read it really easy.
Greg McCarthy, 24550 Northwest Russell Creek Road. You guys got a tough job because I've never seen so many farmers in one place for this long. So this must be a real problem. And I wouldn't trade you guys your seat for anything. And I don't like being here. But we have two pieces of property. One of them is north of Gaston, and we would have to cross that trail in order to do our farming operation. And the other one is just north of Carlton. And we just purchased that a couple years ago, and we're dealing with a new set of problems for us because we're not used to being around the city limits. So we got people riding their four-wheelers through our field. We got dogs out there. We got people hitting golf balls out there. We've got all kinds of situations, dumping garbage. So I'm just trying to figure out what this is going to be like when you increase the amount of people coming onto our property zone. I think we got a huge issue here, and I've submitted a letter, which should be on file. And I think Kula answered, he answered me back, thank you. You got my email.
Yes.
And I said, I think if anybody that would farm next to this trail would be on this letter with me trying to fight it. And you said, honestly, I think I'd like to have the trail through my farm.
That was my honest answer.
And I think we need to help you do that. You know, I think we ought to all get together and.
My wife is so excited right now. I hope that my wife is listening because she'll be so excited.
I think she's going to be really excited.
But that's me and not you, and your situation is different than mine, and I acknowledge that.
I understand you must love trails. So anyway, I'm not going to go over a whole bunch that's been said. I think the legal team and this group of farmers presented you with a stack of documents that'll choke a horse. I question whether you'll go through and read them, because if you're like I am, you're going to start flipping, and something may catch your eye. You may read that one. You may read 10%, 20%. I hope you read it all, because these people are busy. We farm. It's what we do. It's how we make our living, and we don't want to be here. And I think Ben Van Dyke had a great speech, and you know what? He don't want to sit here. He wants to sit in that tractor.
Yeah.
Yeah, so thank you.
Well, I kind of feel sorry for you in a way, Greg, because based on where your property is, you may have to turn around and go up and do this for 5 Washington County commissioners too, so.
Well, we can always sell it, because I think Kula wants to buy something.
Thank you, Greg. Celine
We
McCarthy.
haven't talked about, yeah. And again, thank you for all of your patience. I really appreciate it.
Celine McCarthy, 24, I don't know, it's P.O. Box 417 Gaston, but I live in Yamhill. Normally, I can talk the hair off of a dog, and I think Jim Van Dyke is going to be happy to say that I'm not going to do that because I am tired, I'm starving, I really need something to drink. And I commend you guys for being here all day long. I mean, it's like I'm sure your ears are bleeding as my head is full too. I submitted a letter. I guess I'm just going to touch a little bit on the zoning part of it, you know, and it had to do with exclusive farm use. We're hooked up to, we have 2 parcels of property, and, you know, actually, I'm a physical therapist, so I like the trail ID and the biking and all that kind of stuff, but not through exclusive farm use, which is what this is. So what the zoning says, in exclusive farm use districts, non-farm residential and other development which might likely be affected by normal farm management practices will be limited or prohibited as to maximize the productivity potential of vicinity farm grounds. Well, I can read that again. It's like, other development would be likely affected, will be limited or prohibited as to maximize the product. But it seems like it's going the other way around. We're the ones that have to be limited, and this is our zoning. And this is what makes our state of Oregon really special from anywhere else, because we do have really strict zoning. So we just feel like, you know, we're kind of farming by, or playing by the rules, and all of a sudden this trail comes through and now there's different rules. So you can see by everybody here, they're all testifying that, yeah, it really does affect the farm use. If you look on that picture and you see all those yellow swipes, I bet you if you study the other trails, like the Banks Vernonia one, it's not going through exclusive farm ground. That's what makes that trail so work. And that's what's not gonna make this work. And I know you guys are yawning. I don't mean to be boring.
Oh, no, you're not boring. You're not boring at all.
Greg was awesome, so you're following up on a great.
Well, hey, how do you follow up to an act like that? I mean, you know, he's Irish, he's funny. Anyway, I guess all I'm gonna say now is I wanna keep, because I'm too tired to think, really. I wanna ask to keep the record open for at least another 2 weeks.
Okay, thank you, Celine.
Excuse me, I just want to say the reason I was nodding was because when you were talking about the difference between the Banks Vernonia Trail and that, is that you wouldn't see that. That's why I was nodding, not to hurry up and finish.
Oh, yeah,
Yes,
I know, I'm looking at that.
I agree with what you were saying about the trail.
But yeah, I mean, if you guys really study what works well on the existing trails we have and what doesn't, and, you know, I mean, we are the community here. It's like if there's a big problem of getting our kids to the swimming pool, I mean, I don't think we have a big problem with getting our kids to the swimming pool. If you're looking at the goal of being economic development, well, farming, we are the economic development. And as far as tourism goes, hey, I don't know if you guys know it or not, but the word is out. I mean, you know, everybody comes to wine country for tourism. So I don't think we need a lot of help from this trail. Isn't going to make or break that part. And maybe there's some other places we can put a trail. I don't know. Do we have abandoned railroad tracks going towards the Flying M or the Coast Range? And a cyclist, really, he's going to ride that first 3 miles, and you're not going to ride 3 miles. I mean, maybe when the whole trail's developed, but, you know, it's not going to be big for the bikes, so it's just a pain for the farmers. All right, I'm done.
Thank you, Celine.
Thank you, Celine.
Roy Bowerman? Come on up, Roy.
Roy Bowerman, 7465 Northeast Gun Club. I'm the corner lot. I am the person that all of the accidents happens on his property. I've been there 14 years. I have seen on the average of 4 major accidents per year. The last one, which you can go out and look at right now, there is a telephone box on the east side of your wonderful trail. There is a tree on my side of the wonderful trail, and there is tire tracks between the two. They ran over the telephone box, across the trail. That is the entrance to your trail. How many people are going to die because you're putting a trail, and who is responsible? Am I going to be responsible, or are you going to be responsible for maintaining the safety of the public that you're here to protect? That's all I got to say.
Thank you.
Okay, thank you, Roy. Mark Gubier? However you pronounce it, Mark, I'm sorry for butchering it.
What's that?
However I pronounce your last name, I'm sorry for butchering it if I...
Gabler.
Gabler, okay. Yeah, I butchered it, but...
So I just, Mark Gabler, 7575 Hendricks Road. I just, pretty much everything I had has already been covered. There's a couple things with the values of properties. We farm one chunk of ground along the railroad that it splits it in two. If we have to do the 150-foot setback on that 72-acre farm, it amounts to about 13 acres that the people want us to, they want us to plant the whole farm to hazelnuts. We'll have to see if we do those 13 acres. If you do simple math, if the ground's worth $8,000 an acre, costs $4,000 an acre to develop it, when the trees are 4 to 5 years old, there have been sales, if the family wished to do that at some future time, of $20,000 to $25,000 an acre. That would be a decrease to that family of $8,000 to $11,000 an acre in value because of the trail, and that is just on one piece of ownership. I went on Google Earth. There is what I would consider 78 acres of prime hazelnut ground from Shraples to Gun Club Road. So I'm sure you guys can do the math on that. When it comes to the ODA application complaints, we farm in 4 different counties. We had 3 complaints last year against our farm. We were doing nothing wrong. But when you have a complaint filed, they have to do an investigation. They have to come out, take your time. You have to show them records. You have to defend yourself. And there is no repercussions to the people that file the complaints. That system is broken, and the ODA hired 12 more investigators for the upcoming seasons. Todd Sadlow touched on spraying the right-of-way is technically illegal because the farmers don't own it. When we took over the piece of ground that we farm, the blackberries were 25 feet away from the existing right-of-way that had encroached into the field. We have since beat them back by spraying, taking a cap, pushing them back, whatever. There's not a farmer in this room that doesn't do ditch maintenance for the Yamhill County already, be it spraying, cleaning ditches, putting in new road culverts, whatever. So I guess if Todd says this is illegal, then you guys probably need to increase the budget for the road department so that they can all start maintaining all the other stuff in the county that we as farmers are already doing for you for free. Larry Vanell, a friend of mine south of Corvallis, kept getting complaints all the time about spraying and dust from his ag operations. He planted solid rows of cedar trees to mitigate his problem. It's the property south of Corvallis where there's miles of cedar trees planted right along 99. So with that came the next problem. People backed into his entrances to his fields, they dumped their garbage. Now he gets the job of, or his employees get the job of cleaning up the garbage from other people. KCU asked a question early on of other rails that people farm along, or if people would be okay with the rail being existent if there was trains on there. In Polk County, we farm along 2 miles of railway. It's awesome. We don't have any problems with them. The railroad keeps the right-of-way sprayed. The only problem we ever have is if we need to get an easement to put an irrigation line underneath the railroad, because it takes a long time. Another issue I have is who's going to maintain this trail. I've been at a meeting before where Ken Wright says that he's going to take care of the maintenance on this trail. The last time I checked, nobody lives forever. So who's going to take care of it when Ken's not here anymore? Mary, you asked Brian Cousins about the deputies in Washington County on the trail up there. In our county, on New Year's night, when the homeless guys burnt down the house at 73501, there was 2 deputies on duty in Yamhill County, Sam Elliott and one other guy. So I don't know who's going to respond to all this stuff. The other issue is that I have, probably the last one, is the trails driving a wedge in the 2 local communities. So there needs to be a resolution. I don't, I'm not in favor of it, but it is socially driving a wedge between people that are for it and people that are against it. Thanks.
Thank you.
Thank you, Mark.
Mark, can I ask you a couple
yeah.
things? Okay, thank you. Again, if that's okay.
Yeah, no, it's fine.
Okay, sweet. I think you're right on with the wedge thing. But I wanted to check, so I wrote down 25,000 per acre per year. Is that what you're getting for hazelnuts, or is that what you're saying that the ground is worth once the hazelnuts are producing? I just want to get.
No, once they're up and producing, if that family so choose to sell the property, there are recorded sales in this valley of actually over $30,000 an acre for established hazelnut orchards.
Okay, because I was like, are you making that? I've needed to
No.
change my crops.
I wish.
And I wanted to clarify too that I'm the liaison to Public Works, and I'm also a farmer, and I see what you guys do for the roads. So I'm very aware of that. And I'm also very aware of the work you've been doing on Hendricks Road, so.
Yeah, it's been a project.
Yeah.
Thank you.
Thanks.
Okay, thanks,
Yep.
Mark. Okay, Samantha Bear.
Good afternoon, this loud, commissioners. My name is Samantha Bear, Associate Policy Counsel with the Oregon Farm Bureau, here today representing the Oregon Farm Bureau and the Yamhill County Farm Bureau. I'm going to be really brief in my verbal testimony. We have submitted a packet of written testimony to you guys that I ask you to please refer to, because it's going to go into a lot more detail than I think I will today. And in that packet, I have actually provided you a copy of the Stop the Dump Coalition versus Yamhill County Supreme Court case that was referenced earlier. And if you turn to page 458, that's the citation for you. The court actually gives a great summary of the farm impacts test I'm going to read very briefly. So the farm impacts test in ORS 215-296-1 requires an applicant to prove that the proposed non-farm use 1 will not force a significant change in the accepted farm practice, and 2 will not significantly increase the cost of that practice. Further down, for each relevant accepted farm practice, if the applicant cannot prove both of those elements without conditions of approval, the local government must consider whether, with conditions of approval, the applicant will meet the farm impacts test. I am here to urge you today to deny this application. as the trail will cause significant changes to accepted farm practices and increase the cost of those practices, and the conditions proposed by the county simply do not ameliorate those impacts. A view of a trail running directly through and adjacent to a working farm and its fields and pastures, you are undoubtedly going to have trespass impacts, safety concerns, and increased liability of landowners, which has all been highlighted in previous testimony today. This will have an effect on the farm and the farming practices. It is common sense. The county has proposed some fencing or signage as a means to address these impacts along the entire trail. However, the county has not given concrete details on how the fences will be constructed, what they will look like, what they will be made out of, or how their construction will even be funded. Who will have the burden of placing these fences along the trail? And frankly, unless the county is planning on constructing a 10-foot tall chain link security fence along the entire trail, which, as an aside, would likely ruin the aesthetic value of the project in general, we have serious doubts that the proposed fencing and signage conditions will truly prevent people and their animals from entering these farms. We have farmers in the Willamette Valley that have no trespassing signs posted all over their property. However, they still have random people, tourists who are unfamiliar with farm operations, entering their fields and taking pictures of their crops and blooming trees for their Instagram accounts, or trying to pick produce without authorization. Someone earlier today said that this would be a mere inconvenience, something that's just kind of annoying. But having unsupervised people out in productive field can cause serious issues for a farmer in terms of food safety plans, specialized crop certification, as well as increased personal liability if someone is injured on their property. We also have sheep farmers along the path who are highly concerned about the health and safety of their lambs, who may experience extreme stress due to people trying to take their picture with them, pet them, or chase them, or even if people have dogs that may try to bark at them or chase them. Again, these are not mere inconveniences. These are very serious and real impacts to farmland. You have a room full of farmers that have sat before you today and have told you very honestly that these are real impacts that will significantly change their operations and increase the cost of their operations. I ask you to believe them and to deny this application. Thank you.
Thank you.
Thank you very much. Before I call Daniel up, I want to read into the record that we do have some written testimony only that was submitted by, in opposition by Zach Summers, Nate Craig, Trask Ward, Jim Hurl, get this one separated, Gary Miller, Alan Sitton, Jeff Cruikshank, Jeff Ediger, Jeff Van Dyke, Casey Asham, Harold Cooney, and Danielle Kearns. So those will be read into the record for their written testimony we received today. So that being said, I think we'll go ahead and turn it over to you, Daniel.
Thank you. Thank you very much. My name is Daniel Cairns. I'm an attorney. I work with Wendy Killington. My address is 621 Southwest Morrison Street in Portland. And you've heard a lot of testimony today about the real and significant impacts that these farmers are going to experience. It's pretty compelling testimony. It's pretty factual. But what you don't have the question before you, whether you like a trail, whether a trail of this sort would be good for the county in a lot of different ways. You heard a good deal of proponent testimony about this. What's before you is a conditional use permit application to approve this. And I don't know that you expected to be in this position a few months or a few years ago when you started the legislative sort of planning process. And I heard plenty of discussion among you, commission members, about master planning and addressing these details, and even from your attorney representing the applicant's side of the county, that these issues can be dealt with and will be dealt with through this planning process. That's exactly why the cart is before the horse in this case. The trails that you heard testimony about in Ohio, the Banks Vernonia Trail, the Salmonberry Trail, these trails took years and years and years to plan. All these details that are big question marks before you today, that are significant impacts, clear testimony of the significance of these impacts, were dealt with through these planning process, the planning process that I think you, Chair Olson, envision will happen here. You can't approve this trail without doing that first. And so, for example, all the crossing details, bridges, the design details of those, where they'll be located, there shouldn't be a question about where the parking lots will be, where the trailheads will be. You should know the trip generation that's likely to happen for each of these points of access. And I also serve as city attorney for Banks and have been in that position for less than 10 years, so I wasn't here when that trail was put in place or planned. We don't hear of any problems or conflicts with farmers. And if you've been on that trail, and I assume that you have, it doesn't go through actively, intensively farmed territory. You don't have these conflicts there. And so it's a very different situation. Those issues were dealt with, planned out years ago. You need to do that if you want to have a trail of this sort in your county. Maybe it could happen in this location. I severely doubt it, because I don't think that the Banks of Vernonia Trail had ag operations like this when it was being proposed and planned. It certainly doesn't today. It's mostly forested. And so those sorts of details should not be questions. Those are big questions that are unresolved. And because they're unresolved, the Supreme Court has said you can't approve this. This can't pass the farm impacts test in ORS 215-296. And I think, Wendy made several points about the legal sideboards that are before you. The conditions that have been suggested for this, they don't solve these problems. They're, in the future, this is how we may plan for the solution of these conflicts. You have to do that first. That has to happen beforehand. A couple technical points that I'd like to address too. So the simple statement that these farmers, they can't operate or spray or overspray on this land because they don't own it. Well, that's a very significant legal and factual dispute in this case. You acquired title to this railroad right-of-way through a quitclaim deed. I'm very sure that none of you own your homes with a quitclaim deed. A quitclaim deed means that the seller gives to you whatever title they happen to own, whatever title they happen to hold at that time. And Alan Brickley, who has 2 letters in the record, who was the chief attorney for Standard Title Company when I started as a lawyer 30 years ago, he knows how to read these deeds, and he's of the opinion that all the railroad obtained when they got this was an easement for railroad purposes, a non-exclusive easement. So it means the railroad would share the use of that property with the underlying property owner. Well, the heirs and descendants and successors of the underlying property owners are here before you today. And the way the Oregon law works is when the use is abandoned, it lapses and the easement either expires and reverts back to the underlying property owner, or perhaps the easement can be conveyed. But at most, you obtained an easement interest, a non-exclusive easement interest. And so that's why there's a significant legal question as to whether you own anything here. But certainly, the people who own the abutting properties have title to do something just by the deeds themselves, but also through prescriptive use, they do. And Oregon statutes recognize prescriptive use. And so I would say it's not resolved. I wouldn't say that these people don't own this land and that they can't do these things on this property. I would say there's a very good likelihood they can. So the conditions that have been proposed to you to solve these problems are not legally valid. They certainly, maybe some of them may pan out, but you need to do that beforehand. The planning process for these trails takes years and years and years. And maybe you have followed the Salmonberry Trail. That'll parallel the Banks of Vernonia for several miles up past Manning and then divert over to the Port of Tillamook. 80 miles. It'll be decades in planning that thing. It's a very, very big undertaking, and I think you're just getting a sampling of it today. But the bottom line is this permit, and quite frankly, I'm not really sure why there's a permit proposal before you, because I've never seen, in all my years of practice, a developer that could propose a project like this without ever having to file a permit application. You have requirements in your code about what makes an application complete, what documents are needed. I would say that all the details, the questions you've heard today, are elements, are pieces of information that should be in a properly assembled permit application. The county never filed an application for this. So anyhow, that's what's before you, to approve an application that isn't before you, and that would green light this project, and subsequent master planning may or may not happen. But Oregon law, thankfully, protects farmland. It requires the horse to come before the cart. You have to do this planning before you can approve this permit.
Any questions for Daniel, Casey?
I'm going to hold on.
Thank you.
Thank you.
I did have one other response to the indemnification issue.
Oh, yes, please.
First of all, it gets to an issue, there's already an impact. If you're talking indemnification, there's already an impact, and so you can't pass the farm impacts test. But when my city clients are asked this sort of question, the first thing I do is I call my insurance carrier. And no municipal or governmental insurance carrier in the state will cover contract liability like that. So you would be on your own, and it would be a non-covered claim. You couldn't get insurance coverage for indemnifying what might happen on this trail. So you couldn't do it unless you're willing to take the risk of someone being damaged. And you've heard the huge uncertainty of those kinds of claims and the potential damage that could occur if someone is actually exposed to pesticides. Those are very expensive claims. So you can see why your carrier would not touch this with a 10-foot pole.
Okay, thank you.
Thank you.
Anything for you, Commissioner Starrett?
Very interesting. Thank you.
Anything for you?
No,
Thank you very much, Daniel. All right, Commissioners, that will take us now on to public agency reports. Staff? Okay, no additional agency public reports. We have a request to keep the record open, so Ken, you want to go through that?
Yes, we've got a request to leave the record open, and so I'm going to suggest a motion that you could make. This has...
Commissioner Chair. Ken.
After rebuttal.
Oh, excuse me, Todd, come forward. Well, you were writing so busy, I didn't know if you wanted to be, didn't know if you wanted to be disturbed or not. You're writing so many copious notes. Ken, hold off on that. Okay, Mr. Sadlow, you're up.
Back here, filed an application. It's over.
You want to put the microphone a little bit closer to your...
Todd Sadlow again, presenting this application on behalf of Yamhill County. We filed an application on April 3rd of last year. And as I said in my introductory remarks, this is a remand of the decision that you made on that application. That application didn't go away. So what I filed was what we usually do, is we accept from the applicant on remand, and I've been through numerous remand hearings, this is nothing unusual, a letter saying, please give me my remand hearing, and I also submitted a copy of the decision. But all the parameters of the project are in this original application. That has not changed. We have filed an application. They know exactly what it is that we're asking to do. We did not change what we were asking to do. LUBA did say, please do this, or please. They told us that if we're going to do it, we must do it in a quasi-judicial proceeding. We did it legislatively because 2 letters from DLCD generally said the better way to do it is through a legislative proceeding to amend your comprehensive plan. They didn't do that with regard to our individual code, and I missed that. I've spent over 30 years advising clients not to trust the planners at DLCD who are giving it legal advice and are not lawyers, and I broke that rule this time, and my apologies to you that we're in this remand. I would say, though, about the title that is being litigated, and Mr. Brickley had a copy, apparently, of the deeds that I provided to Jim Van Dyke, and I believe that those were just exhibits to a very lengthy motion for summary judgment. And amazingly, he failed to mention any of the cases that are mentioned in that motion for summary judgment, or to provide any kind of legal analysis that has anything to do with the specific deed in that case or specific deeds that he reviewed. I would say that if you buy property and it says that you own it, accepting therefrom, and then it describes the Southern Pacific Railroad corridor, that you should not expect to exert ownership over that corridor. And that's the case with every deed we've seen with regard to this segment of the corridor. And that gets to my second major point here, which is if we are talking about this conditional use permit and these farm standards and the conditional use standards, we should stick to that. But instead, we've heard extensive testimony that has nothing to do with the less than 3 mile corridor that we're talking about. This has nothing to do with Gun Club Road. It has nothing to do with any farms that are south of Carlton, Yamhill and Carlton. What we wanted was to pick a piece of this trail that would maybe be the most necessary and the most appreciated to the 2 communities that it would serve the most, and get that done so that people could see that the kinds of horror stories that are being portrayed to you today are not only not likely, but that the trail is actually a public good and a benefit for everybody, and that it will be a asset to the community. And that's what we did. We picked this piece of trail. We're not trying to hide anything, and I'm going to get back to some ex parte up the wazoo kind of things here. Staff being accused of malfeasance, and all I can say is that with regard to the incident that you're talking about, the one letter that did not have to do with the trail that was presented by Ms. Kellington was delivered to you right then, right that day, right at that hearing. I thought it was the other letter that she had sent, and at first I was objecting to it because the other letter was specific to the trail proposal. It was specific to the remand. It was talking about the remand, and I thought that should be delivered to you as part of. She should not be able to present things outside of the hearing process when everybody else doesn't know about it, nobody else knows about it, and nobody else gets to rebut it or to talk about it or address it. And so the other letter came to you in the packet with everybody else's materials. I don't know of any materials that have not come to you at all. We either have told people that you can talk about things that are not this application, or you can submit things in the hearing process. And I think you have seen now that people know how to do that. As for the materials that were delivered yesterday, we told everybody, we underlined it in bold in the notice of the public hearing that your interested parties should deliver their comments, they're invited to send written comments to the planning department. So I think we're trying here to make sure everybody knows how to reach you and the proper way to do it. With regard to the use of the corridor, Ms. Kellington made a lot of remarks about how she thinks that the landowners are getting prescriptive rights somehow against the county, or that they were able to get them against the railroad. There is a statute that specifically says that you cannot adversely possess against a railroad, an Oregon statute. I don't have the citation with me, but I believe that I cited it in my motion for summary judgment. There is also a statute that says that you cannot adversely possess against a county. So those two things are settled, and I don't believe anybody ever tries to do that because the statutes are so clear. In terms of whether the spray rule is less restrictive than EPA, the commentary that I provided to you, the 97 pages, says that EPA has less restrictive requirements for protecting people on your own property, but that the EPA rule actually did extend off of the property. The Oregon OSHA rule clearly does not apply off of the property. And by saying that you should do something, Oregon Department of Agriculture is acknowledging that, yes, you should do things. And I think Mr. Wick testified that these things are an inconvenience, that you should do these things, but they're not a significant farm cost to do things that you should do, that it's the responsibility of the sprayer to do this, and it always has been. And that's whether it's a trail or whether it's a public right-of-way, whether it's Highway 99 or Highway 18 or a gravel public county road. And I would also say that under the commentary of that rule, it was pointed out to me that the 150-foot is the maximum spray application for things like filberts, where you're blasting it up into the trees. It has to do with the machine spray pressure mist size, and that the grass seed buffer is smaller because it is closer to the ground that they're spraying. So all these maps with 150 feet, again, in my introductory comments, I think that I've made clear that this is just not reality. This is a map, and I hope that we're going to continue to deal with reality and not maps. And again, that map also dealt with a number of properties that were south of Carlton. It's the same thing really can be said for the Schrapels. And I appreciate their position, and I appreciate, again, I think we all appreciate that Fruit Hill is here. But the Schrapel property is not on the corridor that we're considering, and his facility is not on farmland. The standards here don't apply to it, and the area, he's not within the area that we're considering here. I should also point out that when we purchased the property, we specifically got the easement from Union Pacific Railroad, 30-foot easement across the western and northern edges of the property that they sold to the Schrapels. And so that's not something that is contingent on anything. We own it now. We exercised our right to buy it within the time frame that was allowed, and we own it. I would also note, though, and there was a nice picture in the beginning of the big book that you got that shows, and I think it demonstrates a point that I'm trying to make. It shows the 150 feet. It shows this little red line for the trail, and you could see that there are cars parked in that area. And I'm thinking, you would have to, you would have to stop spraying just from having cars parked there, not from having people on the trail. So all that really is changing, if they're thinking, if they're believing this, that there's really a 150 feet exclusion zone, really all they're talking about is moving that over in that area 30 feet, not 150 feet. They lose 30 feet, if that's true, and I don't believe it is true. You might also see in that commentary from Oregon OSHA the techniques that you can do. You turn off one side of the sprayer when you're getting close to the line. There are ways to do this that do not call for abandoning farm uses on 150 feet on each side of, in this case, a trail, but in other cases on either side of a county road that might only have a 40-foot right-of-way, which a lot of them do. I'm trying to make the point that now the county is a property owner. The county owns this property. It has a responsibility to it. Even when the railroad owned it, they had the right to stop people from spraying them. And whether or not they were diligent in doing that or not, that's a different story. I think that they've probably been less than diligent. They have sent people out to survey and look at the environmental conditions, and we've got reports on that. But it was pretty seldom that they did that. But now we're trying to do the same thing to secure that corridor. And honestly, I don't want to get sprayed if I'm out there looking at the corridor and trying to figure out what is going on in different segments of it. Again, we had a lot of questions like from Mr. Mattson. Mr. Mattson is far north of this project and of this piece that we are trying to get approvals for, and is not affected by it in any way. I think what they're thinking is that if we get this little piece, that then it will be easier for us to get the rest. And I think so too, because I think it helps to prove that a lot of what they're saying is overblown or just fear, just plain fear of people, fear of people from urban areas for some reason, as if they're somehow different. And maybe they are, and maybe they don't have the same sensibility as the people that live out there. And I understand the sociology of that, but this part of the trail is between two rural towns, and not necessarily in this proceeding, but we've heard for a couple of years now in hearings that we've held from those people saying, this would be great for me. So I don't want to overlook what the farmers are saying, and we're trying not to overlook what they're saying, but I'm asking you to look at what everybody's saying while you're considering these standards that you must address as part of this proceeding. Because some of the conditional use standards, other than the farm standards, do address that. In terms of fire, we did hear a lot of testimony about fire before the adoption of Ordinance 904. We had the sheriff testify in the prior proceeding that he did not have a problem responding to trail incidences, and he currently has equipment to get into the segment we're talking about. So there's that. Again, we heard a lot of testimony that has to do with vandalism and feces in the fields and camping and all these things, some of which are happening in urban areas, are less likely to happen in Yamhill County. And also, well, you know, there are no services out there. I'm not sure why how a homeless person could live out in a 3-mile corridor between Yamhill and Carlton. So I think some of that is just plain fear-mongering. But excuse me, but regardless of that, we already offered a condition for fencing. Farmers use fencing. They rely on it to keep people out of their fields. They rely on it to prevent trespassing. We're only trying to do the same thing, and we're only making the same claims about that fencing that fences are useful for them and likely to be useful in this circumstance to prevent those particular impacts. Ms. Patridge was talking, I think she was talking about in the city of Carlton. We don't have anything to do with that. But I just want to say that we're not usurping anyone or trying to usurp anyone. We specifically purchased an existing corridor. We're not attempting to go on anybody else's property. The reason it's zoned EFU is because of an interpretive rule in the zoning ordinance that says that that land is EFU land, even though it's not configured for farming. Part of it is not suitable for farming because it has ballast on it. And it would be hard to turn it back into farming without breaking up the tax lot that it consists of that has currently a highest and best use of being a transportation corridor, which it was for over 100 years. Again, that deals with the dogs, that deals with people coming onto your property and parvo, and I don't know. I mean, a lot of this stuff, it's no different from a road. A road is currently a trail. You can walk on it. You can walk your dog on it. You can stand and look at somebody who's spraying pesticides, although I don't know why you would want to do that. And the idea that more people will be there, I think that we're hoping that more people will be there. We're hoping that it will get some use. But you're not going to get, as I've heard it called, the spandex crowd coming out to Yamhill County to ride their bikes on less than 3 miles of public trail. That's not what that's all about. I mean, I'm old and I can run that in less than a half an hour. It's for transportation in this case and for exercise, not a tourist attraction. I think the whole thing might be, and again, we're talking about planning and planning, long-range planning for these things. We're doing that. We've gotten a grant for master planning for the whole trail, and we are proceeding with that. But we also got a grant for bridges, and we're trying to keep the momentum going if that's at all possible. We're not trying to cram anything down anybody's throats. We're going through the process here. We've got a remand. We're trying to work through the issues on the remand. And this, before the end of the last hearing, and I don't have much more, but before the end of the last hearing, we heard from we said basically we want to accommodate you in crossing the right-of-way, and we're willing to provide gates. We're willing to provide a legal basis for you to be there, an easement, a crossing easement, or a license of some kind. And we also have, in the original plans, showed the kinds of gates we might be able to use. But then we heard, well, I have to open and close the gate. It's going to cost me thousands of dollars a year to open and close the gate. And again, this gets back to the spray issue. Using somebody else's property without their permission, I'm not going to call it trespass because I've said that word enough. One more time just now. Using another person's property without their permission is not something you should expect to do, and using it as part of your farm operation is not an accepted farm practice. It's not. It doesn't mean we don't want to accommodate everybody, but it doesn't come into the equation that's before you. We're only talking about significant impacts to accepted farm practices. Overspray, crossing the corridor without permission, those are not accepted farm practices. We kind of heard some people say, you can't possibly make these findings, but I can't believe that the legislature intended for the farm impact standard to prohibit a transportation project in an existing transportation corridor, especially not a trail, which LCDC has already stated complies with Goal 3. So my interpretation of the rule, and I think the interpretation we've all had forever, is that you address the individual impacts to the farms, you address the cumulative impacts of significant impacts that you find or of insignificant impacts that you think might become significant impacts, and I will do that in the findings. And you adopt conditions to minimize the impacts that you recognize. Now, some of these impacts I think are easier to minimize than others, like the trespass issues, I think can be minimized with a fence. Others, like lawsuits that might be brought against somebody, are much harder to do. And Commissioner Kula has talked about indemnities or insurance or that sort of thing. My problem with that is I just don't know where that ends. This right-of-way is no different from the, I don't know how many there are, but there must be hundreds of miles of public roads and county roads in this county, and spraying is taking place next to most of those, and trespass is happening there, and farmers there have to get their own fences. We're proposing to provide one. But the same kinds of impacts occur because that road is there, and farmers and farm operators have, for 100 years, dealt with that issue, and we have all come to live together. I understand too how this has become a wedge, and it saddens me that that's the case. I wish there was another way that we could do it, but the Friends of the Yamhill Trail put together groups at the very beginning of this to try to get people drawn in and to show them how this might work, and very few farmers participated in that. Now we're here, we are trying to address it. I think we still can address the issues that they've raised. I think we can find a way to provide emergency services. In the case of the segment that we're talking about, it's got Friar Road in the middle of it, and as an access, and the city of Carlton on one end, and a state highway on the other end. So my feeling is that this small piece of corridor doesn't suffer from the kinds of I'm out in the wilderness security and lack of emergency vehicles that a much longer trail might suffer from. Thank you.
Thank you, Mr. Sadno. Any questions? I guess as a rebuttal, we won't be asking you questions, Todd. But
Thank you, Todd.
Okay, now let's move to open records. Ken?
Yes, the request is for 2 weeks. The first week would be for all parties to submit testimony, and the second week would be for rebuttal. And I'll read this off, and if it's acceptable, one of the board members could say so moved. The record shall be open to 5 p.m. on March 14th, 2019 for all parties to submit written testimony or evidence to the Planning Department at 525 Northeast 4th Street, McMinnville. The record shall then be open until 5 p.m. on March 21st, 2019 for all parties to submit to the Planning Department written rebuttal to what was submitted. The record shall then be open for the applicant only to submit final testimony with no new evidence until noon on Monday, March 25th, 2019, and at that point, the record shall be closed. The board shall then reopen the hearing at 10 a.m. on March 28th, 2019, in room 32 of the county courthouse at the point of staff recommendation.
Okay, just a question, Ken, you mentioned and they requested the 2 weeks, and you mentioned for hold the record open, and I'd take it that would be for written testimony. Wouldn't that take us through the 21st and not the 14th?
Well, as I understood the request from at least Mr. Schraple, it was to have it be open for him to rebut what was submitted into the record. And so you've got rebuttal all the way through to the 21st.
Okay, that makes sense to me. So commissioners, is that schedule all right with you two?
Yes, Mr. Chair, I'd make a motion to approve staff recommendation for the timing.
Okay, Casey, I mean, we don't have to, all those in favor signify by saying aye.
Aye.
Any opposed? Hearing none, then we will, I guess the next meeting we'll do the staff recommendation. And now, do we just suspend the hearing, Christian, or do we just?
Yeah, you can adjourn the hearing at this point.
Okay, at this point, I will not close the hearing. I'll just adjourn the public hearing at this time until the date specified by the planning director. Thank you, everybody, for being so attentive and showing up. I know it was a long time to ask you to sit, but I think it's a very important issue, so we appreciate everybody coming.
Formal adjournment.
What? I know what. Commissioners, I still have to formally adjourn the meeting.
Oh, God, that's
Close formal.
Yeah, I will. So
sorry.
I take it we're not, you don't have any comments tonight, do you? You don't have any comments tonight? No, he doesn't have any comments tonight.
We've closed the hearing, now we need to close.
Yeah. Commission meeting's adjourned. Got that, Carolina?
No announcement.
Oh, no.
I-
For anybody who would dare to make an announcement, you're in big trouble.
I had a list.
Oh.
No.